All right, y'all come on up, please. And Miss, up to the podium, one of you can come on up and the other one can just sit in one of those seats right there till it's your turn. So you were Miss Borden?
Yes. You're right.
Okay. And you want to, what, live stream or what do you want to do?
Yes, I wanted to do a live stream in pictures and take notes.
Okay, well, you're certainly welcome to take notes. That is not a problem at all. In terms of live streaming, we've already got a lot of different cameras going, and so you are welcome to pull from either of the streams that's already occurring. All right?
Your Honor, I would like to, if it's okay, I would like to submit some reference letters that I have from a civil rights attorney and also the news media channels that I've been working with over a decade.
You
If I
certainly
can.
may, and it absolutely has nothing to do with who you are or who you represent or what you're going to say. It's just that we've already got so many pieces of equipment in here. It just becomes a kind of a security matter and a distraction to the deputies and frankly to me to have to keep trying to keep track of that many more pieces of equipment and people handling them. Had you been the first person, I probably happily would have given you the right, but it's just, you know, we've already kind of got everything set up. There are two different streams that you can pull from. So yeah, I'm happy to take them. That's not the reason for the denial. It has nothing to do with who you are.
And can I say something, please?
Sure, absolutely.
So my concern up under the Rule 2022, and I've been doing this over a decade as a civil rights leader and also an awarded community advocate for our former mayor. So I am aware that there are other cameras, but with the case of this nature, I feel like the community deserves different angles and different perspectives. So while they do have a camera and while the camera is on, there's still different perspectives and angles. That footage goes through some other entities that I'm not a part of. So even if I was to pull or jump on their train, that is separate from me as a civil rights leader and wanting to share with the community and making sure that it is a fair trial.
Okay, so I don't know if you mean angle as in position that you would take in your reporting or angle as in camera angle.
When I say angles, meaning that, for example, there's a camera on right now.
Right.
That I'm looking at. So if I want to report something or show something and it's not from his angle, that means if I have to jump on what he's doing, I'm relying on his footage only.
So you actually literally mean camera angle.
Yes.
Okay,
Yes,
which
camera
is
angle.
either going to be
Yes.
on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know any other time I've worked with 2-5 and 1146, there's an approval process for that footage. And I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room and film from there, you may do that.
Okay.
Okay. All right. All right. Anything else?
No, Your Honor.
Okay, thank you. All right, and Ms. Hall. Good morning. How are you?
Good morning. I'm fine. Thank you for your time today.
Sure. And you want to do still photography and
Yes, ma'am.
audio?
Yes, ma'am. My situation is a little bit different, even though I do have a YouTube channel and I can pull from the pool, which I
Right.
have done.
Okay.
Because I'm a freelance blogger, I can't depend on the pool for still images. So my situation wouldn't be setting up tripods or anything of that nature. And I would ensure the integrity that I'm as according, especially from our seating that we have, that we don't compromise any integrity of jury or anything of that nature.
All right, and you'd be able to, you say still photography and audio, you'd be able to pull audio from one of the
I can
pooled
pull,
sources
yeah, I can pull
already.
audio from pool.
Okay. And what kind of equipment are you talking about?
Sony AX50, one of those type of still cameras.
Does it make any noise?
I will make sure the settings are off.
All right, you're gonna need to be wherever it is that the deputies put you,
Yes,
and
ma'am.
you're not gonna be able to move around.
Yes, ma'am.
Okay. All right, and what's the camera?
I have a Sony AX1, Canon C50. So I'll work with the settings and make sure which one will be dependable on the fact that it will make no noise.
All right, and you'll be the one operating?
Yes, ma'am.
Okay, thank you.
Thank you.
All right, Ms. Abbasi, did you just get alerted this morning that you were gonna be the one covering court?
Is it granted?
Yes.
Okay,
We'll
thank
we'll get the paperwork out to y'all probably sometime today.
Okay, thank you so much.
Okay. Well, since you didn't know until, I guess, a few minutes ago, nothing you can really do about it other than get here as soon as you could. So I appreciate you doing that. All right, does anybody have an issue with anything that occurred over the course of the evening that y'all need to bring up with me? Or is everybody fine? Yes, sir. Well, Mr. Sharp stood up first.
Your Honor, we came in today.
Hey guys, I guess we haven't not started yet. Or are we on break? What happened?
We didn't start it and stopped again.
What happened?
We had two ladies try to come in with their Rule 22s. One was a civil rights leader, air quote.
Okay.
She got dismissed real quick.
Okay. And then what else happened?
And then some lady came in. She told us she could film from the media room.
Oh, okay.
But that's about it, really. And then they went away. Got us here waiting.
Okay. All right. I mean,
Safe
did
travel.
anybody watch the debate last night? Did y'all talk about that?
We haven't really discussed that yet. But to anyone who was with us last night, thanks for the great exchange and dialogue. That was fun.
Can you replay what happened so I can watch it? Anybody just joining us?
Let's see.
Good morning, everyone. So they all switch seats.
Okay. All right, y'all come on up, please. And Miss, up to the podium. One of you can come on up and the other one can just sit in one of those.
She look a little agitated.
Miss Borden?
Yes. You're right.
Okay. And you want to, what, live stream? Or what do you want to do?
Yes, I wanted to do a live stream in pictures and take notes.
Okay, well, you're certainly welcome to take notes. That is not a problem at all. In terms of live streaming, we've already got a lot of different cameras going, and so you are welcome to pull from either of the streams that's already occurring. All right? Okay.
Your Honor, I would like to, if it's okay, I would like to submit some reference letters that I have from a civil rights attorney and also the news media channels that I've been working with over a decade.
You
If I
certainly
can.
may, and it absolutely has nothing to do with who you are or who you represent or what you're going to say. It's just that we've already got so many pieces of equipment in here. It just becomes kind of a security matter and a distraction to the deputies and frankly to me to have to trying to keep track of that many more pieces of equipment and people handling them. Had you been the first person, I probably happily would have given you the right, but it's just, we've already kind of got everything set up. There are two different streams that you can pull from. So yeah, I'm happy to take them. That's not the reason for the denial. It has nothing to do with who you are.
And can I say something, please?
Sure, absolutely.
So my concern up under the Rule 2022, and I've been doing this over a decade as a civil rights leader and also an awarded community advocate for our former mayor. So I am aware that there are other cameras, but with the case of this nature, I feel like the community deserves different angles and different perspectives. So while they do have a camera and while the camera is on, there's still different perspectives and angles. That footage goes through some other entities that I'm not a part of. So even if I was to pull or jump on their train, that is separate from me as a civil rights leader and wanting to share with the
See
community,
if they
making
started back.
sure that it is a fair trial.
Okay, so I don't know if you mean angle as in position that you would take in your reporting or angle as in camera angles.
When I say angles, meaning that, for example, there's a camera on right now
Right.
that I'm looking at.
No, they haven't.
So if
And
I
thank
want
y'all
to
for the
report
super
something or
chat
show
and the new
something
member prayer
and
changes.
it's
Thank
not
you.
from his angle, that means if I have to jump on what he's doing, I'm relying on his footage only.
So you actually literally mean camera angle.
Yes.
Okay,
Yes,
which
camera
is
angle.
either gonna be
Yes.
on the witness, the judge, the state, or one of the defendants.
Yes, but it's still the reliance of me depending on the footage. And I'm pretty sure the footage that they have, I know of any other time I've worked with 2-5 and 1146, there's an approval process for that footage. And I will also be dependent on that sometimes as well. But if I'm able to stream myself, then I have more control of that footage.
Okay, well, if you want to go back in the media room
Holly
and
D,
tell
we
them
are
from there, you can do
rewatching
that.
because they
Okay.
are on break.
Okay.
We are
All right.
rewatching.
All right. Anything else?
No, Your Honor.
Okay, thank you. All right, and Ms. Hall.
Oh, y'all. Oh,
morning.
I would
How are
tell
you?
y'all
Morning,
something
Ty.
too.
Thank
Oh
you
my
for being
God. Now
here.
I know
Sure.
exactly
And
who
you
that
want
is. Oh
to
my
do
God.
still
Okay.
photography and
Yes, ma'am.
audio.
Yes, ma'am. My situation is a little bit different, even though I do
Elle,
have
you
a
know who that
title
is.
and I
That's who
can
was
pull
sitting next to
from
me in the courtroom that
the
day.
pool,
Remember?
which I
Right.
have done.
I thought she looked
Since I'm a
familiar.
freelance
Yeah.
blogger,
Okay.
I can't depend on the pool for still images. So my
I don't know why the seat
situation wouldn't
changed.
be
Maybe
setting
we'll
up
get some
tripods
intel.
or anything of that nature. And I would ensure the integrity that I'm supporting, especially from our
Is that
seating
the
that we
other young
have,
lady that was with her that day?
that we don't compromise any
Absolutely.
integrity or anything of that nature.
I
All right,
think
and
it
you'd be
was
able
both
to,
of them.
you say still photography
Yes.
and audio, you'd be able to pull audio from one of the
I can
pooled
pull, yeah, I
sources
can pull
already.
audio from pool.
Okay. And what kind of equipment are you talking about?
Sony AX50, one of those type of still cameras.
Does it make any noise?
I will make sure the settings are off.
Okay, they back, Kayla.
All right,
All
you're
right.
gonna need to be wherever it is that the deputies put you.
Yes,
And
ma'am.
you're not gonna be able to move around.
Yes, ma'am.
Okay. All right, and
to see that 460 is up there because I took one stack, but
Okay.
460 was not.
you can check. And were the parties able to come to any agreement or partial agreement with regard to any of the exhibits that were tendered at the end of the day yesterday?
No, Your Honor,
Y'all haven't what?
we haven't discussed that, redactions. I have gone over the exhibits themselves, and I have a legal argument that I'd like to present to the court regarding 104.
Well, I'll hear it after lunch then, because I instructed you to get with the defense so that you could see whether y'all could come to any sort of an agreement. So if they haven't seen it yet, then I will give y'all the lunch break to accomplish what you were supposed to accomplish yesterday evening.
And then I inquired with the court inquired whether 460, which was a document that I believe at the end of the day, some counsel for defense was looking at. I believe that I retrieved it, but I think Mr. Sharp may have had it.
I don't know. Does anybody have 460Y? Can y'all check? sometimes it's hard to keep track of all the documents.
Now, there was several documents that someone, I think it was either myself or Mr. Adams, put into the documents, that folder for the documents.
Identified only.
Yes, identified only.
Good morning, everybody. Adrian starting off as Adrian.
Yes. All right. Do you locate it? Were you able to locate it, Ms. Love? Okay. Well, I'd imagine that would be easy enough to reproduce. It was just printouts from emails, right?
It was just, Riot's emails. And we provided a hard copy.
I mean, yeah,
And actually,
I'm sure I have a copy of it since you gave it to me, if that would help.
it would, if the court doesn't mind allowing us to copy, court's copy, I would.
Okay.
Return it back.
I don't think I've made any markings. Well, I have made a marking on it, sorry.
It would actually help us to recreate,
To just, yeah, look at it to recreate it, that's
Yeah.
fine.
thank you very much.
Nobody was able to find a 460Y anywhere? Okay. Has anybody checked up in that podium area? Okay. All right, well, it can be reproduced. It's not the end of the world if we can't find that particular one. All right, turning to the issues we need to decide. Ms. Abbasi, your co-counsel had filed a motion in limine regarding autopsy photos from the Holmes murder. Is the state ready to respond to that?
Yes, sir.
All right. And Ms. Abbasi, do you want to make any argument?
At this point, no, Judge, the motion is largely self-explanatory.
All right.
I'll let Ms. Sullivan.
Thank you, Your Honor. Good morning.
Good morning.
Your Honor, when we get to presenting this act, which is count one, Act 79, the state intentionally did not include the medical examiner. This is a case in which Mr. Ryan has been convicted of the murder of
Right.
Jamari Holmes. And so it is only the state's intention to bring in 3 photos, and I have a copy of those 3 photos that I can show Ms. Abbasi
All right.
through the
Well,
lead detective in order to minimize that level of testimony. And so we do not plan to stipulate, but we've selected only 3 photos.
Can everybody hear?
yeah.
And I can bring them up to the court. For the purpose of this hearing. Yes. And for the purpose of this hearing, Your Honor, the state's gonna label them states 1 RR, states 2 RR, and states 3 RR.
And what do y'all plan to present with regard to, I mean, just kind of a general overview, the evidence that will establish that Act 79?
Generally, Your Honor, what occurred leading up to the homicide of Mr. Holmes, which was a luring of Mr. Holmes to an apartment complex that Mr. Ryan and Mr. Blaylock then, we believe, ambushed Mr. Holmes along with two other victims. They were in a vehicle. Mr. Holmes was shot, and then they fled. And then subsequent to that, there were Instagram postings, Facebook postings, or excuse me, social media postings regarding YSL, very close in time to the murder of Mr. Holmes, Your Honor.
All right, and how many witnesses are you gonna utilize?
For that act, so, we have 5 witnesses.
Who are they? And what will they generally testify to?
You know, that 5 is a marked reduction from the original list of witnesses. We did not intend to retry that murder.
Well, that's good to hear.
Your Honor, 5, the witnesses for that act are Ms. Sharon Latners, Starry Holmes, who's the mother of Mr. Holmes, Mariah.
Be an eyewitness?
No, she is, just would be able to bring in his in-life photo.
Let's
And
figure out
talk
a different
about
way
Mr.
to do
Holmes.
that, especially given that this is not even the trial of that case.
And speak about Mr. Holmes and who he was. Okay.
I have a relevant suggestion on that.
And that would be sustained.
And to talk about his involvement, who he is as a, prior to this murder happening, he was a juvenile. I don't know if any of these other witnesses would be able to do that. Mariah Smith was someone, I believe he had just met recently, who helped set up the robbery that ultimately led to his death.
Okay, all right, have you moved on to another witness now? Is Mariah Smith another witness or?
Mariah Smith is another witness, Your Honor.
So Mariah Smith would be able to say he was a juvenile, right?
She doesn't, I don't believe she really knew Mr. Holmes.
How old was he?
substantially. He was 15 at the time of his death.
Mm-hmm.
Yes.
And Ms. Latner's backing up, she would, what, introduce a 911 call?
Yes.
And what's that gonna say?
But it was the initial reporting of the shooting. So it was at the time, the time of the shooting.
Just
framing
one
the date.
call?
Yeah, I believe just one call. Your Honor.
Judge, we would have no objection to the call.
Okay.
Admitted where, the witness says he'd like to speak with police and please don't speak. No problem with that call coming in.
Is that the call?
I don't think that that's the call. I think that the initial call about the shooting.
That may be a different call.
Yeah. that's
It's a different call.
Okay.
And
Okay, so,
the witnesses are our skeleton version of what we can present to show absent, because we cannot just put in the certified to show the facts of the case. So we're trying to put in.
well, I mean, sure, the fact of the murder wouldn't get it as an overt act that is a part of RICO. So I understand you need to do a little bit more than that.
Right. And so we're trying to, we've scaled back. We had these
Okay.
witnesses.
All right, I don't
represent
need to
one of-
hear what it was gonna be at one point in time. Maria Smith is going to say what?
She was one of the 2 young ladies who lured Mr. Holmes and his 3 friends back
Okay.
to the location, or to the location.
All right,
Then we have one of the 2 other victims. We don't plan on calling both of them.
okay,
So that it'd be either Mr. Uten or Mr. Mitchell.
all right,
Then we have the lead detective on the case, who is Detective Hogan. Then we have Mr. Mike Sprinkle, he further brought, did the
He'll-
additional evidence of some of the social
Social
media
media.
that came in later. And then last, sort of,
So 7, not 5.
so Rooney Lee is one of the co-defendants or co-conspirators in this case. He is coming in during this portion, but he was present during the initial trial of Mr. Ryan and posted some social media postings with rat emojis when Miss Mariah Smith initially testified in that trial. And so he's coming in that portion, but he's not actually a part of what will prove the actual act, but that's why he's included.
And Your Honor, we do need some clarification whether it's going to be Mr. Eaton or Mr. Mitchell. We've been in contact with the state about going through the evidence we've offered for these witnesses, what does or does not need to be redacted. Mr. Eaton's interview is maybe about.
Can y'all spell that last name?
Yes, Your Honor, it's OOTEN.
Okay.
His interview is maybe about 20 minutes, half hour with some quiet time, and Mr. Mitchell's interview is several hours long.
Okay. When are we going to get to this part of the trial?
Your Honor, we would believe that we would get to this portion of the trial probably early October,
Okay, so fairly soon.
fairly soon. Yes,
All
Your
right,
Honor.
when will y'all know who it's going to be?
We should know within the next few weeks, within 2 weeks, Your Honor.
Well, 2 weeks from now is the end of October, so. I mean, the end of September, trying to rush that along.
We do want to have an opportunity to go through the state what evidence they believe will actually be admissible. Right
Okay.
now, we've got more than 50 pages of Instagram reference from Mr. Blaylock, co-defendant not testifying, more than 200 pages from Mr. Ryan. Those are obviously issues we'd rather not sit down with the court and go page by page, but if we need to, then we will.
And Your Honor, I believe there was some preliminary conversations, and we do intend on furthering or finishing those conversations with Ms. Abbasi and Ms. D. Williams.
Okay, well, that probably needs to get done before the end of next week.
The state could respond to our email if we want.
Can y'all,
We can. We've also found it fruitful to communicate via phone, which we have done and will continue to do at times that are convenient for either Mr. Abbasi or Mr. Williams. That communication has not stopped. I think there were some issues, but we've done that as well.
all right, well, try to do it in a timely manner, please. Okay, let me see the photos. And the photos would come in through the detective. Did you get copies too, or are we just? Is this third one like post incision, or is that the exit wound?
That is the entrance wound. Your Honor.
Entrance wound?
Yes, Your Honor.
Your Honor, one of our objections is I don't know who's going to be able to answer that question. I don't believe the lead detective is qualified to explain what type of injury you're going to get. We don't believe the detective will be able to lay the foundation. Oh, I'm sorry. We don't believe the detective will be able to lay the foundation for these photos.
All right.
We believe that with some conversation, he can talk about the fact that the victim was shot in his head, that is the victim, that he was it was his homicide that he was investigating. The picture, which I believe is 2RR, with just the area in which the
Before it's shaved.
before it's shaved, I believe that he could talk about where the bullet was, or that he was shot in the head. And then the last photo, I'm not sure if he'll be able to say it's an entrance wound. We'd have some further conversations with him regarding whether or not he was present during the autopsy or not, and whether or not he
Do you think that there's any chance he was present during the autopsy?
sometimes they are. Sometimes they are. I'm not saying that he would, but sometimes they are present during the autopsy.
Was he present at the scene before the body was removed?
Yes, Your Honor, I believe so. I believe so, but I need to ask. Ms.
Okay, well, you'll,
Ms. Love.
take out another witness.
Do you know if he was present?
Your Honor, I've got, based on the police report, the officer received his phone call at 6:07 requesting assistance to the homicide. The victim had already been taken to Grady in ambulance 571. He was pronounced dead at Grady at 6:10.
Okay, so if he was at the scene, he wouldn't have seen the victim at the scene, so that wouldn't be helpful with regard to these photos.
And Your Honor, we were trying to avoid the ME, so if we can have some stipulations to that, or we can have the ME come in for
All
a
right,
innocent purpose.
why don't y'all get together? I'm gonna hand these back for now and come up, maybe you could come up with all sorts of stipulations. So we'll revisit that.
But we are just trying to reduce the need of having to call the medical examiner.
Say that again.
We are just trying to reduce the need of having to call Dr. Sullivan.
Well, there's no necessity to call him or her. Can't remember. Thought so. Okay. Yes.
On that, I'm not saying I cannot find my list. I cannot remember if the state is moving for the verdict against Mr. Ryan into evidence, but I would be objecting under 24-8-803-22. And I'm just reading from a case, a jury's verdict that the co-defendants were guilty as a hearsay statement. The exception to the hearsay rule provides for the admissibility of the final judgment of guilty as to a felony, but not including when offered by the government for purposes other than impeachment, judgment against other persons other than the accused. And then I just pulled up 24-8-803, and then it's subsection 2.2, and it specifically says the same.
What's with the state's plan with regard to that?
I just want to put you on notice so we don't go into it.
As to the conviction itself, Your Honor, I believe that it would not be improper, and I'll reread the case law on that. I don't believe that it would be improper to limit, as the court did earlier with the conviction itself of the witness. Actually, because it was not a statement that he made, actually, Your Honor, I think that it would be admissible against all of them. It wasn't a guilty plea, so it's not a statement that the
It's any judgment of previous conviction is what 22 covers.
okay.
So
So to the extent that the actual certified is tendered, then if it is the fact, and it could, we don't argue that it, it's probably the fact that that certified alone is admissible only against Mr. Ryan. But the facts of the murder itself and the circumstances and what he did, we'd argue are admissible against all of the defendants in this case. So,
the facts,
yes.
right.
Not the actual certified, but I was speaking Ms. Hilton, not the court.
I can't hear you. I mean, I know that mic doesn't want to behave properly, but maybe you can borrow the witness stand mic if that one was even working yesterday.
It wasn't. I'll try to hold it carefully. So the certified itself, we may have no argument regarding that being used and there being a limiting instruction as to the certified itself against Mr. Ryan only. But we would also ask and would craft and present to the court an alternative if there is an instruction that is requested that includes language that the facts that are presented, that the jury takes as evidence, are admissible against all of the defendants, including any postings or statements that Mr. Ryan or Mr. Blaylock made as a result of or in furtherance of that act. It seems, Your Honor, as well that while the court can't hear us, it seems that while the court can't pick us up, somehow or another, the person who is running the camera, he hears all of our.
I have,
He's asking
that
us
is
to turn it off.
irrelevant to me.
I know.
I mean, I'm not worried about how the media can or cannot hear. I'm worried about whether the parties in this case and the court and the jury, when the jury's here, is able to hear.
Yes.
So they'll just have to deal with it.
Yes. Because the issue was they could hear our internal.
Oh, they can hear what y'all are saying there at the, so that's getting picked up?
Yes.
Well, that's problematic.
With all the mics off.
Okay, so y'all gonna need to adjust your microphone in a way that is not picking up attorney work product conversations. Can you do that?
We just get the fees from the courthouse.
Okay, well, then you're not gonna be able to to do the audio if it's picking up attorney work product conversations between the counsel at the tables. I don't know what to, I mean, some adjustment's gonna need to be made. I doubt if they can hear it all the way over there, but what all's getting picked up?
Just when we were having a conversation. I turned
The
it off.
state,
I turned the audio off. When I heard it. Whenever I hear a whistle.
well, I appreciate that, but I'd imagine it's gonna be pretty constant that they're gonna need to talk amongst themselves.
And it's happened multiple times in trial that people will text us, they can hear your conversations at the table. So this is a repeated issue that's been.
Okay, well, thank you for bringing it to my attention. Where's your feed, like your audio feed coming from? Where's it getting picked up from? Do you know where the mic is?
No, it's connected to the court system. So whatever feed you are being arrested.
All right, Ms. Persfield, can you get IT to get on that issue, please? She's watching on Zoom, I assume. Maybe I should text her too or email her too. Instant message her on my computer. Give me just a second. So you're attached to what, the Zoom?
Whatever feed the court gives.
I don't know what feed the court gets, but all right.
Ironic when the court can't hear us.
All right, Ms. Pursfield's reaching out to IT about it now. All right, do we want to turn to where we left off when we were last here, which was trying to sort out the nested hearsay in one of the wiretap conversations?
Your Honor?
Yes.
Before we turn the page, could I just get some clarity? Because I'm confused. The state, I believe, indicated that they thought the facts of the murder case involving Mr. Ryan were admissible in this trial, but the conviction wasn't. But then they started talking about limiting instructions.
Mhm.
And I'm confused. Are they maintaining that the jury verdict from a separate jury is admissible against in this case? Or are they abandoning that and saying that they're going to get into the facts of this case?
Go ahead.
We are saying, Your Honor, that the conviction itself is admissible and will be tendered, and that an instruction should be given that the certified that we intend to introduce that conviction should be considered against Mr. Ryan only.
Oh my.
But the facts of the murder and what happened should be considered as evidence if they choose to, believe it, against anyone currently on trial.
All right, so it sounds like
Well-
you do intend to introduce the certified copy of the conviction,
Yes, Your
and that would be accompanied by a limiting instruction that is probably similar to the one I gave before, that that can only be considered against Mr. Ryan. Of course, he's charged with the RICO count, right?
He is.
Okay. And then they would present facts which they would hope to be able to establish not only that a murder occurred, but that the murder was part of the RICO conspiracy.
We would
And
introduce.
that would be admissible against everybody charged with the RICO count.
We would, right, much like some of the unresolved murders that are in the indictment. We would be introducing the evidence that Mr. Ryan and Mr. Blaylock did it, and what connection we believe it has to YSL, and what they did to promote YSL before, during, and or after. So that evidence we believe is admissible against, well, we know it's admissible against everybody on trial now.
Okay.
All right, does that clarify?
Well, it clarified that we do not have an agreement, and I'm diametrically opposed to what the state is saying. Couple things. First of all, that verdict was not the verdict of the fact finders in this case, which
Sure.
we chose and are our jury, and that's Mr. Stillwell's jury.
All right.
Also, Your Honor, I'd like Your Honor to know that Mr. Ryan's case is currently on appeal. It's not a final judgment, it's on appeal.
All right.
And I guess I defer to Mr. Attorney Steele on this, because as I understood it, he was going through the law that would prevent them from presenting this as evidence. And it is evidence against us.
I'm sorry, when you say this, what do you mean?
The
Fact-
conviction.
Conviction?
I'm not worried about the facts. I understand the facts, but the conviction, and they want to use it as proof of an overt act, which as an
Only
element.
as to Mr. Ryan
Well,
is what they're saying.
well, no, they just said it against everyone as far as count one to RICO.
The facts that they're going to present, not the conviction.
Okay, well, I don't, as I understood the case law as Mr. Steele was reciting it, and maybe I'm wrong, but I thought we were at an understanding that they could, that's exactly what they could not do, is take a verdict from another jury and use it as substantive evidence against anyone in this case.
No, they can use it against, I think that they can use it against Mr. Ryan.
Well, they're using it against him for a RICO. This was not an admission by Mr. Ryan. This was not a plea of
No,
guilty.
he
This-
was found guilty. It's still a judgment of conviction.
Well, it's not a final
And-
judgment. It's on appeal.
Pendency of appeal doesn't matter in terms of admissibility. It's right there in the statute.
Okay, well, I understood the state said two different things, and so I was seeking clarity. I'm opposed to it. I'm stating my objection. I don't believe that if Mr. Ryan is charged with a RICO count along with my client, and they have the exact same element, and the jury's instructed that they need to find the commission of one of the overt acts, and they're told to consider the jury, the finding of a jury, a separate jury against Mr. Ryan. I don't know how they separate that. I don't know how a limiting instruction separates that and protects Mr. Stillwell's rights, and they wouldn't accept that same jury verdict against Mr. Stillwell and others for count one. I don't think a limiting instruction would be sufficient. I think they need to prove that case.
I think we have some case law that addresses that subject. I'd like to flesh it out, given Mr. Sharp's objection, but I'd preliminarily point the court to United States versus Pelullo, Pelullo, 14 F 3rd, 881 at 888. It's a Third Circuit 1994 case. And it specifically speaks to prior convictions being routinely admitted into evidence at subsequent RICO trials as an ordinary piece of evidence. A judgment is subject to evaluation by the
Slow down
fact-
a little bit.
Oh, I'm sorry.
A judgment what?
As a judgment, I'm sorry, as an ordinary piece of evidence, a judgment is subject to evaluation by the fact finder, who can accept or reject such evidence as it deems appropriate. Also, United States versus Tocco, Tocco, 200 F 3rd, 401, in site 417 to 418. It's a Sixth Circuit 2000 case, finding the district court's admission of evidence of a co-defendant's prior conviction permissible to establish RICO predicate. Here it says because the evidence was not used as collateral estoppel, but again, these are cases that I would need to flesh out. These are just preliminary cases for the court's consideration, given the argument that I'm hearing Mr. Sharp make right now, that we would point to as a starting point.
All right. Well, we're gonna have to. I guess we're gonna have to look if we think that within the next 2 weeks, we're gonna get to this,
Yes, yes.
or so, 2 weeks or so. Okay. So, Mr. Shar, are you clear at least on what the state's position is?
Now,
Okay.
thank you.
All right, we ready to turn to that Garlington wiretap? Hmm? Oh, yeah, I'm not deciding that issue right now. We'll come back to that. Sure. Evidence before the Garlington wiretap evidence? Okay, then maybe we need to set aside the Garlington wiretap and deal with the evidence that's gonna come in against Ryan. Okay. We'll wait till he gets back, but just trying to figure out which thing to turn to next. Okay, that's fine. Let's take a quick break for anybody that needs to run to the restroom.
Yet another wasteful day. It's still early, but we haven't accomplished not one thing. Not one. I stopped eating meat, Shay, because it just didn't taste the same anymore. It didn't look the same. And I kind of do a lot of reading and research on what's happening to the animals now and how they're grown. And I love to eat. I love food. I'm from Louisiana, so I kind of can just see the difference from when my grandmother used to cook versus how the food is now. And it also gives you a cleaner feel too. It's been 3 years now. Yes, the city is awesome, Coach Karen. I'm actually from a city called Opelousas, which is like 2 hours away from New Orleans. You got this, Rain. You just have to figure out what you like best. I eat a lot of fruits and vegetables, but I still eat seafood too. So but it allows you to be more creative and not eat the same thing every day. But it's doable. Even if you don't stop eating meat, I just say everyone do a good cleanse here and there. Okay, well, 33. I mean, you could say pescatarian, Renette, but I really just don't like to put titles on it. I just try to be more conscious of what I'm eating and eat more cleaner. But Anota, if that's how you say that, I definitely miss my Popeyes sometimes, but I've tried to see if I would go for the chicken or eat it, and honestly, I don't have a desire for it anymore. Thank you, Kim. Thanks for tapping in with us today, letting me fill in for Kayla. Monet, I honestly don't have no thoughts. I feel like all of our sentiments are the same. Okay, Kendall, I see you, Norberia. Um, we haven't accomplished anything yet today. I honestly don't know anything that has been brought out of this morning besides us realizing the seats have been changed and we still don't know why, with at least a definite answer to why. It's a lot of Louisiana up in here. I see y'all. Dang, I'm sorry, Shay. Popeyes, that used to be my life. We're not sure what happens with defendants yet, KK. Okay, Nene from New Orleans.
Stacy, your seatbelt fastened when the seatbelt sign is on, and keep it fastened.
Yeah, he has someone to do his hair.
Thank you, TJ. You always get them chips.
Looks like Kayla is here with us for a brief moment. Hi, Kayla.
Yeah,
I
what's
hope I'm
going
making you
on?
proud.
Why we on break again?
We're on break again.
Not watching at all. Why we on break?
A lot of indefinite happening this morning. A lot of uncertainties. I feel like I'm lost
So
in the
when I
sauce. Besides her crying and complaining and crying and lying, love.
so they're not ready to do anything.
Nothing.
Where's the witness?
Huh?
They don't have a witness ready.
No.
Why not? Where's the witness?
We're on a comfort break.
Well, but yesterday before they left, they said they had 3 people ready to go.
Well, they also said they'd be 3 hours with that man, and it took 3 days. So we'll see how that went.
Oh wait, never mind. This is a no jury day.
Right, but we still should have
So
had something presented at this point today with some type of progress.
I'm on an
Not a
airplane.
secret mission, slavery. Kayla, you on a secret mission?
I'm on an airplane.
You
In a
better not
minute,
let
I'm gonna
that
pull
flight
my
attendant
computer.
see you.
In a minute, I'm gonna print.
Okay. Oh, were you here when she was talking about we could hear her conversations on the mic?
No.
Yeah, I think she's trying to get the cameras out of there, saying the camera picking up they sidebar conversations. Like we can really hear them when they're whispering. She's so full of shit.
We don't cuss on the channel, and
I'm sorry.
she
Y'all know
knows
my
that
French come out of
we
me.
can't hear.
I'm gonna do better. But yeah, she's trying to exclude us, saying that we can hear her in their conversations when they're speaking.
Well, hopefully today I can get you guys a Holidays Chronicle. I haven't been to court in a couple of days.
Oh, we're gonna get Hallway Chronicles today?
Maybe.
Yeah, she's on a plane, Peach.
And by the time I land, I'm pretty sure there will still be no paragraphs.
For sure. For sure. I'm sure she is tapping into the live. She subscribed under her incognito account, waiting for notifications. No, we definitely
Play something for him.
What do you want me to play?
Sit here and look. What are you playing? I'm going to Atlanta, guys.
You from Baton Rouge, Sosa? Okay.
And do a recap from yesterday.
A recap from what?
See what was last assignment the last couple minutes of yesterday. Just open up a new tab. Don't close this one. Do YSL day 126. Oh wait, here we go. There's some movement. They're back. I land at noon, guys. I said that this morning when I got on the plane too.
Well, it is 9/11.
Well, I thought they were coming back.
I seen a head. I thought I did.
Hopefully I'll land in time for lunch so I can do some research. And when I get my computer going and get on the YouTube, I will do a poll to see what you guys want to do for lunch.
Pamela, she's muffled probably because she's on her flight and you know the flight attendants be policing.
All right, well, taking off. I'll see y'all in Atlanta. I'm here.
See you later. Have a good flight.
Well, I guess put out, see if you can pull up day 126 and play the last couple of minutes. It's really easy. Don't close this tab. Open a new tab.
Kayla, don't be talking to me like I'm slow.
Because you be taking the thing off. You can't. You gotta get your transitions together.
I'm gonna learn.
Oops. Yes, this is true. Is it true that Fonnie Willis was YSL Mondo's defense attorney a long time ago? Yes, this is 100% true. He did an interview about it. It's on YouTube. But for you guys who don't know, YSL Mondo is on the witness list. He's a defense witness. And he says that he is the co-founder of YSL. And he was previously represented by District Attorney Fonnie Willis. Now, this is an interesting comment. Okay. I think it's a conflict of interest. How can the co-founder not be on this RICO? Not sure. Cece, did you get it up?
I'm about to find when Mook said he going left if I have time.
No. No, just play yesterday at the end so we can see what her assignment was.
Oh, okay.
And so we're not sitting here looking at a blank screen.
Make our way a little.
I went through great lengths to preview what I was going to ask so as not to open up any doors for, for quote unquote statements that were never uttered or adopted by the witness to be admitted into evidence. The state is now asking the court to just admit documents into evidence that have those statements on it. Those statements provide nothing to the jurors. I don't know what conditionally means. I'm never going to agree to admitting things subject to redactions when I don't know what those redactions are. And it's completely unnecessary. We have read from the documents to get the words correct regarding specific things from those documents, specific acknowledgements from those documents, and both sides have done that. And that's what the testimony is. The proposed documentary evidence is full of inadmissible hearsay and other things, and also provides nothing to the jury at this point. So on behalf of Mr. Stillwell, I should say, oppose the admission of any of those documents into evidence at this time.
On behalf of Mr. Williams, I'm going to join in Mr. Short's response. We've already objected to the admission of any of those documents, and we would, I also do not know what a conditional admission of evidence is,
Well,
so
I
I'd
guess-
oppose.
Right, so I guess she means she wants to, if possible, be able to come to agreement about redactions of them, and if not, then present them to the court with her proposed redactions, which, I mean, maybe y'all can get together, and since we have a non-jury day tomorrow, we can deal with that tomorrow, but I don't mean y'all figure out what the potential redactions are tomorrow. I mean, have something ready to present.
Yes, and so, Your
tomorrow.
Honor, in as much as the tendering was done today, I'll withdraw that request until I have a redacted version to show counsel for defendants into the court.
Okay.
And the conditional, the court had it exactly right. It wasn't.
Maybe we should turn to the evidence that's gonna come in on Mr. Ryan's, on that. That'll happen before the wiretap evidence.
Yes, Ryan, I thought, are you talking about the email that Miss D. Williams sent?
I don't know,
Because
did she send one recently?
I thought Ms. Abbasi and I, that was what we talked about a few moments ago. You said, the two of you need to get together by the end of next week to go through those items so that we wouldn't have to use the
Okay.
court's time to do that.
So I guess it was, yes, Ms. DeWilliams' email from, well, it was a long time ago, about all of the exhibits.
Yes, Your Honor, and
Okay,
I'll
so
get with
y'all
Ms.
will get
Abbasi
together on that.
yes, to discuss a time.
Okay, and can you remind me, did the state decide that y'all can, I guess, concede that Mr. Ryan's statement to police is inadmissible or no?
Yes, we can use that.
Yeah.
Okay, all right. I thought y'all had conceded that, but I hadn't written it down on this. So. Let me put that in the issues that have been dealt with folder. what?
One of the matters that were addressed in an email by Mr. Ryan's counsel was the Harold Bussey stabbing. I believe Mr. Abbasi or Mr. Williams moved in limine regarding excluding the evidence that Mr. Bussey was stabbed. Our argument about it being intrinsic, the court last said, or gave Ms. Abbasi an opportunity to give case law stating that things that were used after the fact, Ms. Abbasi can correct me where I'm wrong, but acts that occurred after indictment could not be presented. And I think in her brief, she indicated that, I don't want to speak for her, but I think she indicated that she found no case law in support of that position. So we're prepared to argue
Okay.
that. I'll let her speak.
Yeah, we submitted a brief and went through each of the possible admissible purposes. And as far as completing the story, something which happened after the indictment was all in there. However, something which after indictment certainly could be part of the parcel and inextricably intertwined in the same facts and circumstances, but that's not this case. So the brief does put out in there that the intrinsic facts the state is seeking to admit does not meet any of the criteria or exceptions, whatever you'd like to qualify it as, for those acts to be admitted. I don't know if the state is planning to respond. I did submit that several weeks.
Right, and I read it and I marked on it, and now all I need to do is find it. I need somebody to keep me organized. Does the state have a response?
We do, and
Did y'all file a response?
No, we made an argument that essentially is the same one we're gonna make today, but based on what they've put forth, we'll respond specifically to the arguments that are asserted, put forth in Ms. Abbasi's brief. We got case law, and I think that the court saw that case law. I won't speak for the court, but I believe the court saw and was satisfied that the case law does say the acts occurring after indictment are not precluded as evidence of the conspiracy.
Right, no, agreed, but it's two separate issues. I mean, if it's gonna be, they're not precluded just because they're post indictment, but if they're gonna be admitted as intrinsic evidence, then they have to fall within one of the things that makes them intrinsic evidence, that it's the same series of transactions, it's necessary to complete the story, or it's inextricably intertwined with the evidence about the charged offenses. So what are y'all contending that it is?
All of them. So in as much as the arguments that are put forth in Ms. Abbasi's brief seems to focus specifically on
Your Honor, if I like that, I don't think there is a focus. I've never heard them state which theory they're proceeding under.
Right, yeah, you're saying it's not any of them.
Correct. I've never heard them state which of those three it's specific are.
So, Your Honor, I'll just tell Ms. Abbasi in the court right now. It is intrinsic to count one. Additionally, the conspiracy that it also is a part of is the YSL gang itself and the conspiracy that the gang itself makes up. I think we already presented some of the facts of the case to the court regarding the in concert action by five YSL members and two others of stabbing one person in defense of Mr. Ryan. And I know that the court has already read the indictment that describes, as the state alleges, the conspiracy itself being preserving, protecting, and enhancing the reputation power, et cetera, of the enterprise through acts that include assault and threats of violence. And of course, I'm not reading the entire indictment, but in this particular case, it falls squarely under a number of actions that are intended to sort of circle the wagons around YSL members, show that they will stand up for each other and that they will commit violence on persons who they perceive as threats to members of YSL. Mr. Ryan, after he was indicted, there were several, at least one YSL member that we have listed as an overt act who makes assertions about Mr. Ryan and his murder charge and subsequent, I think, conviction. And there are people who perform acts during the course of his trial. There was one person that we believe were intended to intimidate a witness who was actually on the stand at the time. There are, by way of examples or analogies of other similar acts that are committed on behalf of YSL to show their solidarity. For instance, when Mr. Garlington is jumped, other members of YSL immediately jump in. We have evidence that when Mr. Copeland is jumped, at least one person in the courtroom now jumped, just jumped in just because. When it's one of them, they're going to come to their defense. The act itself was.
Hear all of this argument, it'd be great under 404B. I'm waiting to hear which of the three categories it falls into. So we're talking about two different issues here. Which of the three, and then 404.
It is not 404B, it is intrinsic.
It could be both. I mean, I guess it would be intrinsic, but I mean, y'all haven't offered it as 404B, right? And you don't intend to,
Right.
even if I rule against you on the intrinsic.
Well, if the court ruled against this, it would be a different argument that we'd be prepared to make on a different day, because that's not something we were putting before this court
Okay.
today.
All right.
So the actions of Mr. Ryan and the other YSL members in concert in stabbing Mr. Bussey, when Ms. Abbasi asserts that they're not necessary to complete the story of the crime, this is our position, is that this conspiracy didn't stop at the jailhouse doors. It's ongoing. It's necessary that the jury sees that it is ongoing, to show to them the truth and the whole truth that we believe that our evidence reflects, to show them the extent to which YSL members go in order to preserve and protect not only their name, their own, but their reputation. Mr. Ryan, Mr. Blaylock, Mr. Eppinger, Mr. Myrick, and Mr. McMullen are seen in the photo that, I don't know that the court needs to see it, but if it does, we can present it on Zoom camera to show the concerted action on their part in stabbing Mr. Bussey. This particular screen grab of the video doesn't have 5 knives in the air like one of them does. This was just them all holding him down. And for the purposes of just this hearing right now, we'll just call it State's Exhibit 465, RR for rebellious writing.
All right.
Your Honor, I guess I'm kind of more confused now, because I think the state's purpose is they want to show that it's ongoing. So I don't know how they're using it to complete the story of the crime if their version is that it's not complete and it's ongoing. I don't see how those two square. It's not an element that the jury has to find the gang is continuing. The only thing they need to prove is that by the date of indictment, this happened. It really doesn't matter as far as what the jury needs to know to, for the state to meet the required elements. Doesn't matter whether the gang is continuing.
All right, but the state can prove if it chooses
They sure can.
that it's an ongoing conspiracy.
Sure, but that doesn't make it necessary to complete the crime.
Well, necessary to complete the story of the crime, and I guess the story of the crime is,
Ongoing and continuous conspiracy that is YSL, its enterprise, and the members committing these particular acts and crimes for the purposes listed in the indictment under the definition of the conspiracy itself. And this act is not something that is obviously relevant to the issue of whether or not the defendants are or are not guilty of count one in terms of what we're alleging that they conspired to do. It certainly would be an overt act under the definition of overt act of count one. So it would go to prove count one as to each of the defendants. It's therefore relevant, highly relevant as to that particular issue. It's presumptively, of course, the court is the gatekeeper, but under 402, because of its relevance, it's presumptively admissible. Under 403, Your Honor, there's nothing about it that is so substantially more prejudicial than probative, given its highly probative nature. Do you have the Zoom up here? Let me pull it up and put it on the Zoom. Considering it's coming, just, we're not in yet.
all right. Ms. Abbasi, can you remind me, and I don't know which one of y'all cited Murphy. Was that you, Ms. Abbasi? The part about integral and natural part of the witness's accounts of the circumstances surrounding the offenses, which factor did that go to?
I specifically did not cite that case. I did discuss whether it would be integral and natural part of what happened. I didn't cite him.
Okay, well, maybe it was just one I.
I did want to touch on one thing the state said, because I think we're getting into dangerous territory. The state said that this act in and of itself could constitute an overact to support the verdict. Well, now we're talking about trying to prove the charges against the defendant based on something not in the event.
Well, and you know, that's an issue that I've got written down here as something that y'all owe me law on, whether an overt act not listed could be the sole basis for a conviction.
Right, we do, and I think at some point.
Still waiting on that law.
No, we actually, I think at some point, and I might be wrong about this, but a contrary position was presented, and whatever case was cited, did not support that position. And we have affirmative case law that we present in the form of a brief to the court.
All right, will you go ahead and get that filed can you get it filed? When can you get it filed? By Monday? By Friday? All right, by Monday.
Your Honor, I can get to the part kind of the contrary case law. In the appellate, I know it sounds kind of, doesn't sound to square up, but it leads to an inconsistent verdict that perhaps some of the jurors found the defendants guilty based on the acts which were in indictment, and perhaps some of them found the defendants guilty on acts which were not in indictment.
I mean, it's gonna be real fun when we get to the verdict form. I think that we're gonna have to get really specific about what they're finding. Because I don't think it can be that 6 found one and 3 found another and 2 found a third.
I think that this situation, this precise situation came up in Cotman, and I could be very, very wrong. I read it, I glanced over it briefly, but I think that the court found that given that the court instructed the jurors that their verdict had to be unanimous, that it did not present a reversible issue. The defense argued, or the appellants had argued, that there was no way to tell whether or not they all agreed on the same overt act. But in giving the court the brief that we intend to present, I think we can address that as well. I think that that part is easily
All right, so
addressed.
that'll be two different issues. There's, can an overt act that's not listed in the indictment be the basis, the sole basis to support the conviction?
Mhm.
But then there's also, does the jury need to find unanimously this overt act, specific overt acts? Do they need to delineate which overt acts they are unanimously finding exist to each defendant?
Right, and I think that as it relates to our previous discussion that the court said we would address a little bit later, you know, whether we number them or whatever, I just off the top of my head, I think that them listing an act that they found unanimously had been committed as to the defendants, I think would suffice.
Okay, well, if we all agree on that, then we don't need a brief on that.
Okay. So, I'm sorry, Ms. Abbasi.
I don't know if we made it to the 403 part on this.
No, we hadn't. We sort of got sidetracked,
I wanna
but.
make sure I'm not.
All right.
All right, so we all agree that the jury is going to need to delineate. We unanimously find this overt act exists as to each defendant, right? I mean, we're going to break each defendant's counts out separately, and
I think that
I agree, but think that's.
will, and to make certain that we present clearly to the juror, to the court, we do believe, yes, that the jurors have to make a unanimous decision as to each defendant and as to their overt acts, but as to whether the overt act it finds as the one unanimously has to, you know, deal with the others.
I know, I mean, it can be wholly entirely separate as to each defendant. It needs to be a separate determination as to each defendant.
Yeah.
But for each individual defendant, does the state agree that the jury has to unanimously find two overt acts, one of which needs to, or happen within the statute of limitations?
We agree they have to at least find one that happened within the statute of
And
limitations.
it needs to be unanimous that, let's say they all find overt act 66, whatever that is.
I believe it's safest that they find unanimously.
Okay. All right,
And
then I don't need law on that because we'll just do that the safe way, whether it needs to happen that way or not. Okay, so back to, so I still will need by Monday whether an overt act not listed can be the sole basis for the conviction. And now we will go back to to what we were talking about, which is this
the intrinsic,
allegedly intrinsic act.
So Mr. Ryan, given Mr. Blaylock is not here, but I will, since they were the two that were charged with the murder in one of the overt acts listed on the indictment, Your Honor, Mr. Ryan and Mr. Blaylock have entered a plea of not guilty to count one. And they are obviously charged with committing an act of violence against a person as alleged in the indictment in a manner that furthered the interests of the enterprise in the conspiracy. The three, I guess, points that Ms. Abbasi referenced in her brief were that the intrinsic or the act needed to arise out of the same transaction or series of transactions as the charged offenses necessary to complete the story of the crime, or is inextricably intertwined with the evidence regarding the uncharged offenses. And there is an or, so it does not have to be all three. So given that the jury will hear evidence of Mr. Ryan's and Mr. Blaylock's concerted efforts as they related to Mr. Holmes. They will hear evidence of Mr. Ryan's actions after the murder of Mr. Holmes. They'll hear evidence about their connections to YSL, but the fact that you have other members of YSL acting on behalf of Mr. Ryan to support him in a violent way against another person whom they allege only messed with Mr. Ryan's commissary, stabbing him just because he messed with Mr. Ryan's commissary, show the extent to which members of YSL go to assert their dominance, even in a situation like the Rice Street Jail. And to protect one another, to show that you don't mess with one of our own. The argument obviously can be made by anyone. Yeah, this is not really what it's all about. But in terms of what the state is required to prove beyond a reasonable doubt to the jury, we alone bear that burden, given that it's evidence that there is violence committed on behalf of a member of YSL by members of YSL. We believe that it shows that the gang itself conducts itself in a particular way, and that
Okay, let's stop interrupting though. I mean, I assume she'll get to it at some point.
that the gang itself conducts itself in a particular way. And in Johnson versus State, a Supreme Court of Georgia case, whose site is 312 Georgia 481, decided September 21st, 2021, at Penn site 491. The court said that, of course, evidence is admissible as intrinsic when those three elements that we just mentioned exist. And they went on to expound and say, in applying this test, we have explained the evidence pertaining to the chain of events, explaining the context, motive, and setup of the crime is properly admitted. If it is linked in time and circumstances with the charged crime, the defendants, the YSL members, are all together. They are the ones that are included in or that participated in the stabbing of Mr. Bussey, are all housed together at the Rice Street Jail. The time frame is shortly after they're put together in that situation, all together in the Rice Street Jail. In this particular case, in Johnson, it has a set of circumstances that are not exactly the same as this, but we believe are analogous in many ways. In Johnson, of course, the appellant was charged with participating in criminal street gang activity, and the state's theory was that he was involved in the gambling house shootings with blood gang affiliate Porter and several unidentified assailants in another restaurant shooting. The evidence related, as the court found, to the Boulevard Place shootings added significant weight to that theory because the evidence was linked in time and circumstances with the charged crimes, and one victim was a member of a violent gang. We are not alleging that it is on all fours with our particular case, but to the extent that the Johnson court found it pertinent to say that the intrinsic act, or the act that the state alleged was intrinsic, added significant weight to the state's theory for these reasons. We believe that that is analogous to our case as well, with seven total, acting in the same, overacting with an extreme amount of violence on behalf of one person, whose connection we believe with the 5 YSL members is just they are all YSL members and they are acting protectively towards him. We believe that incident adds significant weight to our theory of the willingness of YSL members to participate in that enterprise in a manner involving violence to protect the dominance and the members of the enterprise and the gang itself. So the court found that even though the state didn't charge appellant in connection with the shooting, evidence of the incident was relevant to disputed issues in this case. So as Mr. Ryan has entered a plea of not guilty to count 1, conspiring to violate the Racketeer Influence and Corrupt Organizations Act by participating in YSL through these acts or conspiring to participate in them, then evidence of the involvement of Mr. Blaylock, Mr. Ryan, Mr. Eppinger, Mr. McMullen, and Mr. Myrick, all of whom are also charged in this indictment with the conspiracy. Evidence of Eppinger being charged with the shooting of an officer, and that Ryan, who was promoting YSL while in prison when Eppinger got a bond for shooting at the police, that Blaylock is a co-defendant on the murder of Mr. Holmes, which is an overt act here, and that Demise McMullen is a named co-defendant on the 2015 murder in the same indictment, shows how intertwined these people, this type of action, and this gang itself is with one another. They're all inextricably intertwined with the evidence regarding the uncharged offense, which is the stabbing of Mr. Bussey. So we believe that it satisfies the requirement of the requirements of being an intrinsic act.
Okay, which of the 3?
The third one, we believe is the strongest in that it's inextricably intertwined with the evidence regarding the uncharged offense.
No, it's the charge, it should read the charged offense, right? I mean, it needs to be inextricable, right?
Yes, that the
Just a
case is
typo.
citing it wrong. Yes, thank you.
So-
And that being count 1, the conspiracy.
So how is it, and you think it's also necessary to complete the story of the crime, right? You're not asserting that's the same series of transactions as the charged offense, are you?
When the court says the same series of transactions, we believe that it's an overt act, in as much as it could be considered an overt act to promote, to support the gang. So in as much as it is or can be considered an overt act for count 1, and that it is gang activity, which it is.
All right, I'm not quite sure where I got this language, but I jotted down, and I think this is kind of the definition of inextricably, or an explanation of inextricably intertwined with the evidence regarding the charged offense, is that it is an integral and natural part of a witness's accounts of the circumstances surrounding the offenses in the indictment. Anybody
So,
know if that's
So this-
that's as to, that's the explanation for what it means to be inextricably intertwined.
I think that came from Murphy.
That's Williams versus State, 302 Florida 474. Cited in the brief.
What year is it was Williams?
2017, it's cited to 11th Circuit.
Okay, and I think that language is also in a Court of Appeals case in 2020.
Okay, so, but I mean, if that's what it means for it to be inextricably intertwined with the evidence regarding the charged offense, how is that an integral and natural part of a witness's accounts of the circumstances surrounding the indicted offense?
So if the indicted offense is the conspiracy itself, and our witnesses talk about what they've observed, and we have evidence of what has occurred to further that conspiracy.
So would this be a witness who's being presented regardless, or is this a witness as to, I mean, obviously, if they're just coming in to testify about what happened in the jail, that wouldn't be the same thing, because I would have already made the determination, oh yeah, you can talk about this. Is there going to be any witness who there's no way they can give their account of how it is that any of these defendants is guilty of RICO without telling the jury about the stabbing?
No, we're not saying that. We're not
Okay.
saying that at all.
So then it's
No.
not inextricably intertwined.
But it does, it's an uncharged offense. That arises out of the same transaction or series of transactions as the charged offense of count 1. And the series of transactions is the acts of violence that have been described. One of the overt acts, as I said, is the murder of Mr. Holmes by Mr. Blaylock and Mr. Ryan, as we've alleged in the indictment.
And then how does
And
this
then-
arise out of that transaction?
The series of transactions, one of them is that the series of transaction is the set of actions that occur after, before, during, and after that murder itself. The series of transactions are the overt acts that help promote the purposes of the conspiracy. You have Woody Lee posting, I'm sorry, we made you a thug, so early little thug. You have people who are acting within YSL in support of Mr. Ryan. Mr. Ryan essentially talking about staying true to YSL regardless of his circumstances after the murder.
All right, and are all of those overt acts?
Yes, those that I
are
just
alleged?
named are, yes, alleged overt acts. So the series of transactions, we would argue, is not a simple matter as on Monday, July 3rd, he got up, went to the store, bought a gun,
Yeah.
did that. It's
All right,
more
remind me
broad.
when the jail stabbing occurred.
It was February the, what day? February 20th.
Of,
February the 1st. January the 1st of 31st of 2023.
January 31st, 2023,
Yes.
and he'd been in prison, I guess, since 2019. When did they all get moved to the jail?
Mr. Ryan, I think, and Mr. Blaylock, those 5 co-defendants were, I'd have to look and see in Odyssey when they were transported, put together in.
Roughly.
Thank
Okay,
you.
Approximately.
okay, that's, I mean, approximate is fine.
And Also, Your Honor, under 104, and I get that we are still hashing out whether or not it's intrinsic. Once the court makes that determination, and we believe that it's clearly intrinsic regarding the conspiracy and the gang itself, there's another argument in support of its admission and use at trial that we make under one of the other rules of evidence, but not until we finish this part.
Well, I'm curious now as to what that would be.
Just that under rule and I'm also curious about how the court will see or not see this position that I'm offering. But under 24-1-104, which specifically deals with the court handling the admissibility of evidence and the court's determination of it. 24-1-104E expressly says that this code section shall not limit the right of a party to introduce before the jury evidence relevant to weight or credibility. And so to the extent that part of our evidence, and it doesn't, speak to the weight of the evidence of the murder, but we believe that it substantiates and it corroborates our assertion via the overt acts that we have listed, that there is this conspiracy and that there are efforts that are continually made by members of YSL to support and protect one another and to advance the dominance and notoriety of the gang through acts of violence and assault.
All right, well, I do not think 104 has any bearing whatsoever on whether y'all can admit it before the jury.
Okay, see, I knew.
Okay, so that takes care of that one.
All right.
All right, do you have any, can you look, if you haven't yet, for any case law that deals with kind of a similar set of facts? Mr. Atkins is shaking his head, yes.
Since
you
he
can
is-
look for that.
Oh, that is, we definitely can. I was just trying to make sure that I fully got what the court was saying. So in saying the same set of facts, is the court speaking that
Similar set of
specific
facts.
as to, somebody jumping somebody?
Well, I mean, yeah, ideally, if you could get that, that would be great. But no, it doesn't have to be that specific, but something that deals with gangs and or RICO, because what I hear you saying, or what I think I understand you to be saying, is that part of why this is intrinsic is because it's necessary to give a full story of how YSL is this ongoing criminal enterprise that uses violence to protect their members.
Right.
Am I understanding you correctly?
You are, and to assert its dominance. And in support of that, I also say that each of the members of YSL, Blaylock, Eppinger, McMullen, Ryan, and Fleetwood, had all, I believe all of them had been brought in from prison for YSL related offenses that they had been convicted of. Eppinger had been sentenced to prison off of a probation revocation for an armed robbery after he shot Officer Rogers. That was a YSL related incident. Mr. Fleetwood had been brought in from prison after shooting at Milton Howard, who at the time was driving YFN Lucci's vehicle with tinted windows. So the argument obviously could be made. He didn't know it was Mr. Howard. He knew it was an ops car. So all these people are all incarcerated because of YSL related offenses. And then you put them all in the same little area, and they are once more acting as one single bullet against somebody they believe is a threat. But I can and we will look for a case on all fours with this particular set of circumstances.
Okay.
Your Honor, should we say about 403 argument until the state?
I mean, I honestly think the 403 argument is easier than whether this is intrinsic, but yeah, I'll go ahead and hear that because maybe that'll be dispositive of this issue.
So would Ms. Abbasi, should I let her go first, sit down and see the floor, or does the court want to hear from the state?
It's in the brief, so I'll let you begin.
Well, I mean,
They have the burden, I'll give you the.
all you really say in the brief is it doesn't meet 403. You don't really say why.
Well, it's that it has to survive the balancing.
Okay, well, that's pretty clear.
To exclude what is a scant or cumulative open court, I think everything in here we're dealing with is scant and cumulative. There are, I don't want to get wrong, how many other acts in here the state can prove. These are not necessary. I'm sorry. Is that on? That in the 403 analysis, the court should determine the prosecutorial need, degree of similarity, and temporal remoteness. There are 191 overt acts. I think by the time the jury has heard all of those, they will have heard quite a bit of evidence regarding how gangs operate, examples of criminal street gang activity already. Quite a bit. I'm sure by November there will be more. Don't think there's any prosecutorial need to be coming up with these things additionally. There is plenty. Your Honor is able to exclude evidence which is cumulative, which is of course prejudicial, and a waste of time. I think that's where we're getting to in this circumstance. Clearly, there was enough evidence for the grand jury to return an indictment when
Well,
they heard this.
that's a lot lower standard.
It is, but if even that lower standard, it was met there, then I don't see how it suddenly become necessary here.
Okay. Go ahead.
Judge, I've heard, and everyone I believe has heard a lot about the notion of the evidence being cumulative, as if there is a certain amount of evidence, the state who bears this very high burden, I'm sure we'll hear told over and over again in closing arguments, that the state should be allowed to present to meet that very high burden. And I don't believe that cumulative evidence means proof of a different kind to show or to prove the same act. Just because the state has 150 ways to prove that the defendants conspired to violate the Georgia RICO statute, and the state, in an effort to ensure that each of its victims are adequately represented and that the jury hears sufficient evidence to allow it to convict each of the defendants, doesn't mean that the state should be constrained to putting up one piece of evidence, one picture showing somebody throwing up a gang sign.
Can I ask you a question? How many of your overt acts, if any, are assaults or aggravated assaults that are designed to either protect alleged members of YSL or promote or continue the, I can't remember the word you said, but the dominance, assert the dominance of YSL?
As it relates to Mr. Ryan, or just in general?
In general, since the argument is this is done to protect members of YSL and
to assert their dominance.
Assert the dominance of YSL.
Okay. Since an overt act does not have to be a crime, I'll just name them, of course. So number 9, where defendant Williams asserts in one of his songs, YSL.
No, that is not what I mean. I don't mean saying you're gonna do something. I mean actual assaults on people.
We have Mr. Holmes's death is alleged by the state to have been a murder of someone that they believe to have been a member of a rival gang.
All right, so
Mr.
I'm sorry. I mean, I guess maybe, so because it's a rival gang, that would be dominance.
Yes,
And
it's-
that's overt act, what, 79 or 69?
And I can also even be more precise there as I look for that number 79 or 69. Mr. Drinks's murder is alleged to have been a direct retaliation for the death of 2 people who were
Okay.
associates.
Your Honor,
Mhm.
I'm sorry, I'm just trying to
69.
I'm trying
determine
to
what you're
figure-
asking. Are you asking what the indictment alleges?
What,
Is-
yeah, overt acts.
Well, the
alleged in
indictment,
the
as I
indictment.
understand it, just broadly alleges that the overt acts are done to that, for those purposes. The indictment broadly alleges several purposes and doesn't delineate which overt acts are designed to do what. So the answer, as far as I understand your question, would be all of them. They've
All right,
alleged all
well,
of them.
but I mean, I'm asking the state sort of what, I appreciate that position, but I think I'd mean it a little bit differently than that. And yeah, sure, they could end up saying every one of these does all of these things, but I'm kind of asking them to be focused on aggravated assaults, obviously, or worse, murder, that are for these very specific purposes.
So to answer your question about the number for that murder, it was overt act number 79.
All right.
Also, the act on 4/28 by Mr. McMullen.
Overt act number
April
28.
April
Oh,
28th.
okay, yeah.
I'm looking at them in chronological order.
All right, that's fine.
The act by Mr. Garlington, Mr. Sledge, that act of shooting Miss.
Are we talking about things like rival gang type incidents?
My understanding of what the court said
I
is
just
what
want to know what
acts
the state's position is.
that were done to acts of violence done to promote either the
Either
notoriety or to
protect
protect.
the members of YSL or to promote the dominance of YSL.
So the shooting, we believe, by Mr. Winfrey of Lil Wayne's tour bus, which would have been a different one. It's encapsulated in 39 and 40. The shooting of Mr. Murphy. On April the 12th.
Do you
Jackson
have any other
Montgomery.
overt acts where members or alleged members of YSL are basically doing a beat down of anybody because somebody from YSL got threatened or attacked?
We have other ones where they're shooting at other members, and we
Okay.
have where they, for instance, Mr. Kendrick and Mr. Arnold go out and plan to shoot somebody because someone jumped on Mr. Arnold in a club.
And that's an overt act?
It is.
Okay.
Where also I think we have. Yeah. And they are, I think, Acts 41 through 45 is the
Okay.
Other than the murder
All
on
right.
the 28th that or the
Thank
aggravated
you.
assault that I talked about.
Okay. All right, well, y'all see if you can find me some more on point factually case law, please.
Okay.
And
Is the
I know
court,
y'all want a decision, but
that's the.
we're gonna come back to it yet again.
And Your Honor, in terms of the number of acts that we've enumerated in here, does the court want specifics or just the number?
Yeah, that's all right. I mean, you've told me enough. That's fine.
Okay.
I mean, it's not like that's critical to my determination.
Okay.
I just was wondering if there were so many that this was something that would really be cumulative, but it doesn't sound like you really have anything that similar to this.
And as well, Judge, in terms of judging whether or not something is substantially more prejudicial than probative, it would have to, I think I've said it before, it would need to tend to sway the jury to convict the defendants on a ground different than something that has been alleged in the indictment. And given the allegations that we've made, we don't believe that this comes near that category of cases or circumstances. As well, Judge, I know the court is aware, but just to put it out there, 403 is, all of these rules of evidence are rules that favor admission. And so 403 is not to be used as been alleged to limit the state's ability to present evidence so much as it is a permissive statute that under very rare circumstances should be used to exclude relevant evidence. And the mere fact that a defendant may feel that, oh, the state has too much evidence against me, is not one of those circumstances that the courts have recognized.
So actually do speak about prosecutorial need.
To the extent that the argument throughout is that YSL is a gang, that everything that has been, that YSL is a music label, that everything anybody does is just their own independent act that has nothing to do with YSL from day one, from openings throughout up to even now. The assertion by every defendant is, and even the witnesses, I did it for myself, by myself. Every step of the way, the state is having to rebut that assertion that this is just me. I'm a criminal, but they aren't.
Okay.
So to the extent that there's no one here willing to stipulate that crimes are being committed by them and others with whom they've conspired to promote or on behalf of YSL, the state has a very strong need to present evidence of one, concerted efforts to commit the acts that we've alleged, to show the conspiracy between the defendants, and to show the purpose behind their concerted efforts.
All right, thank you.
Your Honor, I'm just looking
ma'am.
here at some case law on prosecutorial need to see what I have to answer Your Honor's question in that respect. It's in 403 itself, in case law, kind of more specific. to keep looking, I'm looking as I'm speaking here. As far as the prosecutorial need, I'm looking at cases where the need is there's no other source for that information, or at least limited sources of that information. I'm not sure how many hours of gang expert testimony the jury has already heard from about how a crime can further a gang or be part of a gang. I think the need to that point on this principle, that there is no need. They've heard about it in depth. They will continue to hear about it. And as I said, I'm trying to look and see if I can get any more case law to specify if we have a level or a test for what need is.
All right. Thank you. Well, if you find something else, feel free to just, shoot it over in an email that you share with everybody. That'll be fine. It doesn't need to, I mean, if you want to file it as a brief, that's also fine, but.
What I've got, just looking at some case notes here. Prosecutorial need to induce a prior rape-related incident to show. Yes, I'm sorry. Explaining that the prosecutorial need to introduce a prior rape-related incident to show the defendant's intent was high because there was little other evidence supporting the charge of aggravated assault with intent to rape. That is a case, Kirby versus State, 304 Georgia at 483. And I haven't read that case. I'm looking at it. It is cited within Jackson versus State, 306 Georgia, 69 from 2019.
All right.
And Your Honor, could we get clarification? Is that a 404B case or a 414 case or 413 case, Kirby?
This is addressing a 403 issue.
Is it in the context of a 404B?
I don't know, but it's not a different analysis under 403.
As I said, I've not read the full case. It is
No,
just
I mean,
cited
it's
within-
fine. I understand the concept. Okay, let's set that aside and move on to something else. So there was I've got some notes of things we were going to circle back to. And one of them was a video of somebody smoking pot wearing a chain and it saying some things. BB maybe and Eppinger, some about robbing Smith. What was that about?
Yes, Your Honor, I believe that Mr. Shard, we were supposed to narrow
It
down
was-
what video
yeah.
we were going
Okay.
to admit. I sent that over a few weeks ago, which ones we intended to use. I'm not sure we've been able just to talk about it in light of the last couple of weeks.
Okay, well, these are notes from back when we had that non-jury week, which I feel like has been a while ago now.
Yes, it was the week of August 19th, Your Honor.
Yeah, that's what I thought. So and that, I guess that was with regard to counts 27 through 29, maybe, is I think what I wrote down.
Yes, Your Honor.
So is that a video y'all intend to utilize?
We sent over, there are portions of that video we intended to utilize. I believe that the portion that was at issue is not a portion that we need to publish to the jury, Your Honor.
You're not going to show the jury?
Portions of the video. So the video is maybe approximately 5 to 7 minutes, and there's a portion, and I want to pull up my notes to see what I actually sent over to defense counsel as to what timestamps we intend to use, but a portion of it is relevant because it shows Mr. Eppinger and Mr. BB, the two
Mhm.
people alleged to have committed this armed robbery,
Right.
on the phone. And a portion of that video, Mr. Eppinger appears in I think it's like a Instagram picture, an Instagram video and BB shows him the chain, but there's another portion of the video in which Mr. BB is pointing a weapon at the camera. So there's just relevant portions, and we just haven't had the opportunity to discuss it, Your Honor. And I can let defense counsel know what date I sent over what the state intends to show.
All right. Does defense counsel still object to whatever portions those were?
Yes, I'll re-forward the email. August 23rd at about 1:55 p.m.
Bless you.
Sent are approximately 5 clips that probably total together about 6 minutes of actual viewing. Is that about right, Ms. Hillen?
Yes, sir.
Okay, so in all honesty, we haven't had a group this is all acts involving someone that's not sitting here. And if we could have a couple minutes
Okay.
just to talk as a group to figure out
You may.
what our stance is. on
All right,
this.
and you know what? I may have y'all do that over the lunch hour. So the next thing I had us circling back on was, and I guess maybe these were from I don't know, we were going through maybe one of the sets of statements, because I've got like page 2, 523, 513. Oh, these were the wiretaps, maybe. Big Nick.
Yeah.
Waters Road. And then, oh, the comment about, yeah, this was the wiretap stuff, the flipping the car and laughing about that. And the state had said y'all were gonna narrow what you wanted to use from that and let us know. Do you recall that?
Just trying to remember flipping the car portion.
I don't know. It was there were 2 reference numbers. One of them was 513, one of them was 523. It was on that chart that you gave us, I think. On the second page of it, Garlington talking about how they came through and thought they were going to come back and they were going to get ready to light them up, laughing about Shamel Drink's murder and the need to re-up on drugs to sell. And I had determined that the drug part was in, but y'all were gonna look again at that other part. You said there was a non-hearsay purpose for it. Did did y'all ever go back and do that?
By lunch, we can.
Okay.
We'll be able to have an answer by lunchtime.
Yes.
Would you kindly just repeat the two reference numbers?
Yes, 513 or 523. On the chart, it's 513.
Thank you.
And then when we got to 1109 or 1124, there was an argument that that shouldn't come in against Nichols or Stillwell because they had already been arrested at the time and somebody was going to provide law on that.
Yeah, did that fall under the broader proposition that the court sort of touched on earlier regarding whether or not overacts occurring after arrest could be used to prove the conspiracy itself, which would include people who have been arrested prior to the act being committed? If it did, we'd like to sort of address it.
I mean, I think y'all would need to establish that they're still a part of the ongoing conspiracy. Listen to and did re-listen to the part that on the chart is 1974, and I think the other reference was 1999. And this was I don't know if the argument was 403 there. Confusion, I think, was the argument. And upon re-listening, I don't find that to be a 403 issue. So that is admissible. That was about as far as we had gotten. And then, of course, we still need to circle back on the That one that we got bogged down with the nested hearsay with Garlington talking to Funk, who talked to Quay, who talked to Rel. So why don't we break for lunch? Y'all got some tasks to do over the lunch break. Do you have the material for me to look at? Yeah, it's not noon yet. It's about 1:45 but.
I just reached out to our other team members.
Okay.
To try and.
All right. Are you gonna email it or bring it as a hard copy or what's?
I'll email it, that makes it quicker.
Okay. All right. Please do that over the lunch break. Let's reconvene at 1:15.
Yes, Your Honor, and I also put 460 on top of.
My copy of 460. We never did find.
I found our copy.
Okay, great. Thank you. Thanks.
You told me at the meeting you wasn't gonna ask me the question, but then you get in the courtroom and ask me the question.
So,
That's what happened.
okay. So was it that I said I'm not going to ask you that, or did I tell you not to tell the jury that?
You said how I took it when I
How you took it. I just need to know my words. John,
It's non-responsive. Ask your next question.
my words only. Did I ever tell you not to tell the jury that Defendant Williams encouraged you to talk, to tell, take Kenneth Copeland to the police station. Did I ever tell you that?
You just said you didn't want me to say that.
Okay. Now, is it your testimony that I said, I don't want you to say that, or I'm not going to ask you that?
Both of them.
Overruled. We don't really have a clear answer.
All right. And it's your testimony that your lawyer and Lieutenant Lansico were still right there when I said these words that you heard?
Yes, so I wouldn't have said it.
All right. And based on what you just testified to the jury, you gleaned from that that I didn't want you to tell the jury.
I never used the word tell the jury. I just said exactly what you said to me. I say, Ms. Love told me that she didn't want me to say that, and she wasn't gonna ask me that question.
Okay, so then your memory is not, you don't remember telling Mr. Steele. You do not remember asking Mr. Steele saying, did Ms. Love tell you do not tell the jury?
If he said jury, I forgot, I made a mistake. And I should have corrected Mr. Steele if he said jury. But I'm telling you what you said to me in the meeting. I ain't saying you said don't tell it to the jury. But that's the way I took it too, because that's who I'm supposed to be talking to, right? Telling the truth to, right?
Right.
Okay, so in my way, not the lawful way, that's the way I took it. Because if somebody tell me, oh, I don't want you to tell my girlfriend this, I'm gonna take it this. You feel what I'm saying? You don't want me to tell the truth.
Okay. So, all right. We're going. So were you surprised when I asked you, did he encourage you to take Kenneth Copeland to the police station if you thought I didn't want you to tell the jury? I'm exploring what he said his understanding was.
Overruled.
So were you? When I asked you that question, were you surprised given that you thought I didn't want you to talk about it?
I don't know. I can't recall. I don't know.
All right. Now, on cross-examination, did you tell Mr. Shart that you didn't feel like you could go to trial, or you didn't have the ability to go to trial? And
That's how I couldn't afford to go to trial.
Okay.
That's the question he asked me. He didn't say the ability. He said afford.
All right. And that's the reason that you answered yes to all the questions that you answered yes to on State's Exhibit 444 Yankee and 1AS?
I don't recall.
Having had time to think about it now, do you remember and realize that your sentencing acknowledgments placed you in peril of probation revocation if you testified inconsistently with something you said was true during your plea agreement?
I don't think I testified nothing that wasn't true today, if I recall.
Do you remember testifying on last week when I asked you specifically about portions of what you agreed to and for you to tell me if any part of it you're now testifying is false, to label it false, and if any part of it, if it's all true, to tell me it's true. Do you remember me having that conversation with you?
I remember the conversation, but you had put so much on, I don't even recall what went on.
Do you remember me putting in front of you State's Exhibit 447Y? And
Yes.
I object, like a new question.
You'd like a new question?
Rather than you remember me doing this, just
Oh, okay. Right. Whether he remembers it or not is not really the relevant matter.
Oh, God.
all right. Did you testify that
I never seen
number?
that. Not
I
highlighted.
give you the number.
All right.
Did you testify that number? I took it already. I put it back. These spaces at 1AS. Here it is. Okay. And it's 447. The second part. Did you testify that, looking at this, at State's Exhibit 1AS, did you testify that number 3 under defendant's factual acknowledgements is not entirely true?
No, I didn't say it was not entirely true. I think I remember I said the part of the support of YSL, and you put care as a robber gang member. I told you.
Ladies and gentlemen, please be seated.
All jury present accounted for.
All right, thank you, Sergeant Ingram. Good morning, ladies and gentlemen of the jury.
Good morning.
All right, sound good. Without further delay, we're going to continue with the presentation of the state's case. State, call your next witness.
Good morning, Your Honor.
Good morning, sir.
Officer Floyd.
All right, summon Officer Floyd, please. Officer Floyd, good morning, sir. Sir, if you would please approach the witness stand. Once you get there, if you would turn and face Sergeant Ingram and be sworn as a witness before you sit down, sir.
Raise your right hand and swear firm testimony you give the truth, the whole truth, nothing but the truth.
I do.
Have a seat. State spell your first and last name and how.
All right, Officer Wesley Floyd, Wesley. Last name Floyd, Floyd.
Good morning, sir. How are you?
Good, how are you?
Officer Floyd, where are you employed?
City of Atlanta Police Department.
How long have you been with the City of Atlanta Police Department?
About 10 years now.
And what unit are you currently assigned to?
Currently, I'm assigned to our training academy.
And what do you do for the training academy?
I teach recruit classes.
What unit were you assigned to previously?
Zone 3, evening watch.
And how long were you with Zone 3 Evening Watch?
About 5 years.
Were you post-certified during that time?
Yes.
What were some of your responsibilities as a Zone 3 Evening Watch officer?
To respond to 911 calls primarily.
What coverage area did you cover as a Zone 3 officer?
My primary area is what's called B sector. It's pretty much everything south of 166. So Cleveland Avenue, Metropolitan Parkway, those areas.
Officer Floyd, I'm showing to you what's been pre-marked as 31B Victor and 30 Victor. Officer Floyd, do you recognize those documents?
Yes.
And what are
It is a roadmap of Zone 3.
they? Okay, that 31 Victor or 30 Victor?
31 Victor shows all of Zone 3.
And 30 Victor?
30 Victor is a more specific area in Zone 3.
Okay, are those accurate representations of the area you were assigned to?
Yes.
Your Honor, at this time, the state genders 30 Victor and 31 Victor.
Any objection to either 30 Victor or 31 Victor?
No objection on behalf of Mr. Williams.
All right. 30 Victor and 31 Victor admitted may be published as you see fit.
Officer Floyd, I want to turn your attention to May 11, 2016 at approximately 3:30 p.m. Were you on duty, sir?
Yes.
And were you patrolling the streets or were you in the office?
I was patrolling the streets.
Were you in a marked patrol vehicle?
Marked patrol vehicle.
Were you in uniform?
Yes.
Were you wearing body camera at the time?
No.
Why not?
We weren't assigned body cameras yet.
Do you remember hearing a call over the radio about a stolen vehicle?
Yes.
What was the nature of that call?
That there was a vehicle that had just been carjacked.
What was the description of the vehicle that was carjacked?
It was a black Toyota Corolla.
And what was the location that the Corolla was reportedly taken from?
Somewhere on a mall drive. I don't remember the numbers.
After hearing the carjacking call over the radio, do you see a black Toyota Corolla matching that description?
Yes.
I am now publishing states 30 Victor. And Officer Floyd, if you can, to your right, there's a ruler.
Okay.
If you use that ruler. Can you show the jury where you first were when you see the Corolla matching that description?
Right up here at Lakewood Avenue, where it meets 166. I was traveling northbound on Lakewood Avenue, going up towards off the screen.
Okay. And what direction was the Corolla traveling?
The Corolla was coming off of 166 eastbound, that Arthur Langford eastbound right there, getting onto Lakewood Avenue.
Were you able to retrieve any tag information from the Corolla at this time?
Not at that time.
Why not?
It was traveling, when it got off, it was traveling the opposite direction that I was traveling in.
So you were traveling towards Pecan Drive, is that?
Yes, I was traveling northbound right here where Pecan Drive is, and they came off to go, I guess that's westbound on Lakewood Avenue.
Okay. So do you make a U-turn and travel in the same direction as the Corolla?
Yes.
You can see. Okay. So now. So you make the U-turn. What direction does the Corolla travel from Lakewood?
It made a turn onto Bicknell.
Is that a left or right?
Left-hand turn, traveling south on Bicknell Street.
And once it turns left on Bicknell Street, were you able to maintain sight of the vehicle?
No, I lost sight of it when it turned onto Bicknell.
After losing sight of the vehicle, after losing sight of the Corolla, what direction do you travel?
I traveled onto Bicknell Street as well, trying to regain sight of it.
So you made a left as well?
Yes.
And do you see the Corolla a second time?
Yes, eventually.
Where at?
It had turned onto Polar Rock Road. It made a left from Bicknell onto Polar Rock eastbound. And I caught back up to it on Polar Rock Road.
And were you able to get behind the vehicle at this time?
Yes.
Were you able to pull the tag information at this time?
Yes.
And did the tag information match the description from the reported carjacking?
Yes.
Do you really like the vehicle at this time?
Yes.
Does the Corolla stop?
No.
So now you're pursuing the Corolla on Boulevard Road, correct?
Yes.
All right. Where does the Corolla travel from this point?
The Corolla ended up making a right-hand turn southbound onto Lang Drive.
Okay. And from Lane Drive, where does it travel?
It turned south again, right onto Macon Drive.
And you're still pursuing at this time, correct?
Yes.
Where does the chase subsequently end?
It proceeds south on Macon Drive all the way to the intersection of Cleveland Avenue, where it was involved in an accident. And that's where the car chase portion of it ended.
What was the description of the other car that was involved in the accident? Or what kind of car was it?
Oh, in the accident, it was a silver Audi.
In just a moment, Officer Floyd, I will be showing you states 19 Victor through 28 Victor. Do you recognize 19 Victor through 28 Victor?
Yes, I do.
How do you recognize them?
That's the intersection of Macon and Cleveland.
And are these photos a fair and accurate representation of the accident location that day and vehicles after the accident?
Yes.
Your Honor, just time to state tenders 19 Victor through 28 Victor.
Any objection to 19 Victor through 28 Victor?
All
All right. States 19 Victor through 28 Victor are admitted and may be published as you see fit.
Officer Floyd, I am now publishing 19 Victor. Please describe for the jury what this is a photo of.
That's the intersection of Macon Drive and Cleveland Avenue facing the convenience store.
I am now publishing 22 Victor. You please tell the jury what we are looking at.
That is the silver Audi that collided with the black Toyota Corolla.
And 23 Victor.
The same car.
Victor, I have no questions. All right, what are we, please tell the jury what we are looking at here.
That's the black Toyota Corolla that I was in pursuit of. And that's where it came to rest on the side of the road after the accident.
And that's the location where it subsequently ended after the accident?
Yes.
What happened after the parole came to arrest?
After it came to the arrest, the driver's door opened up and the suspect inside began to flee on foot.
How many suspects were in that vehicle?
Just one.
Did you pursue him?
Yes.
Did anyone else pursue him?
Yes.
Who?
There's another officer, I believe it was Officer Baker in my report that pursued him. He got ahead of me.
Did either of you catch him?
Officer Baker did.
Now, when you heard I'll take you back a little bit. When you heard the bolo of the particular vehicle, do you remember what the bolo was?
Black Toyota Corolla, and they provided the tag information, but I don't know it off the top of my head.
Anything about the suspects or suspect?
It was black male suspect with khaki pants, is what the bolo said.
Were there multiple suspects or just the one?
I only knew of the one.
What was the gender of that person?
Male.
I'm not publishing 18 Victor. Officer Floyd, is this the suspect that you apprehended today? That was apprehended today?
Yes.
And this is the suspect wearing the tan pants and the leading question. What was the suspect wearing?
Tan pants.
Court's indulgence, Your Honor.
Yes, sir.
Officer Floyd, just a couple of quick questions. How long did your pursuit of the black Corolla last?
Distance or like time?
Oh,
Distance, after the fact, I redrove the route and my odometer said it was 1.9 miles. Time wise, I mean, few minutes, maybe.
and then when he was apprehended, what was his demeanor like?
Angry.
No further questions at the time, Your Honor.
Cross. All right, Mr. Adams.
Officer Floyd, good morning, sir.
Good morning.
Officer, you are, if I heard correctly, excuse me, you're currently an officer with the Atlanta Police Department, is that right?
Yes, sir.
You were so employed back in May of 2016, true?
Yes.
You are currently you work at a training academy. Did I hear that correctly?
Yes, sir.
You train recruits.
Yes.
Essentially, they come in as recruits to be police officers, and you're charged with training them in terms of how to be good police officers, procedures, that sort of thing.
Yes.
You have 10 years of experience as an Atlanta Police Department officer, and so you have a good bit of knowledge to impart to these young men and women who come in to be police officers, correct?
Yes.
One of the things that you have learned as a police officer, and I presume, you're going to correct me if I'm wrong, that you impart to these young men and women who are coming to be police officers is that you teach them how to conduct investigations.
Yes.
True? You teach them, I would guess, that there's more to policing than simply, chasing suspects and that sort of thing.
Absolutely, yes.
Based on your experience and based on what you tell these young men and women, that when there is a crime, that there's some investigation that goes on in addition to simply arresting a suspect, right?
Yes.
Because at some point, you know that if someone is charged with a crime, they may very well, and they being the person who's charged, may show up in a courtroom somewhere to answer those charges, right?
Yes.
You also know that either you as a police officer or any of these young men and women that you're training as police officers may have to show up in court and testify about the evidence that links that person to the crime that they're charged with, correct?
Yes.
All right. You were involved with this incident that occurred on May 11th of 2016. You weren't the only officer, but you were intimately involved with that case, right?
Yes.
I heard you mention an Officer Baker, who was one of the other officers involved in at least the chase part of the investigation, right?
Yes.
He is the person who caught up to this young man. I think his name is Christian Eppinger. That's what you remember, right?
Yes.
And you were also involved in the arrest and taking into custody of this young man.
Yes.
He was, Christian Eppinger, the only person arrested for the crime that was reported on that day, right?
Yes.
I heard you say a little earlier that the only person that you were aware of involved in the commission of this crime was the person arrested, Christian Eppinger. Just one person, right?
Yes.
Okay. And in fact, when you got the bolo, when the radio traffic came out, you were advised that there's this black Corolla that had been carjacked, and there was a person in the black Corolla that you were going to be looking for, right?
Yes.
Now, you did not know anything about the circumstances of that carjacking other than that somebody had been carjacked, right?
Correct.
That's a serious offense.
Yes.
You treated it as such.
Yes.
You were involved in the pursuit and the capture of that individual, right?
Yes.
And ultimately, when he was taken into custody, you were not the one who took him well, he was a juvenile, right?
Yes.
He would not have gone to Rice Street.
No.
He would have gone to YDC, the Youth Detention Center.
Yes.
You didn't take him.
No.
Before I go on, let me ask you a question. Do they take, when juveniles are arrested and they go to YDC, YDC doesn't take pictures, booking photos of those juveniles, do they?
I don't.
Yeah, speculation.
I sustain the question.
If you know, do you know?
I do not know.
Okay. You were shown, there was a picture that was put up a little earlier.
Yes.
And did you identify that picture as the person that was arrested on that day?
Yes.
Do you know when and where that picture was taken?
No.
Okay. You would not have been the person to take it, right?
No.
You would not have seen it taken.
No.
You cannot testify that it was taken at YDC or any other location. You don't know where or when. True?
No, I do not know.
Okay. When this guy was taken into custody, you don't know him. You've never seen him before.
No.
2016, you had been patrolling Zone 3 for how long?
Approximately 2.5 years.
Okay. Now, you'd never met Christian Eppinger before, right?
No.
You didn't know anything about him.
No.
You don't know anything about his affiliations.
No.
You don't know anything about his mindset, whether this guy has any sort of mental, psychological issues, anything like that, right?
No.
You certainly don't know anything about his motivation.
No.
You don't know why that young man, on his own, decided to commit a carjacking on that day, do you?
I sustain the question as a form. Human phrase, sir.
Okay. you don't, because you don't know Christian Eppinger, you're not in his mind, you don't know why he committed that carjacking on that day, do you?
No.
Right. You certainly don't have any evidence or any personal knowledge that you can provide to this jury to indicate, to tell them that he committed that carjacking because he was involved in some sort of racketeering conspiracy. You don't know that.
Your Honor, improper question.
What is the
I stand the question.
Can I inquire as to what is improper about the question, Your Honor?
Rephrase it, sir. Rephrase it.
All right.
Compound to begin with, so, but it will draw other objections.
All right. Let me break it down. All right. You can't tell this jury that Christian Eppinger was involved in some conspiracy on that day. You can't.
Objection, Your Honor. The judge will give the law. This court.
I stand the question.
All right. Did Christian Eppinger say anything to you when he was taken into custody?
No.
All right. Going back to your training, your experience as a uniform officer, and you've conducted dozens, hundreds of investigations, I presume.
Yes.
You know what to look for when you arrest someone and you investigate the crime that they've committed, right?
Yes.
You know, and you train now, but APD also trained you on making notations in your police report about everything you know about the commission of a crime, right?
Yes.
And so in this case, when Christian Eppinger was arrested for carjacking that woman by himself, you would have known whether to note that if there was anything else involved in carjacking, whether there was a conspiracy going on, whether it was a gang crime, you would have made notice of that, right?
Yes.
Okay. You wrote a report.
Yes.
Everything you knew about the case, you put in the report back in 2016.
Yes.
You did not put anything in your report that this case was a gang-related carjacking, right?
Right.
You did not put anything in your report that this case was a RICO-inspired carjacking, correct?
Correct.
Because you had no evidence to suggest that was the case.
Correct.
That was 2016, right?
Yes.
We're in 2024.
Yes.
In the 8 years, am I doing math correctly? 16, 4. In the 8 years since then, you still have no evidence that you can give to this jury to indicate that that case, that carjacking was a gang-related carjacking. True?
True.
And certainly, you to this day, same question, have no information, no new evidence, nothing since 2016 that tells you that that case was a RICO-inspired carjacking, correct?
Basis.
Court will instruct improper question.
I stand the question.
You were never, after the arrest on that day, you were never called upon to come and testify in the case, were you?
No.
You did not construct, write, print any supplemental reports other than your initial report?
My initial report was a supplement to the other officer's report.
Read?
Yes.
Okay. But that's the only report that you wrote. You haven't amended that report, added anything since then?
No, the only other report that was created was for the traffic accident alone.
Okay. You know, was there a gang unit back in 2016?
I believe so, yes.
You did not have any interaction, communication, or anything like that with any gang unit in regards to this case back in 2016, did you?
No.
Now, you are aware, since you've been called in to testify about the incident that occurred back in 2016, right?
Yes.
You are aware, have you seen the indictment, the charge in the indictment?
What do you mean for?
Okay, well, let me ask a different question. You are aware that this incident that you're testifying about is part of some larger racketeering RICO?
Oh, yes.
Right, you know that, right?
Yes.
All right. You, I presume, have had discussions with the state in regards to what you know about the case from back in 2016, haven't you?
Yes.
Right. And you've not been in a position, you've not been able to tell them, hey, look, I've got information that this case was involved in some sort of RICO case. You haven't told him that.
No,
But you don't know.
no,
You don't have any evidence to indicate that, do you?
no.
But here we are, right? And I want to ask you a couple questions about your testimony today and what's happened between 16 and now.
Okay.
Christian Eppinger, the person who was taken into custody, you saw a picture of him put up on the screen a little earlier, right?
Yes.
And you remember him and how he looked from back then, correct?
Yes.
It would be true, I was gonna say fear, it would be true to say that you don't see him seated anywhere in this courtroom, right?
No, I don't think so. No.
Okay. Now, Jeffrey Williams. Do you know Jeffrey Williams?
Not until this case. No.
Okay. You see him seated over there, right, in the tan colored suit?
Yes.
All right. Do you know where Jeffrey Williams was on May 11th of 2016?
Objection, Your Honor. Not for speculation.
No.
Okay. Do you have any reason to believe, any evidence, and this is just personal knowledge, you have any personal knowledge that Jeffrey Williams was in any form or fashion involved in the May 11, 2016 crime that was committed by Christian Eppinger?
No.
One moment, please.
Yes, sir.
You were shown a map, right, a little earlier that was put up on the screen, and you're familiar with that area because that's the area that you controlled at one point, right?
Yes.
You were also familiar with the streets because those are the streets that car went down that Christian Eppinger was driving, and where he was ultimately arrested, right?
Yes.
Now, this was a carjacking, and you tell me if I'm right, that you've investigated more than one carjacking in your time as a police officer.
Yes.
Carjackings occur all over the city, don't they?
Yes.
People who commit carjacking sometimes are caught, sometimes they're not, right?
Correct.
Can be caught anywhere, driving a car in this part of the city, another part of the city. I mean, the fact that this guy was arrested at the location that he was, that's just where he happened to lead you guys on a chase and where he happened to crash and where you happened to arrest him, right?
Yes.
Nothing unique about a carjacking on Amal Drive versus a carjacking on, I don't know, Roswell Road,
Objection,
right?
Your Honor.
I stand the question.
All right. Did I hear you correctly that when this guy, Christian Eppinger, was arrested, he was wearing, I heard you say khaki pants, is that right?
Yes.
All right. You remember him wearing any bandanas or anything like that?
No.
All right, may I have one moment, please?
Yes, Your Master.
Just thanks, that's all I have. Thank you, officer.
All right, any further examination?
Yes, Your Honor.
All right, Mr. Matthews.
Officer Floyd, good morning, sir.
Good morning.
Just have a few questions for you. You don't have any evidence that you can present to the jury that any of these defendants that are seated in this courtroom had anything to do with this May 11th, 2016 incident, correct?
Nope.
Now, with respect to your being a trainer, can you tell this jury when you are at the academy and you're training these young recruits, do you go over with them any information concerning gang activity?
I do not. We call someone from our gang unit to come out and teach a very basic introduction to the new recruits.
So the new recruits do in fact have a basic level training of how to identify gang members, gang activity, so forth and so on, correct?
Yes.
Before they step foot on the street, correct?
Yes.
And that's been going on for some period of time in the APD, correct?
Yes.
Can you tell this jury, to the best of your knowledge, how long have the recruits been receiving that gang training to the extent that a gang person comes in and trains them?
I'm sorry, how long have we been teaching it as a department?
Yes, to your recruits.
I can only speak on since I've been hired, and we've been doing it since I've been hired. So in 10 years, we've been doing it at least.
So for at least 10 years, all of the officers that step foot into a police car and get on a beat, they have some training on how to identify gang members, correct?
Mm-hmm.
They have some training on how to identify gang activity, correct?
Yes.
And that's information that they would have at the very beginning on their first day in training, correct? On the first day on the street, correct?
Yes, it's a very basic overview. It's not super in-depth.
Right, but enough to identify gang members, correct?
Yes.
And enough to identify gang activity, correct?
Yes.
Thank you, sir.
Any further examination? Any redirect?
Just briefly, Your Honor. Officer Floyd, as a patrol officer, were you trained to investigate RICO investigation?
Not for RICO, no.
Okay. And have you had any specialized training on any RICO related subjects at the time of arresting Mr. Evans?
No.
Any gang training have you had
Outside of that basic,
Overruled.
at the time of Mr. Evans' arrest?
outside of the basic recruit class for it, no.
Was Christian Epinger the person you caught in Miss Terralia Hill's stolen vehicle?
Yes.
Publishing 18B, Victor. Officer Floyd,
Yes.
it states 18B, a picture of Christian Epinger.
Yes, it is.
Now, when you became involved, did you get word of an accomplice of the vehicle at all?
No.
Did you personally get word on any accomplices?
No.
Were you working only in your capacity as a patrol officer when you arrested Mr. Evans?
Yes.
And did you carry out all your duties as a patrol officer on that day?
Yes.
You said basic gang training. What did you mean by just a very basic gang training? What did you mean by that?
I'm not sure exactly what all is covered in the course. Like I said, I don't teach it. But they just, to my knowledge, it's just a very basic introduction to gang activity.
And finally, were you working as a gang investigator when you arrested Mr. Evans?
No.
No further questions, Your Honor.
Anything further, Mr. Adams?
Yes, sir.
Mr. Matthews, you get your turn. Okay.
Officer Floyd, bear with me a second, because I think there was one or two questions that was asked. I just didn't hear the question, so I'm asking you to repeat something that you already said. But I did hear you say that at the time, you were not working as a, quote, gang investigator.
Correct.
All right. But I mean, it is true that at that time, there was a gang unit that if you saw something that made you think there was some gang connection in this case, you could have contacted them. True?
Yes.
Objection, Your Honor.
Oh, the objection.
And you did not contact the gang unit because in your analysis of that matter, you didn't see anything that suggested to you, a trained police officer, that there was any gang involvement in this case, right?
Correct.
I think there was a question asked of you about RICO training. You've not had any RICO training, I presume.
No.
All right, but you know what it is, though, right?
Yes.
Okay. And similar to the question I asked you about the gang, I think you answered this before, but you didn't see anything at that time that made you think this was anything other than just a carjacking committed by Christian Eppinger by himself.
Correct.
Okay, thank you.
All right, Mr. Matthews, go ahead, sir. Okay, all right. Anybody else? Any other redirect, sir?
No redirect.
All right. May we excuse 2013, when I understand from councils that you had an extra job working at Neiman Marcus,
Yes, sir.
and that you had 4 interactions with Mr. Williams,
Yes.
reportedly, and that you summarized that in a written statement, gave that to the defense, and this is consistent with the preparation that around December of 2023 that you had with the representatives from the state of Georgia. Is that correct?
Yes, Your Honor.
Okay. If you could tell the court a little bit about those particular 4 interactions, as much as you can recall, consistent with what you told them,
Yes, sir.
them being the state. Okay.
Yes. So while in the throes of the investigation into what happened down at 126 Cleveland Avenue and 2745 O'Haitville, I worked this extra job at Neiman Marcus at that time, I guess, for since 2004. So I'm there every Friday. I had never seen Jeffrey Williams, to my knowledge, even come in the store. But a week, maybe 2 into my investigation, Jeffrey Williams comes in to Neiman Marcus, and I'm sitting on a stool. I've got on my City of Atlanta police uniform. I'm not a detective, in my detective attire. And I waved him over. I said, come here, let me holler at you right quick. I told him directly right then and there, this joker named Bean, he's put you in this car that went off that cliff over there on Old Haitville, right into 126 Cleveland. I said, I'm telling you that because you're gonna get the discovery anyway from somebody else in the car. You know what I mean? You're gonna learn this happened. I'm telling you, I'm giving you 100%. This guy's putting you in the car. But what I did tell him was, the same guy, Bean, was identifying which gun he had during this commission of this robbery that turned into a police shooting. And I said, I'm not gonna lock you up based on what Bean said alone. If there's DNA, because Touch DNA was really moving in 2013. If Touch DNA comes back with male profiles on him, I just said to him, boom. Are you gonna make me come get you with a warrant, or will you give me a voluntary sample to eliminate you from this case? And I assured, I said, I'm not gonna lock you up with what Bean says alone. I need something else, that's how I get down. So Mr. Williams was like, I don't even know what you're talking about. He was adamant. He seemed very nervous because, you know, I'm a uniform officer just coming up with this stuff in him, right, in some store he's coming to on his free time. A few weeks go by, maybe 3, because I got the DNA fast-tracked through the GBI. I learned from the analysts there were too many male contributors to the gun that Bean identified Jeffrey Williams being in possession of. They wouldn't be able to put a usable sample up into CODIS. So a few weeks later, Mr. Williams comes back in the store again. I don't know what day, but it was weeks after the first encounter. I said, yo, come here, let me holler at you. I said, guess what? I can't use that gun against you as corroborative evidence or evidence against you based off what Bean said. So I tell you what, I'm done with it. I did some research on you independently because I didn't know you were about to blow up. I said, and excuse my language, I said, go make $1 million, stay the fuck off Plea. That's what I said to him. Maybe a month or 2 goes by after that. I'm at Neiman Marcus again. Now Mr. Williams comes in the store with a couple of people, a small, I guess you would call entourage, just maybe some associates. But in particular, he introduces me to his sister, Dolly. Didn't know this sister at all. She gives me her phone number. They asked me, would I be their road security? collectively between Mr. Williams and his sister. I was like, that's not what I did. Case, I did take her number because Dolly gave me her number. I put it in my city issue phone, Dolly, Young Thug's sister, or something to that degree. And that was the end of it. The fourth encounter may have been months on down the road, might have been 6 to 8 weeks. Mr. Williams comes in. We don't have any verbal contact in the fourth encounter. My stool that I sit on is right at the downstairs escalator going in menswear. Mr. Williams is with DK, real name Walter Murphy. And from about 25 feet away from me, he's pointing to Walter Murphy's like right pocket to his pants. And there's a long stack of money in Walter Murphy's pockets as they go down the escalator. He points at it and he doesn't say anything to me. He just makes reference to it, make sure I see it. I don't know what that meant, you know, but that was that. So those were the encounters.
Okay. All right. The objectives of the conspiracy included but were not limited to preserving, protecting, and enhancing the reputation, power, territory of the enterprise through acts of racketeering activity, including murder, assault, and threats of violence.
You may have heard about Young Thug's upcoming criminal.
You good?
It's a show, Judge.
Oh, it is? Okay, well, I ain't Judge Glamble, and I don't play, so stop showing out. All right, let's see. Mr. Jimenez, you want to tell your client to get a grip on himself?
No.
I'm gonna get right to the point. I think the case should be thrown out due to the fact that I'm insane. Build a pocket knife, build a pocket knife, build a pocket knife. My mommy say that I got that. We'll be coming around the mountain when we come. We'll be coming around the mountain when we come. We'll be coming around the mountain. We'll be good around the mountain. We'll be good around the mountain. Heart.
Mr. Payne, take a seat. You good?
Okay, Sergeant Ingram, go ahead and summon our jurors first, please. Okay, ladies and gentlemen, please be seated. All right, thank you, Sergeant Ingram. All right, ladies and gentlemen of the jury, good morning. Oh, that sounds good. That sounds good. Everybody had a rested weekend. So you sound good. Okay, listen, ladies and gentlemen, there's something I need to take up with you. So don't get too comfortable, all right? Ladies and gentlemen, we've had a medical issue come up with one of our participants, so I'm going to have to recess for today, okay? And these things happen. So we'll come back tomorrow morning at 9. I'd like you to be here for 9 o'clock for an anticipated 9:30 start time, and we'll just see how things go at that point in time. And we'll take the week as it comes. So as is my custom, just remember you add knowledge and admonitions. Remember the things that I have told you that make this, that you're continuing to do, will make this a fair trial, a just trial, and a lawful trial as to all sides. So, do you have any other questions of me at this time? Okay, we're still on the same schedule. I'll give you a couple of days and we'll see where tomorrow I should say leads us, and then we'll make plans accordingly. So with that, ladies and gentlemen, unless you have any other questions of me or any other inquiry of me, I'll see you tomorrow morning for 9 o'clock, and then we'll see if we can get started, okay?
Yes, sir.
Okay, all right. All rise for our jury. Gentlemen, please be seated. Our jury has left us at this point. All right, counsels. Okay, anything else from me at this point in time? We are going to start tomorrow morning for 9 o'clock. Depending upon the information that we get, we all will gather regardless, and then we'll see what happens once the court gets more data points. All right. So, anything else from me at this point in time?
That one is dead.
Anything else from anybody else? Okay. All right. Unless there is anything else, counsels, we'll be in recess till tomorrow morning. And
September 17, 2000.
You were saying to the court that you have a belief that there is another statement out there. There's not.
How can you say that?
Because it hasn't been brought up. If it gets brought up, then we'll correct it at that point in time. But right now, I'm going to direct you not to inquire that line. You don't have a basis to do so.
Not true.
Well, go ahead and make a statement and see what happens.
Your Honor, listen.
Go ahead and make the statement in contravention to what I've just told you. And I'm telling you that you will have some problems in front of me.
I'm trying to articulate to you.
You have told me everything at this point. You have told me that there's got to be a statement. Now, if you find the statement, I will, one, apologize to you. Two, I will take corrective action. That's probably not going to be nice to anybody. But at this point, there's nothing for me to do other than, if you don't have a good faith basis to do it, you can't ask the question.
Honor, listen. There is a recording between Detective Quinn and Adrian Bean where Adrian Bean says, I lied to your...
But we don't know what he lied about.
He says he lied about who he's talking about, the car.
But we still don't know whether or not he had a conversation with Detective Lewis.
And I made it clear, it's 10 years ago.
But you said you had, in your conversation with Detective Lewis, that's what you proffer.
I said, or any other detective or law enforcement, read the transcript. I made it clear. I don't know. He doesn't remember names. He says it was Detective Quinn. Also on the recording, on Sunday, January 22, 2023, Mr. Bean is the one who said this happened in the hospital. Your Honor, I'm the one complaining about I don't have the statement. I've been asking for it. This is Brady. Clearly there was a statement made.
We don't, but we don't know if there's a statement. You're supposing there's a statement, okay? And there may be. And you know what I said? And you know what I said earlier? I said if there is Brady that's not disclosed, then that particular individual is going to have some problems with me. I told you that already. Or I have a lot of different remedies I can execute at that point in time.
There has to be, that's why I gave you.
But you can't intimate or otherwise cross over the line when you don't have the statement to back it up.
Judge, I've been robbed of the statement.
But we don't know where the statement is. If we find the statement or it comes up or in cross-examination, Quinn brings up and says, hey, have a statement right here in my massive file. And if he does, then of course I will revisit this particular subject again.
I'm saying it's been deleted. It's been destroyed.
We don't know. You don't know. We don't know what happened. We don't know what happened. We had the same issue that happened earlier in this trial about a statement. We don't know whether or not it was the hack or whether or not it's intentional. Now you can make whatever hay you want out of it. I mean, and the jury can decide for what they want to give it. But you cannot ask the question in its current form. You just can't.
Your Honor, I'm not asking any questions, but you have to understand the following, please. 6 days later, Detective Quinn and Adrian Bean are on recording where Adrian Bean tells Detective Quinn, I lied.
About what?
I lied.
About what?
Who was driving the car. He gets cut off. Detective Quinn says, yeah, tell me about it. Where's that statement? That's what I've been asking for.
But that doesn't still give you the latitude at this point in time to ask that question. Now, I told you, if we find out from Quinn, and I'm telling the state that if I find out that the statement exists, there's going to be a lot of unhappy people.
Well, what if you don't find out it exists? I still am entitled to it. That's my whole point.
Okay, but here's the thing. You've asked me for it. I've asked them. If it comes up later, or I find out it's sitting someplace that was in possession of the state, pursuant to case law and definition, then we'll have some problems.
I understand, but you're asking where you have to find the statement for. I'm telling you the statement was made.
It doesn't work that way, Mr. Steele. I'm sorry.
It does work that way.
No, it does not.
Yes, it does.
No, it doesn't. And you haven't presented any case law to tell me how to do that. And I'm telling you, as the judge presiding over this case, if you do that, it's misconduct.
I'm not doing anything.
I'm telling you right now.
I don't know what you're telling me.
I am telling you, you have no good faith basis at this point in time to ask that question right now, or to intimate that.
I didn't ask any question. You are listening to District Attorney Love. I'm ready to cross-examine. I'm going to play the recording you just heard. This gentleman tells me on recording that he was at the hospital speaking with law enforcement. I want that. It is backed up because on recording, 6 days after the crash into that side of the building, Your Honor, Detective Quinn and Mr. Bean are talking about the statement that Mr. Bean made prior. I don't have it. And when the court asked me, well, you got to find it, or if I find it, it wasn't given over.
Then we'll have some problems. Then we'll have some issues.
I have some issues now. I've been begging for it. The state's supposed to give this.
Let me ask, hold on, Mr. Okay, stop for a second. Ms. Love, have you inquired of Detective Quinn where this other statement may be?
Judge, that's just it. Mr. Steele is literally manufacturing evidence. There is no other statement. I have asked whether or not there was a statement. I asked Tracy Lewis at the hospital. Let me be real clear, because he keeps conflating stuff. Adrian Bean never told Detective Quinn that he made a statement at the hospital. I have his transcript.
Okay, but we don't know where he made the statement, and also he's lied. So we don't know what he lied about either.
Your Honor, to be very clear, there's no statement. I have asked Detective Lewis. They can ask Detective Lewis. She never talked to him. Okay. Detective Quinn, who is the only person, it's not just police, the only person Adrian Bean asserts to Brian Steele in this recording that he gave us, this 10-minute recording, he said, I spoke to Detective Quinn. It's obvious that he didn't speak to Detective Quinn at the hospital, because the first time he met Detective Quinn was September 17th when he pulls him in for the interview. Literally, Mr. Steele is manufacturing something. So when the court is even asking me, okay, do you know where this statement is? Assuming that there's not a statement. There is no statement. There's no evidence. That's the problem with Mr. Steele asking questions the way that he asked them. He is assuming facts that are not in evidence. And he is usurping the jury's province and their ability to discern and weigh evidence because he is injecting assertions into his questions about things that don't exist. Similarly, he says, do you recall explaining that you made calls from the Fulton County Jail that you knew were being recorded to support your lie to the police that Jeffrey was involved on September 11, 2013? That's what he asked the witness. You heard the interview. He doesn't say that anywhere in that interview. This is the kind of manufactured evidence Mr. Steele keeps putting in front of the jury. He never said that during the interview, yet that's the question. That's the question Mr. Steele asked Adrian Bean on the stand. Nothing like that ever happened. And his conversation, during his cross-examination of Adrian Bean, the cross-examination is replete with examples just like that. There is no statement. He can't sit there and say there has to be a statement and then ask the question as if there is one, because that's improperly asserting to the jury something that isn't factual. There's no evidence of it. So to answer the court's question, of course we have asked who spoke to whom. Did Tracy Lewis, did you speak to Adrian Bean? Tracy Lewis, I talked to Walter Murphy, and I put it in my report. I made a report of that. Calhoun, did you talk to Adrian Bean? I talked to Frederick Prothro. Here's my recording of that. Detective Quinn, and then this idea of destruction of evidence, that is the fallacy that is getting thrown around. That's the problem with asserting facts not in evidence. That's the problem with them being allowed to ask those kind of questions. Do you destroy evidence? Nobody has said anyone destroyed any evidence. Eduardo Navarro Flores said he heard that Detective Quinn had erased the interview. Well, then why all throughout Detective Quinn's report does he refer to the lie that Eduardo told in the...
Play something, I don't remember though.
And did you hear you explain that the case involving Mr. Dotson was totally dismissed?
I don't recall, sir.
And for you, the case involving the armed robbery or attempted armed robbery or the aggravated assault on Mr. Dotson was dismissed. You pled guilty under Alford to aggravated assault on the 3 police officers and fleeing and attempting to elude. True?
I don't remember.
And then I asked you, was Jeffrey Williams, performer known as Young Thug, involved in any way, directly or indirectly, with the events involving Mr. Dotson on September 11, 2013? And you said he was not involved in any way. Did you hear that?
I don't recall, sir.
And then you explained, you just heard that you explained that you qualified it as the detectives and police. And I asked you the authorities, the police, the prosecutors, I just made it broad, that they forced Jeffrey Williams into it. Did you hear you say that?
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all now. I ain't gonna tell you no lie.
Yes, you may. You're gonna take a break soon. Hang in there.
You need a moment?
Keep the ball rolling.
Okay. Mr. Coco, if you could just show me where you stopped again, remind me. 349.97, Your Honor, play further right from there. All right.
When your wife is speaking,
hearing that?
Yes, sir.
And can you tell us what that meant?
That it was really telling us to like, hey, put Doug in on this right here. You know what I mean? If you don't put him on that, you could be facing a lot of time and all type of shit like that. You know what I mean?
And who is they again? I know. Okay. And there are other prosecutors and police.
It was just really just him. Like, it was just really him I had made together.
Okay.
And there was a few more officers that were just around, you know what I'm saying? We was in the hospital. I was in the hospital, you know what I mean? When shit happened. So it was like they pushed in and I was like, I'm the victim. I don't know what's going on. So
yeah, as far as
accident.
Right.
And that stopped at 4:39:97. Did you hear me ask you about the jail recording that's now marked as Mr. Williams number 205 around the 11-minute mark, me playing it for you earlier in Mr. Investigator Martin's car, and then ask you about it, about they gave us a story to tell. Did you hear that?
I don't remember.
And your response was that you were going to be in a lot of trouble if the police wanted Jeffrey Williams in it. And that conversation occurred on September 11, 2013 at the hospital.
When the witness does not recall, the jury has the recording, they can hear it, and I would object to Mr. Steele's narrated version.
I stand the question. He can't remember it, so. Mr. Kokomo, where did we stop? It's 1:39:97. If you could continue.
In your car, they say we crashed. Yeah, careened over a police car and into the side of the building. Right. You were driving the car.
I was the driver. And he said, trying to say he was driving.
Yeah.
You know what I mean? So
the police wanted you to say you.
Yeah, but
that's what you did.
Also, but not in the vehicle with him.
Did he have anything to do with it?
Yeah, and then
It stopped at 5:03:30, Your Honor. Do you remember saying that? Do you remember hearing just now that it was Detective Quinn? Did you hear that?
I hear you playing an arm call, sir.
Well, I was meeting with you in January
But I must
of
object to Mr.
2023.
Steele testifying.
I sustain the objection. We were meeting on January 22, 2023 at the Kroger. You remember that?
I don't remember, sir.
And January 22, 2023 is approximately 9 years and 4 months from September 11, 2013. Is that an accurate calendar?
No, sir.
Do you remember any other detectives' names or police officers' names or prosecutors' names, anything from this event in September 2013, besides Detective Quinn?
No, sir.
Objection is to the form. He does not even say that he recalls Detective Quinn.
It's on the recording.
He does.
question, Mr. Steele. All right. And then did you hear you saying again, Jeffrey Williams had nothing, or whatever you call him, young thug, had nothing to do with this horrible incident? Did you hear that?
I heard it, but I still don't recall, sir.
All right. Let's continue, Mr. Kokomo. It's at 5:03:30, Your Honor. Yes, sir.
I'm 42 years old, man. No other man tell me what to do. And no other man make no other man tell no other man what they need. Everybody wrong.
So why did you tell the police, because I'm reporting that Jeffrey Williams was involved did this armed robbery because the police told you to say that so you get out of trouble. Is that the reason? Yeah. Okay. Now you're also on another jail call, the one I'm going to send you. That's the one I want to do. I'm going to send it to you. But when you say the reason that you would have a jail call with your wife and a friend of yours or whoever, you can tell us. That's because the same reason. It's just the police gave you something, the story tell you, it's going to say it to everybody. Okay. All right. We're going to shut the recording. It's what you told us the truth because it's all I've ever asked you for. That's it. All right. Did anyone promise you anything, threaten you? Nobody promised me that. And Jimmy and I have been straight. Investigator Martin and I have been straight with you all the way. Is that true? Right. And Investigator Charles Mills. I've been working hard trying to catch up with you. I work hard too. I'm not just not working 2 jobs, so you know, I'm a world worker day and night. So we appreciate you. Certified flagger, certified supervisor, you know what I mean? And I was doing dishwasher at night, so you know what I mean? I'm real whoop to be going in 23 to be going through anything that got something to do with quarter law or anything like that. I'm real whoop for that. And just if it's going to come up, you did go to prison for 3 years, got 10 to do 3. Right. But I know what you explained, but just explain again what truly happened. I know you took a break. I don't even know.
It's at 6:46:52. Stop. 62. Stop. Sir, did you hear? I'm recording Mr. Williams, number 197. Discussion, you explaining and agreeing that you included Jeffrey Williams in your crime to get out of trouble.
I don't remember, sir.
Woody, or Lil Woody, was very uncooperative from the beginning. Before he was even called to the stand on Friday, June 7th, his attorney
Okay, and so, and Detective Dennis will have, I'm sure we qualified him as an expert already.
Yeah.
Yes, so, all right, do you have any videos or phone jail calls or any photos that you are going to introduce through him? Or ask him to testify to as to?
So because we're separating his testimony regarding this incident, the Lil Wayne incident, from his testimony, because he has direct knowledge of and expertise regarding other acts as well. Our intention is to present what he saw and what he found in the Lil Wayne bus shooting incident for this period of time that he will be on the stand. And so
asked Mr. White if anyone pulled out a gun on people in the Silver Pontiac, correct?
I believe he did.
Okay. And D'Angelo White's response was, we had guns and shit, correct?
Yes, he did say that, and it was more to that as well.
We had guns and shit.
Yes, he stated that.
Okay. We being plural, correct? Correct?
Are you insulting my intelligence by asking if we means plural? I think you are, though.
Okay.
I think you are.
All right, well,
Sir, don't do that. Don't do that.
We're not vetting the witness or intelligence, and if he has a question, Your Honor, I would ask you to ask.
All right, sir, let's be respectful to our witness,
I'm being
okay?
very respectful, Judge, and I always will.
I doubt it.
Guns being plural.
I'm going to object to the last response by the witness as commentary.
Let's sustain the objection. All right, Mr. Sharp, please, this is focused on the questions. No, just focus on the questions. And Detective, please just answer the questions.
My apologies to the court, sir.
All right, sir. All right.
Guns being plural as well, correct?
He stated that's what he said.
Objection, asking.
I stand the objection.
I haven't asked it. Remember last week when you were testifying and we talked about, or Ms. Love was asking you questions and you referred to people in the blue car as practically children?
No, I don't recall that being the exact thing I said.
Okay. Well, which we heard, we and guns. As an investigator, did anyone seek further clarification from D'Angelo White when he say we, who in that blue car possessed guns? Did anyone ask?
Ask who had the guns?
Yes.
That's not on the recorded statement, sir.
So did anyone ask? I understand it's not in the recorded statement.
Mhm.
Did anyone ask who in the blue car had the guns?
I don't believe the jury heard that, so it's not on the statement.
So that's a no.
We did not ask him that.
Okay. Did anyone ask how many guns were in that blue car?
Sir, that's not on it. Well, that goes to part of we did not further inquire about the guns that he stated we had. So every question regarding the guns and who and we, and as we all know, we heard the recording. It's not on the recording, therefore we didn't ask him that.
Did anyone ask what types of guns were in the blue car?
Objection, asking, answer.
I never asked that.
I will rule the objection. You can answer that.
Sir, no further inquiry was asked about the guns that they had in the, that Mr. D'Angelo White said they had in the vehicle.
Okay, and as lead investigator in this case, and I understand that you weren't there on that night, you're aware that guns were not located in the car.
The night of the incident?
Right.
Yes, I am aware of that.
The car relocated itself to an address at 1987 Fremont Avenue, correct?
It did.
Okay, did anyone search the 1987 Fremont Avenue address for any guns that may have been discarded there before the police arrived?
Objection, assumes facts not in evidence.
Stated.
Stipulation.
I stand the objection.
Was 1987 Fremont Avenue searched that night?
Sir, as you just stated, I was not there on the night that the incident occurred.
So you don't know the answer to that question?
I personally did not execute a search warrant on Fremont Street.
Okay. Now, you've been able to review, in court, in fact, we reviewed the surveillance from the Citgo from that night, correct?
Correct.
Would you agree that we can see the blue car pulling into the gas station, following behind the silver Pontiac?
Objection, as to characterization, best evidence in the video.
Okay.
I stand.
Mr. Kokomo, could you please pull up, that's fine. DS9 at 1340. And before we start playing, did you ever ask D'Angelo White or any of these other individuals that you say you interviewed, why they went to the gas station?
I don't recall at this moment.
Okay. And this gas station, this Citgo, it's a place that sells gas, correct?
Among other things.
Okay, and it, well, among other things, it has a store where you can buy chips and
Like Old Food Mart, yes, sir.
headache powder and different things like that, correct?
It's a food mart.
Okay. All right, Mr. Kokomo, if you could publish DS9 at 1340. Okay, Investigator Gaither, did we just see the two cars pull into the Citgo? The two cars, meaning the silver Pontiac and then the blue car?
Yes,
Okay, and the silver Pontiac is the one that OG Bentley and Rodney Allison are going to exit, correct?
yes,
And the blue car is the one with D'Angelo White, Terrion Moody, Christian James, Cornelius Davis, and Dexter Montgomery, correct?
the victim's correct.
Okay, you keep saying victims, and that's cool, but,
Objection, Your Honor, to, commentary by Mr.
I stand the objection.
and that's the car that D'Angelo White said that there were guns, plural, in, correct?
Yes, in their vehicle, yes.
Okay. So 2135, they're there. Mr. Kokomo, if you could play.
Bless you.
Okay, Mr. Kokomo, could you fast forward to 2200? Okay, and for the record, we're going from 2135, I believe it was, to 2205.
Sir, is there?
Excuse me,
I'm sorry.
I'm sorry. 1340 to 2205.
Sir, is there any particular point you want me to
Well,
start
I'm
watching,
gonna
or am I
try to
looking for something in particular?
I'm gonna try to fast forward it. I'm
Okay.
gonna try to save some time, because I don't wanna watch the whole video again,
Okay,
but we'll see where this goes.
okay.
Your Honor, I would ask Mr. Sharp to just clarify, he has 4 separate videos on the screen for the record. So to clarify which, one of these images he would like the witness to focus on.
I'm gonna ask the witness to focus at 2205 on the top left. If you could get it to 2200.
All right, let's know when you get there.
Okay, and I have 2144, the blue car is leaving, correct?
Yes,
All right, and so you would agree the blue car, and we can go back and watch if you want, but would you agree that blue car was present for about 8 minutes?
I'm not sure the exact timeline.
All right, I guess we're gonna have to do it this way. 1340, please. Okay, please note on the top left, Investigator Gaither, it says 2135, 52.
Okay.
And for the record, both cars are present now, correct?
Yes.
And Investigator Gaither, what I'm gonna ask you to watch over the next 8 minutes or 9 minutes is whether anyone in the blue car either pumps gas or goes into the store to buy any items.
Objection, compound speculation. What they do is speculation.
What they do is speculation, it's
Oh,
on
I'm gonna overrule the objection, so.
I can tell you no one pumped gas or went into the store.
Okay, thank you. So the state.
Yeah, no commentary. Let's just move on, okay? Thank you.
Ms. Kokomo, thank you. Thank you. So while they were there, no one got out to pump gas. No one bought Sicko gas.
Sir, I just answered that.
And no one went into the store to buy any items.
That's an answer. Come on, let's move on, Mr. Sharp.
Ms. Kokomo, could you go to 2205? Or my time?
Hey guys, I just left from Cobb County. I'm here. Hopefully we start back soon.
And the blue car goes down Jonesboro Road, correct?
Yes, sir.
All right, pause it, pause it. Pause it, Mr. Kokomo. Okay, as it's, the blue car is left, we see OG Bentley. Is he running to his car to give chase?
Here in this frame?
Yes.
No, he's right here. If we're looking at the bottom frame as well, he's right here inside the store.
So, kind of lumbering or walking slowly into the store.
The way I understand my constitutional obligations pursuant to the 6th and 14th Amendments of the United States Constitution, the corresponding sections of the Georgia Constitution, I'm required to make a full and complete statement to the court.
Electronically, the communications between the state and the various attorneys whose clients have pled. However, I think for me, it's just going to be easier if you can print them out and give me a hard copy, and I'll give you until, if you can just have those to me by Monday morning, that'll be fine. But I just think it's just gonna be easier for me that way. And just, and I didn't go through all of them. I started going through them, but make sure that if there were a couple of emails that, and it was like well into the string. So I'm sure if I got to the original email, the attachment would be there, but just make sure I've got the relevant attachment too. Okay, so I'll just deal with all of that after you give it to me in hard copy form on Monday. All right. Did y'all get an opportunity to try to come to any sort of an agreement, if there is any, on those items 451Y through, I think it was 455 or so, and then 460Y?
Your Honor, no, it was not an intentional disobeying of the court's instruction. What I was doing was the state's position is slightly different than it was with an argument for why.
Okay.
And whenever the court allows, I'll address it. If he wants me to start now, I'll just start
All
now.
right, so did you give a redacted copy to the defense, or you just think whatever your new position is might change everything?
It will change
Okay.
everything.
All right.
And I did also, the thing that I'd asked Ms. Winfrey for that she so kindly provided was what exactly the objections were to the exhibit so that I could address them in turn. What I recall specifically, I believe that it was Mr. Stillwell who made the initial objection that.
Hang on a second. Can y'all try to be a little more quiet over there so I can hear? I don't know who it is, but, oh, that actually reminds me too, before we get into that. Just a reminder to everybody that there's not supposed to be any eating in court, and that the defendants are not supposed to be on laptops. Okay, that has not changed since I took over this case. All right, go ahead.
My recollection is that Mr. Stillwell's attorney is the one, Mr. Sharp, who originally specified a portion of one of the exhibits that he felt should not be allowed or presented to the jury because it contained information he thought was overly prejudicial. If I'm not speaking correctly, I'm certain he'll correct me where I'm wrong. But other than that, I was wanting to make certain I heard all of the objections so that I could speak to them. But if my because I'm going to make a proffer to the court.
Okay, it would be a lot easier, I think, part of their position had been until we know what the state's actually proposing as the redacted exhibit, it's hard to make objections. So are you ready to share that?
Yes.
Okay.
Yes, I'm ready to address
If you would
it
do
all.
that, that might help the
So, Your Honor,
court and the.
on what theory the state would be seeking to admit out-of-court statements?
That
as
was part
documented?
of what I intended to address. So
Okay,
I'll just
well,
start.
let's all get a copy of what it is we're.
They're not redacted. It's the ones we gave them. So the ones that I have previously identified,
Can I have a hard copy of them? Because that's another one of those things that if I'm having a look on the electronic, it's like embedded within several emails
Yes.
before I ever get to what I'm supposed to be looking at.
Yes, Judge. So
Thank
what,
you.
what I'm gonna do is just give to the court my, the copies that I tendered. And I'm gonna speak from my notes as to, what it is about them and why it is that I believe it.
All right, well, hang on. Laura, can you have the substitute JA come down here and grab these and make some copies for me? Please, thank you. Because I have a tendency to write on things once I get them. I'll try not to do that until I get my copies, but if you'll come around here, I can actually reach you. Thank you.
You're welcome. And what, for the record, I have given to your honor, 1AS, which was the plea agreement that had been tendered at Mr. Sledge's plea. I've also tendered 444 Yankee, which is the document we were referring to. That is an exact duplicate of that. 451 Yankee, which was
Yeah, I mean, I know what they all are. So 451, 2, 3, 4, 5, and 6 should be, yeah, and 6, and then 460.
Yes, Your Honor.
Okay.
Your Honor, would the court permit me to take my seat so that I can read it?
Yes, you may.
Thank you.
I heard that too.
Use the right lane to take exit 255 toward West Paces Ferry Road.
Testimony.
US 41.
The court and I think everybody else is aware that as we referenced State's Exhibit 1AS or 444, my particular question to him after he started talking about his truth and his ability to tell his truth was using the guidelines if a acknowledgement that you signed.
Yeah, I remember. We don't have to like belabor the point.
Okay.
He picked out several and listed the ones that he said were false, and they were 3, 4, 5, 6, 7, 8, 9, and
All of
16.
Right. With the exception of about 4. Right. And then he said that he understood none of the sentencing
At the time, yeah.
acknowledgements at the time. So, Your Honor, under 24-6-607, OCGA 24-6-607, Your Honor. Impeachment by contradiction.
Well, that's not impeachment by contradiction.
Well,
that's who can impeach.
So as I'm reading, and I know that it's who can impeach, who may impeach,
It's a different one. 621 is impeachment by contradiction. A witness may be impeached by disproving the facts testified to by the witness.
Right. The reason that I referenced that only is because it was in the book that I'm reading from. There's a section that I'm looking at. So particularly a witness may be impeached by contradiction in several ways. Close questioning to elicit concessions of errors in testimony during direct, questioning a witness about the substance or implications of evidence already produced during the case to suggest contradictions, confronting the witness with his or her own contradictory prior statements, or calling another witness, or introducing other extrinsic contradicting evidence. Generally speaking, the admission of extrinsic evidence for contradiction impeachment is restricted to non-collateral matters, so that evidence that impeaches by contradiction and is not collateral can be both substantively admissible as well as admissible for its impeachment value. And that is coming from Baylor, Behler versus Hanlon, Hanlon, 199 FRD 553. And then the parenthetical is surveying numerous commentaries. Judge, with respect to Mr. Sledge, the reason that I began my statements to the court about what it is that he said, and will then go into what his lawyer said. When I asked his lawyer about plea negotiations on the heels of Mr. Sledge, not just saying he was told he could get up and tell his truth, but on cross-examination, he was asked repeatedly through the use of allowable leading questions. These weren't your words. You didn't write it. You didn't understand it. You didn't know what you were signing. You felt like you could come in here and tell your truth. You signed it regardless. I'm not directly quoting, but essentially, even though it wasn't true, you signed it. And things of that nature were elicited during cross. You signed it because you wanted to get out to go see your sick mom, things like that. You were in Fulton County Blues. That's the only reason you signed it. These aren't your words. These are only the state's words. So all of those questions were intended to attack the credibility of the veracity of the statement that Mr. Sledge made on December 28, 2022, when he signed the plea agreement. And Mr. Sledge acquiesced to all of those attacks, essentially asserting through his sort of obfuscations and running back and pulling back my truth. I don't understand. I don't recall. I don't remember saying that. That isn't true. And his pointing out at the state's request the factual acknowledgments that he now asserts were inaccurate or not completely true. He allowed himself and the cross-examining attorney to, in front of the jury, completely question or to undermine the credibility of the statement that he made and his own credibility at the time that he made the statement. So as the court has already instructed the jury that the inconsistent statements of a witness are also substantive evidence that may be considered against other persons on trial. Can the court hear me okay?
Yeah.
All right. So as the court has already instructed the jury that it can now consider that statement as substantive evidence. What we've seen is an attempt by the defense to destroy the jury's faith in the credibility or veracity of that statement made by Mr. Sledge on December 28, 2022. So when questions were posed to his attorney regarding Mr. Sledge's understanding of those acknowledgments and sentencing agreements, on the one hand, after he made clear that though he's a friend of both sides, he's a defense attorney through and through, Mr. Wright, though he did clear it up, he seemed to, his answers on cross-examination, there were some things that were not true. There were some things we didn't agree to. He was kind of vague with it, and it took belaboring point by point for him to even acknowledge, hey, number 3, number 8, these are the only 2 anybody took issue with. So at this point, Your Honor, I believe that the iterations that were presented to Mr. Wright and to his client per his words are important because it is further evidence that corroborates Mr. Sledge's understanding of and his understanding of the final plea agreement that is 1AS and 444Y, and his ability to effectively engage in and have an active hand in that final document that he signed on December 28, 2022. It points not only, it demonstrates not only the inconsistencies of Mr. Sledge's testimony, but his outright perjury regarding his purported lack of ability to have any say in what that final document asserted that he signed. It is illustrative of the fact that he actually did have the ability to tell the state what he felt wasn't true and what parts he wanted changed. And I think that our position is that it is relevant in showing or allowing the jury to judge the credibility of statements Mr. Sledge has made on the stand versus the credibility of the statement that he made on December 28, 2022. The statute that I cited earlier, it substantiates our position that the representations that Mr. Sledge made under oath on December 28, 2022 were part of a long and detailed negotiation and refinement that Mr. Sledge himself took part in. As I think at this point, 24-1-104 might become relevant. That's the one I brought up earlier that didn't have any bearing on what we were talking about. But in as much as 24-1-104 speaks to the code section not limiting the right of a party to introduce before the jury evidence relevant to weight or credibility, we believe that this particular evidence allows the jury, it is pertinent evidence that they should be allowed to see, to understand fully what was put before Mr. Sledge, what he did dispute, what he did not dispute, and what he, so that they can compare it with what he finally agreed to and make a better determination about the truth of the statements he made on December 28, 2022. I think that the argument that some of the statements, the allegations made by the state, those are things that one way or another may be asserted in any event. For instance, they caught nut down bad is a statement that we know is going to come out either through the person that said it the person that relayed to law enforcement that they said it, or in his statement to police if he lies on the stand. These aren't matters that are so prejudicial that they should be kept from the jury. These iterations, if you will, the defense wanted to have us reference part of them, but pointedly objected when I attempted to have Mr. Sledge show or point out differences between a previous iteration and the final version. That previous iteration was not circled there. It's one that I have because I did not tender it as a marked exhibit. They actually objected to my calling it a previous iteration. And I think in attempting to keep from the jury, not just the previous iteration, but the number of them and the changes that were made and requested, and the changes that were not requested, as is reflected in 460Y, we're keeping rather from the jury very relevant, pertinent evidence that in no way substantially prejudices either defendant through its admission. So I believe that an instruction that these are assertions made by the state, essentially questions that they ask the witness, then defendant, are these true? I initial them if they aren't, tell me what changes need to be made, and that they are not to consider as true from this witness or as take as statements by this witness, anything that doesn't appear on state's 444Y, and that they should look at state's exhibit 460Y as substantive evidence of the defendant through his representative of what he was calling true and not true at the time that the state presented him the iteration that came just before it. So it allows them to put in context Mr. Sledge's factual acknowledgments and sentencing understandings that he signed.
I'm gonna get copies made all of these.
Yes, Your Honor.
All right, so just one. Oh, batteries, thank you. All right, I've got some batteries. If
Oh,
you
did they
think
go in
that
here?
might help with- I'll just put them up here.
Oh, boy.
It seems like your mic is out and I need batteries. I don't know whether they take double A or triple A.
Double A over here.
All right, got a few of each. I'm just gonna set those right there. All right, so I think that, you know, there's the 444Y one, which is the signed plea acknowledgement. That's sort of a separate type than all of the rest of these correspondences back and forth. And are you at this point saying, just so I understand, that like as to 460Y, you don't even intend to redact it at all?
No.
All right, help me understand what you're saying.
As to 460Y, I wanted to redact everything except the one email that Mr. Wright sent. I want to take out everything else before. I even think I included twice in that 460Y, the same email. So I would like to redact out all of that except the email from Mr. Wright to me on December 27th at 8:43 or thereabout at night, wherein he is making statements for his client. So they are statements of his client that number one is okay, number two is okay. And I say that under, I would call it an adoptive admission, but he is
Well,
an
it's
agent.
an agent.
Right.
Yeah.
So he is stating, his client is stating, number one is okay. And in order to know what number one is, the jury needs to see what number one was that I sent to them, which would be the exhibit directly preceding, which I believe is 452. If I'm wrong, I'll make that correction. But the jury should see 452, wherein Mr. Sledge says that's okay. They should see whatever he wrote about 450, about number 2.
Let me ask you something. I mean, is he really a party opponent anymore?
He was.
But is he now? Because admitting it in this trial now, is that an admission by a party opponent?
Oh, you mean in terms of the?
You're saying, this is a statement by Mr. Sledge's agent, which it is, but would that get admitted under the admissions by a party opponent exception to hearsay?
I wasn't admitting it under
Okay,
that.
so-
I was just saying they are statements of Mr. Sledge.
Okay, all right, but under what exception do they come in?
They are Mr. Sledge's statements. He is a witness who was on the stand, who was subject to cross-examination. So inasmuch as they are inconsistent and contradictory to the testimony that he gave.
Okay. So I can see 444Y coming in as a prior inconsistent statement because he definitely testified inconsistently once he was on the stand to what he said in that document, which admitted as factually true all of those things that he initialed.
Right.
So that's a separate item, and I'll hear argument on let's deal with that one. 444Y.
Is it my turn?
Okay, so don't talk about the rest of them until we get past.
Not yet, because I think this is kind of separate than the rest of them.
Okay.
Because it's a different type of document. So do you want to say anything else about that? You saying it's a prior inconsistent statement and it's impeaches him by contradiction.
Yes, and it corroborates the state's position and.
Well, I know why you want it.
Corroborates the state's position is
That-
not a hearsay exception.
Right, I understand that. Yeah, so why is that not come in as a prior inconsistent
Your
statement?
Honor, first, I just have to address one thing.
Okay.
And I'm sorry, I'm not trying to be a whiner. This is exhausting because every time we are on the same page and Your Honor seems to direct us, things somehow get relitigated. We were up at the bench and we all looked at 444
No, 444 is a different one, but yes, 451 through 6 and 460.
Are we talking about the emails right now? Or are we talking?
No, what I wanted to talk about right now is the actual final plea
Okay.
acknowledgement.
So I'll address that.
Okay.
We all talked about this and we determined what would be admissible as prior inconsistent statements. And the state was allowed to read and confront, and he acknowledged that he signed. So he never said he didn't sign those things. He explained it. But those factual acknowledgments on the 1AS, which I think is 444Y, were read into the record and fully litigated. And we not only heard from Mr. Sledge, but then we heard from Mr. Sledge's attorney for a day. And the whole process of how everything happened was covered ad nauseum. I think the jury gets it. And there's nothing that I would understand to be gained by admitting the paper copy of what was testified to and discussed over a week with, this gentleman and his lawyer on the stand, however many days it was, that hasn't already been covered. Additionally, Your Honor, of course, my stance would be, if it were to be admitted, it would not go back to the jury because it would be continuing witness. It would be, signed statements, written statements, and the idea that somehow, well, that deals more with the prior versions, but
Yeah, let's
you
not
know,
get to those
yeah,
yet.
I won't get to that yet, but we've discussed this, and now we're back to arguing about it again.
I don't actually know that we discussed 444Y1AS.
Well, the state sought to admit it at one point, is my recollection, and you instructed the state to ask about the ones he was denying, and they confronted him and they said, "This is what you're denying, factual acknowledgement." I'm using an example. 3, and then it was read, and then it was discussed, and then we went from one to the other to the other. The state was certainly not rushed in their examination of Mr. Sledge. So all this has been covered. There's no need to admit the document into evidence at this time. And it's cumulative, but also it should never go back to the jury to begin with. So I don't even know what purpose it would serve at this point.
Well, we can deal with that later, what goes and what doesn't go and what's subject to a continuing witness objection. But it's definitely a prior inconsistent statement. Y'all were given an opportunity to cross him on it. He was given an opportunity to explain it. It can come in as extrinsic evidence.
Well, okay.
It's pretty clear law. I think.
Well, the other thing is, I don't know if he denied, the other thing is he didn't deny adopting it. He said, and he gave an explanation.
I know.
Right, but I don't believe that lays the foundation for a prior inconsistent statement. Him saying, "Oh, I did sign this, and this is why I signed it."
Okay.
And then, so.
Well, the statements on the document say every bit of this is true, and I acknowledge every bit of this. And he testified inconsistently to that with regard to the majority of it.
He did, but he never said at the time he didn't acknowledge it to be true.
I think he did. Okay, so to me, I don't know if the entirety of it or just the parts that he denies are admissible, but does it really matter?
It
If,
does.
1, 2, and 14 through 15 come in?
I'd have to really look at it, and this is, the state has not given us a proposed redaction, but.
Do you propose to redact that at all?
No, and just as a
Well-
point of clarification, on the first day of direct examination, he specifically said that 1 was not true. He said that on the second day, he came back and said yes, but the first day he said no.
It's interesting that Ms. Love says that, because when she actually was examining him, she misspoke and said that he adopted number 1. So now she's saying he denied it. Yes, I believe that if we're going to admit them, if the state's not willing to redact it, then it should not come in.
All right, so
What is it that they're proposing that we redact, Your Honor?
the parts that he didn't testify inconsistently with.
So I believe that the document as a whole serves to rebut it's a contradiction. The document as a whole is a contradiction, impeachment by contradiction. It serves the other, the 3 things that he said he admitted, 10, 11, and 12. 5, 10, 11, 12, 14, and 15. Provide context to the types of admissions that he was willing to make. It provides context.
All right, well, didn't they watch a video of you reading out
Not
just the parts that he said were inconsistent?
Yes. just the parts that he said were inconsistent. And I believe that the document as a whole is evidence, powerful evidence of what the document contains, of the statements that he makes in the documents. I think it's evidence. The fact that he signed, the fact that the document exists, the fact that they can see what it is that he was looking at, and compare it with what it is he is saying on the stand allows them to further assess his credibility. It corroborates what they saw. It corroborates his understanding of what it is that he was signing.
All right, if we're talking about is it an exception that permits his admission, it being corroborative doesn't get you over that line. So yes, sir. Yeah. Now it may be that what you mean to say is that the entirety of the document needs to come in because that's the only way they can understand it. Is that what you're saying?
Yes, I'm sorry for not doing it as well as the court did. When I say context, yes, it is the only way that the jury can fully understand the document and what was before Mr. Sledge at the time that he signed it.
The state's stance is that the jurors can't possibly understand one factual acknowledgement about a video, for instance, without being provided another factual acknowledgement about gas stations on Cleveland Avenue. That acknowledgement about gas stations on Cleveland Avenue just sheds light on this acknowledgement about the video that allows the jurors to understand that. That's ridiculous.
You had him admit on the stand the factual assertions that he still agreed with, right?
I had him not read from the document.
Did the jury in any way hear the factual acknowledgements that he still acknowledged?
I believe that the
You know
answer is
the
in
answer.
some form or fashion they did. For instance,
Hang on just a second, Ms. Love.
oh,
Mhm.
And you said it, and I think the Honorable Attorney Sharp just said it. My memory, and according to my notes, the entire, from the swearing in of Mr. Sledge, then it skipped. And then the entirety of his acknowledgements, whether he admitted it or did not admit it, was read over my objection on a video audio from Crime and Law, or Law and Crime. And now we're doing it again. That's in evidence. So I'm objecting to it. It's already there. And the state at one time told you that they needed that evidence in because it shows demeanor and he had an opportunity to sit next to his lawyer, and that there was no one else in the courtroom, and Mr. Williams and I and the others weren't there to intimidate him, or whatever their word was. This is just cumulative. He's been impeached. He's been thoroughly impeached. So I'm objecting to 444 at all.
and at the appropriate time, I'd like to respond.
The answer to your question is yes. It has been acknowledged.
So your recollection is that on the video, every factual acknowledgement was read?
That is, if I'm wrong, please correct me. I'm not trying to be wrong. That's according to my notes. There was nothing redacted. It went right from the acknowledgements, whether he agreed or disagreed. It was read by Miss Love.
All right, Ms. Love, I know you sent us an email at some point that said, here's what I intend to play.
Respectfully, Mr. Steele is incorrect.
Right?
We do.
Okay, so hang on. And was sent Friday, September 6th at 7:45 a.m. And then, yeah. that's the right date.
And what
They
we,
may be again to me at 9:54 a.m.
right. Would the court like that we put it on the screen or just reference the portions that we were taking out?
No. Oh, yeah, no, you didn't play the ones that he said were true. You only played the ones that he said were false.
Right. I know. Yes, Your Honor.
Okay. Okay, so
And when the court feels it appropriate, I just had a couple of more words to say in response to Mr. Shart's response about 444 and impeachment by contradiction and the amount of time spent on it.
all right, I'm not concerned with the amount of time spent on it.
Okay, then not that, but-
So the ones that are prior inconsistent statements are the ones that he said were false. So if you're arguing that the entirety of the document should come in, what's your basis? Your basis for that is it's the only way for the state to, the jury to understand what he was willing to admit to and what he wasn't later on. What's your argument as to why it should all come in?
So, Your Honor, reading from Morgan versus Covington, 648 F 3rd 172 3rd Circuit is a 2011 case. The doctrine of, and this is quoted, this is cited from there. The doctrine of impeachment by contradiction serves as a means of policing a witness's obligation to speak the truth in response to proper questions and permits courts to admit extrinsic evidence that specific testimony is false, of course, because other evidence contradicts it. Other inadmissible evidence is admissible as rebuttal evidence where counsel opens the door to such evidence on direct or cross-examination. The doctrine of curative admissibility relates strongly to impeachment by contradiction. I won't get all into all of that, but when on cross-examination, Judge.
Appreciate it. All right, I'm going to give you your
Would you get that?
documents back.
Thank you. Ms. Hilton's coming.
None of these are yeah, okay. Thank you. Sorry to interrupt. Good.
Yes, Your Honor. So we're not just talking about, if we were only talking about inconsistent statements, then that would limit us to a portion of it. But here on cross-examination, the entirety of the cross-examination was intended to present to the jury the impression that the statement itself was not knowingly or willingly or voluntarily agreed to. And in fact, even though the court sustained the objection to the question, I believe Mr. Sharp said it, or I'm sorry, forgive me, Mr. Sharp, Mr. Weinstein said it when he said, when the state put these words in your client's mouth. So the point of it is, when on cross-examination, whether it's effective or not, when the effort is, and the witness has allowed it to happen, that an entire statement is essentially sort of undermined. You say you didn't understand it, you lied because your mother was not well and you wanted to get out of jail. The validity of the statement itself is now, it's impeached. It's almost like you're impeaching the statement itself. You're saying that the statement isn't valid. And so in as much as the statement as a whole does allow the jury to understand, it does place the few admissions he makes in context. We'd ask that it be admitted as not just a prior inconsistent statement, but as impeachment by contradiction.
Your Honor, A, there's no contradiction. He said that the state presented me a form that they wrote on their letterhead and asked me to initial it, and I did. And that's exactly what the form is. It's a form that they wrote on their letterhead that they asked him to initial, and he did. So there's no contradiction. The document doesn't contradict anything he testified to. Now, there needs to be a hearsay exception. And the reality is, if they're arguing that things are prior inconsistent statements, they've already been played in the video and we've already heard it. And if they're arguing things aren't inconsistent, then they shouldn't be played. There's no reason for the hearsay to come in. So even if I granted to them that it's a prior inconsistent statement, we've just established that we played a video with all of that being read, the jury's watched it, and that was covered. So at this point, that form for any hearsay exception that it would fall under, that's already been covered by the video.
All right, I'm going to rule on this one that the portions that he disavowed on the stand may come in as extrinsic evidence of a prior inconsistent statement. And we'll deal later with whether they actually go out as continuing witness or not.
And for the record, which ones are those?
So I would think that would be, if everybody has it in front of them, my understanding is he disavowed 3, or at least portions thereof, 3, 4, 5, 6. These are all under 4, under, factual acknowledgements. 7, 8, 9, and 16. And then every bit of Section 5, the sentencing acknowledgements. He said he didn't understand any of them, even though he initialed saying, I understand fully each of them, as well as the paragraph underneath that.
He also acknowledged on day 1 of my direct, number 1, I wrote it, though he changed that.
Well, if he changed it, then it was no longer inconsistent. I mean, I didn't, when you were like, all right, here it is in front of you, tell me which ones there you have any type of problem with. He did not say number 1. So he done, I made my ruling. All right, so that's that one. That is, and I don't know whether you're gonna tender 444Y. That would make more sense. You've established that it's the same as 1AS.
I did.
Okay.
When
I'm listening. Yes.
I'm going over just one moment, Your Honor.
Okay.
Yes, Your Honor, that is, we understand the court's ruling with respect to 444Y.
All right. And I don't think it would come in as, whatever it's called, the rule of completeness, because that would be if one party's introducing it, the other party has the right to do more. And this is all one party over here trying to get it all in. So that doesn't apply. All right. I think now we can move on to the rest of them, which are all sort of, I need a bigger bench. The same thing. Well, I guess what's in 460 is not contained in any of 451 through 456. Is that correct?
Well, 460 is Mr. Wright's email to us.
Back. Okay.
Right. And so 460, and by 460, I do mean the last four pages.
The part where he says, let's not do these ones, or here are the issues with these ones. So do you actually want or need the rest of them in?
Judge, because so
And if
the answer is
so,
yes. And I
okay,
will
under what basis?
Okay.
Under what evidentiary rule?
Yes. So as to number one, because Mr. Sledge, on the second day, he agreed and gave testimony about examples of number one. It's not so much that it's an inconsistent statement as it relates to number one, but when Mr. Sledge on cross-examination asserted that he did not have the ability to change things, that we didn't change things for him, showing the way that the recommended changes were presented to the state. What is not said is as important, in our opinion, as what is said.
All right, are we talking right now, I'm sorry, about just that portion of 460 that's Mr. Wright's 8:43 p.m. email?
I should have been clear. Yes, just, and the second part of that is just a duplicate where I asked that copies be made. So we are only talking about Mr. Wright's December 27, 2022, 8:43 p.m. Response to the state. Subject line is Sledge agreement updated. And with Mr. Wright on the stand, I clarified what exhibit came in before that he was responding to, which was 452.
Okay.
And then what exhibit came after that, which I believe was 453, but I'll check my notes to ensure that that's the case. So in as much as number one, he's saying, okay, there's no caveat, there's no, oh, hey, we need this. Okay. So number two, obviously, Mr. Sledge agreed to number two, but there is an additional, they formed about 3 years before Peanut was shot, him offering up that kind of information, Mr. Sledge offering up that kind of information. He is nowhere in there is he asserting it's a record label.
All right, well, nowhere in his factual acknowledgement on number two is it asserted what YSL is. It just says defendant has been a member and or associate of YSL since blank.
Right.
So he wouldn't need to say, and by the way, it's not a gang.
I agree with that. Also, but in number one, where we say what it is, we don't use the word gang. We say something, we use specific language that he's perfectly okay with. And then in number two, he makes no effort to, qualify anything as he did on the stand multiple times.
Okay, well, as we all know, the case law holds that it's actually not illegal to be a member of a criminal street gang. It's only illegal to commit crimes in furtherance of it. Well, to commit crimes, period. And then it makes it a gang
What makes it a gang is a
violation
crime.
to commit crimes in furtherance of it.
And that's why number one says.
Right. And so, I mean, number one is whatever number one is, but that number 2 says, oh, by the way, it was about 3 years before Peanut was shot.
It's that he's offering information, and I'm going to defer whatever the court's ruling is,
Mhm.
but it's that he's offering additional information. He's
I think
comfortable enough to say.
I think that is okay, I think it was about 3 years beforehand, so it must have been about 2012.
Okay.
Okay, so 3.
Number 3.
Didn't we read that into the record?
We did. We read the response Mr. Wright gave,
Okay.
and I believe
We did
we
read that.
read,
We did read into the record.
if I
Your
make
Honor.
it, I
All right.
believe we read as well the portion of 452, that was number 3, and then the final. I think we read 3 number 3s into the record, just so that the court is hearing what I believe is the full truth. We read not just that, but I asked him to read what he responded to and then how we changed it for him.
We read at least the final version of number 3.
We
many,
did.
many times.
Oh,
So number 4, back on the email by Mr. Wright.
Okay.
We never read that in, right?
So
I'll
number
remind-
4,
I'll remind
we did
the
not.
court that we approached about number 4. There were obvious problems with number 4 that were inadmissible. We were told to stay away from number 4. The state was told away from number 4, told to stay away from number 4 for obvious reasons. There's all sorts of speculation in there. And now, after being told to stay away from it, and we were told to stay away from it, and we did not address it during cross-examination. Now, after witnesses have testified, the state's seeking to admit a document that has number 4 in it. And it's just, I mean, I don't know what we're doing.
Okay.
Your Honor,
Number 5 is not even relevant, right?
Your Honor, if I may just circle back briefly, as it relates to number 4, there was an objection to it. We followed the court's instruction. We did not ask him about it. And when the issue that I have with number 4 not being addressed here is more importantly, I don't know how an assertion that the witness did not adopt is prejudicial when he is not, he denies it and we change it, and we take it out, that he was planning, he had personal knowledge that they were planning. That is powerful because it is a material fact that
He doesn't
denies.
have personal knowledge
That's
that they
ex-
were planning it.
Judge, that's the point that I'm making, that he says, I did not know that. The fact that something that,
Even saying I did not know that is sort of like,
or that's not
it
true.
was true, but I didn't know it.
No, he's saying that's not true. He is
No,
saying
he's
that-
not. He's saying, I don't know. I think maybe XYZ. That is not coming in. That needs to be kept out under 403, if nothing else. And that's really the only thing you wanted in, right? So
I didn't hear you.
is that really the only thing from this that you wanted in?
When you say this, you mean
From this being this part, the 8:43 PM email from Mr. Wright that is
Oh.
included within 460Y.
I didn't even, the language of what he says, I didn't even need to have that in. I mean, I understand why that would be considered, and I understand the court's position there, why it would look like something was pre-planned. The reason that I was asking or seeking to have the assertion in is just to show that he says no to it. We could take out all of number 4 under Mr. Wright's email and just say, no, I don't, just, he denied it.
Well, we can't make it say something. It
No,
doesn't
not
say,
put the
so
word
we're not
no.
gonna be
He
doing that.
said, Mr. Wright said on the stand
Okay.
that is something that we did not agree to and we took out.
And that's exactly the point. Mr.
Exactly.
Wright said all
right.
the stuff on the stand.
We're not going to be admitting 460Y. And that leaves 451 through 456. And those kind of, what would be the theory under which those would come in?
It, Your Honor, provides, it contradicts Mr. Sledge's testimony when I presented him with a prior iteration, that there was an objection to it being called a prior iteration. And I asked him to show me things that were different. It contradicts his testimony that he saw prior iterations and was allowed to make changes to the prior iterations. He said on cross, the first time he ever saw that plea agreement, it might have been the first time that he saw.
Well, that was the first time he saw that plea agreement because all of these were prior versions.
And when I asked him, did he see any prior versions? My recollection is that he denied.
I don't remember that. I think he said the back and forth between us and the state was up to my lawyer. I left that to my lawyer.
And Mr. Wright clearly testified that he took a version to speak to Mr. Sledge the night before.
And I'll look back at.
All right. Well, subject to that actually being some kind of so that would be what, impeachment by contradiction?
Yes, it would.
Okay. Well, you can let me know if he actually testified
Your Honor.
in the way that you remember it. Yes.
And I don't think we should have to litigate this again, and I'm going to explain why.
Okay.
The state, under the state's theory, well, I mean, why don't they just do this for every case? They could write out their facts, just send them to a bunch of witnesses. Witness doesn't need to initial them at all, and then they take the stand, and then we just start bringing in all copies of documents that they wrote and sent to witnesses that witnesses looked at. I mean, it's false facts here. It's facts that haven't been adopted on these documents. There's inadmissible statements on these documents. It's a mess. And we didn't create this. We didn't tell the state to do it this way. We didn't tell the state to write their documents and then send them to an attorney, write the statements and send them to an attorney and see what the co-defendant says or the witness says. We didn't tell them to do it this way. They created this problem.
I understand. You can get back to me if you can find some kind of testimony that you think lets you get this in. Right now, they are excluded.
Yes, Your Honor. Thank you. And I will look for that.
Yes.
I can't say with certainty, but I'm just going to ask if there is also a case which I, in my mind, in the recesses of it, believe that it may address specifically like
Okay, well. if you-
iterations.
Sure.
Okay, thanks.
Even if Mr. Sledge did say there were never any other versions, and which I don't think he said, you've disproved that by presenting the testimony of Mr. Wright. So I think given the number of 403 concerns there are with 451 through 456, I'm gonna just stand on my ruling excluding them.
Your Honor, with respect to the 403
Mhm.
concerns that were raised, given that 403 addresses matters that are substantially more prejudicial than probative, and given the extent of the cross-examination and the efforts to undermine the willingness or knowingness of Mr. Sledge's statements, essentially even in the arguments that are made, it's essentially, the argument is that this isn't a statement that Mr. Sledge made. Showing that Mr. Sledge, showing a prior statement, contradicting that testimony.
That's what 444Y is. And that's it.
The,
As redacted.
that's the ultimate
That's
one that he
I
signed.
know. And
But
that's-
showing, yes, it is. It
I
is.
know.
Showing that he was untruthful and letting the jury decide, why are you telling stories about that? About seeing a prior version, we believe is strong evidence that allows them to judge his credibility, why he's saying what he's saying, any bias he may or may not have, and help them to determine the truth of which statement they should believe. So we would ask that the court, I don't know, revive its prior ruling.
5 minutes ago.
Revive the ruling that the court
Okay.
made.
Denied. Let's move on.
Denied. Let's move on. Y'all miss my voice today?
Yes, definitely. All right, what were y'all tasked with over the lunch period?
Your Honor, we reviewed the proposed segments of those videos that showed Mr. Beebe and Mr. Eppinger referring to and they weren't referring to it, but it's clearly involving the armed robbery that they're charged with that's listed as an overt act. I can say on behalf of myself and Mr. Steele, we have objections. I think Mr. Steele was going to articulate them
All right.
to those segments.
Okay, I think it would probably help for me to be able to see what those are, but before we do that, 463Y, were you intending to tender that at all? I don't know if that was one that you had included that we said we'll circle back.
CC, you been holding it down, girl.
Sentence that showed that he got the sentence on the second count too.
No, that was just to
okay.
refresh his
All right,
memory.
thank you. All right, can you queue up the portions of that video, please? Hmm.
Never ready. So many moments of silence, man. What's up? Get the cue to ain't it they I'm confused. All right.
Together that, just the portions of that guilty plea. So if we're going to be just showing portions of various videos and things, if y'all could do that for those as well, that moved things along much more quickly.
Thank you, Judge. We will, after we,
Great.
work it out.
Decide. Okay. Thank you.
The first portion of this video, it ends in 2624. In the video, it's the Atty Kay B, and it'll be Christian Eppinger. This is after the armed robbery that both are alleged to have committed. Mr. Beebe has recently or did plead to the charges in this indictment regarding this armed robbery.
All right. So I'm sorry, timing wise, this is shortly after the robbery or shortly after?
Shortly after the robbery.
Okay.
And we're going to begin the first portion at 1:12. And it's about 3 seconds, Your Honor, from 1:12 to 1:15.
What y'all going on now? What's up, Slim?
And Your Honor, as you see, or if you see there, when Christian Eppinger gets onto the call, he throws up what we have alleged is the YSL sign, and then Durante do it back towards him.
Okay.
The next portion, Your Honor, is 2 minutes and 45 seconds to 2 minutes and 52 seconds.
Anybody in here? I'm out there. All right, Slanton.
Can you get rid of that box by chance?
Yes.
I don't know why that does that, but.
And so, Your Honor, if I need to play back, I will, but when they're ending the call, they both say flat, which is a terminology that we are alleging that YSL members use. And then the last portion is 356, 408.
But they hit them up really year on my artist minimum. They give me, I done built me a business up.
And it ends there. Just a few things. The clothing that he is wearing around, I believe this is OTS or on the slime clothing that he is wearing. This is also his public page. And so immediately after this call, he then points a gun at and towards the camera. Again, going towards the state's theory that members of YSL operate with violence and using guns to show their threat, their notoriety, and given everything that has happened in the video, those relevant portions. Those are, for this video, the 3 portions we see.
Ms. Hilton, excuse me.
Can you not hear?
I didn't quite follow the first thing she said. Something about what was on the clothing.
We believe that this is clothing that we've seen on other YSL members. It's either OTS or on the slime clothing. We've seen, and I think we have a few other posts, Your Honor, with them wearing similar type of clothing, but it has either YSL or related terminology on the clothing.
All right, and on what piece of clothing is that?
On his, I believe, the headpiece as well as the shorts.
All right,
Your Honor.
can you show me that last portion again?
Yes, Your Honor. And I started a little.
So on the headpiece and the shorts.
They ain't got no involvement, but they hit them up really year on my artist minimum. They give me, I done built me a business up.
And what does he say?
Built me a business up.
I heard that part. What does he say before then? Is this just to show the clothing?
No, the clothing and the pointing of the gun.
And pointing of the gun and saying.
They hit them up really year on my artist minimum. They give me, I done built me a business up.
I think he's rapping a lyric to a song, but he says he hits them up, and I'll have to go back and look at the other portion of the language.
Your Honor, procedurally, are you wanting us to argue these one at a time?
I think, yeah, that'll be this set, not like, well, not necessarily one portion at a time, but like this will be, I'll hear the argument as to this. So I guess there's the beginning where they're throwing signs, the end where they're signing off with the language, and then the middle, the end of their call, and then the end of his post where he is wearing particular clothing, pointing a gun and saying something indiscernible other than that he's going to build a business up. But maybe you can let me know what he's saying. But if what he's saying doesn't matter, then
I have
What he's saying does not.
okay. All right.
I have reason to believe that he's singing a popular
Okay.
line from a song that
All right.
is not involve anyone in this room.
Okay. So is this what's the line of clothing?
So
is it like a line of clothing you can buy in stores?
I don't know if you can buy it in stores. We believe that there's one member of YSL, Miles Farley, who is purportedly a clothing designer. He creates
Okay.
some of the clothing.
That is
I don't know if this is that.
That's
but,
not his clothing line.
Oh, well, but the clothing says, and I have another picture because I believe this is from all the same line.
Okay, but I mean, if this is something he's wearing and you want it in to show that he is a gang member.
And the clothing says, and I want to back up, we believe it says slat on the clothing, on the shorts. And I'm looking at another act that we have, Act 143, with him and Christian Eppinger, and Christian Eppinger wearing a jacket similar to the pants and the hat set that he's wearing in this particular video.
And when is this from?
This video is around October of after October 10th of 2021. The armed robbery takes place in October of 2021.
All right, and tell me why y'all are offering this.
Your Honor, so with the first two portions is to show that both Mr. Eppinger and Mr. BB, again, right after the robbery, are in communication with each other, showing their association with YSL by one, using the gang symbols, and two, using terminology in which members of YSL uses. And then the last portion of the video, which is when he places the gun inside of the video, Your Honor. Again, this is a public posting of Mr. BB. And it shows, again, that members of YSL uses what this gun for no reason comes into this video at the end. There's nothing, I don't know what the purpose of actually flashing a gun is, but to show that he, as a member of YSL, has handguns, uses handguns, especially coming after an armed robbery, which we allege.
All right, and the armed robbery was what, like October 12th or something
October
like
12th of
that? And then
2021.
when is this video posted?
I just need to pull up the Instagram, Your Honor, of when this exactly video was posted.
And can I ask the state another question while they're looking into that? It's being, and I'm sincerely asking, it's being stated that this is a public posting. And I'm wondering was it a public posting or was this something retrieved off of his cell phone? Because those are two different things.
It was not retrieved off of his cell phone. We got an Instagram return for Mr. BB.
So yes.
So
these
was
are
this on his
public-
Instagram page? Was this a story that disappeared after 10 seconds? I'd need a little bit more context about what exactly this video is and where it came from and how it was presented to the public.
It came from his Instagram return. His page, we do not believe, was a private page. And the Instagram video was of him. It's a Instagram call that he makes with Eppinger, so it has to be public because Eppinger knew to log into the call when that's how he gets onto the call.
So is it public between the two of them?
No,
Forgive me, I'm not.
no, I believe it's
Instagram
public to
familiar.
Instagram because
To his private page? Because you said it was a public post on a public page, but then you said it was from his private page.
no, it's his personal page.
Oh,
But
okay.
a public.
You don't mean it's private, you just
No,
mean it was his page.
personal page.
Your
Okay,
Honor,
but it's a
people-
public page.
People that are younger than me, that are helping me here, are telling me that this is not something, like if I wanted to check out what Mr. BB was doing on Instagram, it's not something that I could find publicly. This was a call.
If you followed it, like if, I know a lot of people have lots and lots and lots of followers, like thousands and millions. Would any follower be able to see this? I'm just trusting the youth in the room now to. I can Google it. All right, let's assume for now that it's a public page and we can circle back
My
on that.
understanding is once the call, and this is my confusion why I'm asking the state. Okay, I'm using call, but
Once
it's not
the-
technically a call. Okay, but once the interaction is done, it is not saved. This is what my understanding is. It's not saved on his page. So I would not be able to say, hey, for instance, if I said,
Could you watch it while it's going on if it's being posted to the page?
if you were, I think it depends if you were invited.
If you're a follower. I mean,
Yes, so.
whomever.
With Instagram, if they are on a Instagram story, oftentimes the other person watching your story could get onto the call if you accept them.
All right, can they watch it regardless?
Yeah, can they, who would that?
I don't know. somebody other than the two people communicating
Other people can watch.
can watch it.
Are you saying can watch it if they're given permission to watch it, or are you saying they can just watch it? Because our
If they're
understanding,
followers or if it's a public post.
They can watch, I can log on, I was friends with not a friend, if he has a public page and he's in his Instagram story, he's talking to someone, I can log in and watch.
And then there's clearly something he does even after the communication is over that he's showing in the post.
Right, and he can, and then the other person, Mr. Evinger, can come out of the call. He can
All right, and does it disappear or does it stay up
I
until you
believe
take it down?
disappears. I believe it disappears.
Okay, so it's up for 24 hours. And do we know whether this is an Instagram story?
I'm going to confirm, I believe.
Okay, well, we'll assume for now that it's a public Instagram story that's up for 24 hours.
And I'll add one other thing, and I can't say this with certainty. On one of these calls, or whatever they're called, one of these interactions between him and Eppinger, it was determined that no one was in the room. So I don't think that there's the room meaning watching. So
The virtual
I
room.
don't believe that.
Well, I'm not sure that matters
Oh,
if you're
well.
posting it to be consumed publicly, if there is somebody watching.
Okay, well, I think you can tell if there's people watching or not, and I think it was this call, but I don't want to swear to it.
All
But I have no evidence that anyone was actually watching, other
Okay.
than him and Eppinger.
So do you know when the post was made? Have y'all been able?
I misspoke, Your Honor. The posting was 2 days before the so on October 10th is when the posting, according to the Instagram video, was
Okay.
taken.
All right, but close in time.
So it was close, so it was 2 days before showing
All right,
these two individuals.
okay. I think that the first two portions are relevant and not excludable under 403. The third one, unless you can get me a whole lot more to explain why that clothing makes any difference at all. The fact that he's holding a gun when nobody can, when all he's doing is singing, doesn't show anything.
You're right. He is representing, we believe, with the clothing on YSL prior to an armed robbery that he commits with.
Okay, I understand you believe that, but until you can give me some basis to believe that.
To believe that the clothing is.
That the
why-
clothing, yes, it makes
Yes.
any difference whatsoever.
So, Your Honor,
So.
with respect to the case law that has come out after Rodriguez and all in the furtherance of a gang.
Uh-huh.
So some of the things that courts have named as evidence of furtherance of it being done in furtherance of the gang
Mhm.
is whether or not the person is wearing items of clothing, articles of clothing that have or bear the gang name, if they say the name, if they do things that represent the gang in close proximity to the time of the crime.
I understand that.
And with the fact that he is pointing the gun at the camera and saying whatever he's saying, our analogy, we draw the analogy that in pointing that gun at the camera, if, as Ms. Hilton is looking, we find sufficient to the court's satisfaction that he is wearing YSL clothing, in the same sense, he's representing YSL as he's pointing that gun at the camera, making the statements, whatever they are, singing or otherwise. And in doing so, he is making a public assertion about YSL's willingness to perform violence or to
All right, y'all get back to me on the clothing.
I'm ready for the
Okay.
clothing.
I
So
think-
I'm going to show a portion of the video.
Your Honor, I think I'm probably stating the obvious, but that's not when the armed robbery happened. So.
But yeah, it sounds like it was 2 days before.
Yeah, so I don't know about what Ms. Love just said, this has nothing to do with showing that the armed robbery was somehow gang related. even if he's wearing that clothing. But Your Honor, regarding the clothing, again, I agree with Your Honor about the ruling, and we'll look at the clothing, but the gun, I don't like, the thing about clothing is we can get a screenshot and see what someone's wearing. I don't know why we have him rapping and pointing a gun, because that is just
What
a
lots of
man.
people unfortunately do these days.
Right.
Your Honor?
Yes.
And further, what clothing is this? Because Miss Hilton, first she said she thought it was one clothing, then it might have been somebody else's clothing. So can you please tell us what clothing line is this?
I can't tell you the clothing line. I can just tell you that the clothing has slat on it. And if we look at his shorts, and this is at timestamp 3:43. I'm using this timestamp, and then I also now want to show the court Act 143 with someone wearing the same similar clothing, and where it's clearly that it says slats on the clothing, which is terminology used by YSL. So
Okay, you're showing us where it says this on this clothing.
So on this clothing with the black base, the blue lettering says slats. And then there's also some red items, but we know that the blue lettering says slats. And I know this, or we believe it is this, because just need to pull up.
Do you have him wearing other gang paraphernalia at other times?
That's what I'm
All
pulling up
right,
now.
then that's gonna be sufficient.
So Act 143, Your Honor, which is, we believe on September 29th, 2021, so about 2 weeks before the
Mhm.
video, Mr. Eppinger, who he's in the video with, is wearing the similar clothing, the slats. He just has the jacket version on.
Okay.
And then BB is wearing the OTS, which says only the slimes. I don't know who created it, but it's slime clothing or slat or YSL affiliated clothing, Your Honor.
And who is that? Is that?
So that's the same. So the person in the jumpsuit is Mr. Durante BB. This is the person who had the gun in the video. Next to him is Mr. Eppinger, who was the person who joined.
Okay,
the
so you
video.
have both of them a couple of weeks before wearing what y'all allege to be gang clothing.
Yes, Your Honor.
All right, that's enough. You can have those two portions that are the beginning and the end of his call, and we're not gonna do the third portion.
Okay, thank you, Your Honor.
Yes.
I want to, if you rule definitively, I want to just put my objection on the record. These are out-of-court statements. Mr. BB and Mr. Eppinger are not here.
Mm-hmm.
So it cannot be, the way I understand the law, admission by a party opponent because they're not on trial with us.
Right.
And therefore, it has to come under some sort of co-conspirator hearsay exception. And I don't know how this furthers a conspiracy to say, and I believe these are quotes, what's going on in the first 112 to 115, Your Honor, and then what's up, slat. I don't know how that furthers the conspiracy, so I'm objecting to the verbal. In addition, I asked the court, there are a tremendous amount. There was a contest on the internet who can say slat with a song so many times. I tried to put that in evidence, and Your Honorable Court sustained the state's objection and said, who cares? It's a popular thing that is being said now, and who cares that people are on the internet saying that? The state just said that slat is important because that's what YSL members use. I want to show that everybody uses it. And slat was a popular term before 2012 when this supposed gang formed. You will learn if you let it in.
Did somebody already establish that?
I
I know you
tried to.
established it with regard to like some of those other sayings.
Yes, Mr. Trantavia Stevens stated that when he was younger, it was made popular by a rapper, an artist named
Right.
Lil Wayne.
Okay.
So I was stopped from doing it. So I'm objecting. I understand. I'm not trying to belabor this, but I'm objecting to all the verbal statements. And then I just think it's nothing here to me furthers the conspiracy. And
All
that's
right,
the only
well,
way to do it.
Thank you. All right, so that's that issue. Oops.
The next video. It ends for the purposes of the record in 3396. And I'm going to find the date, Your Honor. This is after the robbery. And we'll play from 10 seconds to 2 minutes and 52 seconds.
Do you know how far after the robbery?
That's the date we're looking up now. Yes, sir. This is on 10/13/2021, so one day after.
One
the
day
robbery.
after, okay.
What are we watching, guys? What is this?
All in the club throwing gun signs.
I missed y'all so much.
All in the club throwing gun signs. I know what the fuck going on, man. Shit, YSL.
Okay.
Few things, although he's in the bed saying he's in the club throwing gang signs, he threw up the YSL sign.
And y'all, who is that? Who stole the chain? What are we looking at? Somebody help me. I'm so lost.
More importantly, I freeze frame on the chain. This is the chain that was stolen from the victim. 2 days prior to, or a day, excuse me, prior to the, this video being posted. He's also wearing, you can see his headpiece or the hat or the mask that he has on his head is also another mask that says "Keep America Slime Again."
Period.
Says this shit YSL at the end. So,
okay,
for those reasons, we believe that is relevant.
Can somebody tell me who it is? Because they're not on this trial.
And just like the first one, I'm not conceding that this is for publication for the public, and I haven't heard how the state is going to lay that type of evidence before the court. And I don't have that evidence, so I can't tell you that it was for publication. I
So
can't
it's a
tell you
live-
private.
Okay, we'll circle.
More Brady. Why they don't never have the evidence?
I don't know
Crazy.
how the state's going to prove that that is the chain that was stolen from Mr. Smith.
I bet it looks like a pretty distinctive chain. Are you gonna have
Trap
somebody
commander.
to
Yes, sir.
identify that as the proceeds of the robbery?
The victim goes by the rap name Trap Commander, and that's what is said on the chain that is stolen. And we intend to call that individual.
Okay.
And then I don't believe that this, depending upon if it's public or not, I don't believe that this furthers a conspiracy, which it has to, the way I understand it, for his verbal statements.
All right. Can you
So in looking at the Instagram return, we know that this video is from the archived live videos.
Okay.
Instagram does not disclose, at least on our immediate review, whether it's a public page, but we know it's a live video. I imagine he is broadcasting it out to someone because it's a live video. He's not broadcasting it to himself. And so a live video is what we discussed earlier. He gets on Instagram and anyone who is following him can literally open up his icon and see that he's doing a live video.
And if you haven't yet, are you going to present somebody to explain to those of us who are not 20
Yes.
that all of this is true?
Yes, Your Honor. We will
Okay.
have someone explain Instagram for Instagram. And because he is posting a day after the armed robbery, the boldness of stealing the person's chain and with YSL paraphernalia on and saying YSL. For those reasons, we do believe it's in furtherance of the ultimate YSL enterprise conspiracy.
All right. I'm going to rule that admissible. I am, yes, when I rule it admissible, I have done the 403 analysis and found that it is not excludable under 403. Nothing in there is substantially more prejudicial than probative.
The next item, number 16, and that's going to be from 53 seconds to 2 minutes and 50. And for the purposes, we'll identify it as the last 4 digits, 5860.
This is
And this
also
is
Instagram.
It's also an Instagram video.
Live feed.
A live feed as well. And this is on October 14th, 2021.
Okay, so 2 days afterwards.
Yes.
Okay.
52 seconds.
What? Why they do? You don't hold a line. Oh, lock Slate face up. They locked Slate face up. They did.
This making my stomach hurt.
Damn, why everybody did? Yeah, they wound up. You Slate face, man. He said, what? He said, so where you at? You still on the way up there? Yeah, we on the way to the room. We on the way to the room right now. Oh. I'm gonna call you.
Yeah, all that motherfuckers playing. Cigarette, yeah. Slap theater, man. Hey, I'm at the studio. You at bullshit? Yeah, I'm gonna lock in right quick. About 4 or 5 hours. You'll be back.
Yeah, like
by
if they're
Sunday.
not on trial, I'm confused why we're watching them. Who are these?
Yeah.
I know the one boy.
Hey.
Who is this?
Oh, yeah, slap fit, no rat fit. No kiss. He's somebody add me, please. What that is? Where you from? Boy, how the I don't think get all this shit. Hit the phone.
And we can stop it at 2:47, Your Honor. So a few things that occur in this video is Mr. BB is on his way somewhere, and Mr. Eppinger joins the call again or joins the video again. You hear him say, as he's holding up the chain that they just stole a day before, says slap business, and then later again they say slap business, no rat business, Your Honor, and believe that testimony will come out during this portion that Darius Smith had went to the police, after he had gotten robbed. I believe there is some information that he was being threatened after he went to the police. Okay. After he went to the police, Your Honor. Furthermore, also in this video, you see another co-conspirator, Miles Farley. When they pan the camera to the individual who's in the front, he appears to be sleeping. That is another co-conspirator in this case, which is Miles Farley. So for those reasons, and you see them also in this video putting up the YSL sign as well, that for those purposes, this is relevant to show association, to show the furtherance of the enterprise, especially even after the armed robbery.
All right.
May I, Your Honor?
Yes.
I am going to wage the same objections, that it does not further the hearsay objection to the conspiracy. But if your court is consistent, then what I'd like you to do is please wrestle with the idea that the one before 3396, showing the court said that's a specific pendant, and therefore it's relevant. An armed robbery occurred the day before. This is the following day, so 2 days after it. This has the same pendant showing, so I would argue that under 403, at some point, it's cumulative. So those are my arguments.
All right. So I think, yes, sir.
Yes, Your Honor. I have a question. As a condition precedent to the admission of this particular piece of evidence, public or private is a condition in terms of the social media, whether or not the platform was public, correct? Is that what I'm understanding? It's a question.
So you said this was another live feed?
Yes, this is also for archived live videos.
So if they are downloading that information or those documents from a live feed, how do they know at the time that it was public? That's what I'm trying to understand. I want to make
Well,
sure.
and honestly, you may need to have somebody come give a proffer on all of that. I mean, I hear you saying your understanding is that it would only be archived if it was the live feed, and that live feeds stay up for 24 hours. And I think that anybody who wanted to log onto that page could see it, or at least anybody who was a follower could see it.
Definitely anyone who's a follower could see
Okay.
it. And I think that's the distinction. Anyone who's a follower of the person could see it. Whether or not someone who's not a follower could see it would determine whether or not it was a public or private. I don't know if that to me, that goes to weight, not admissibility of the evidence coming in, whether or not it was a private or public page. But what we know is a live video, other individuals can see that, whoever may follow him, or if it's a public page, people who don't follow him can see it. But other people besides himself could view the video.
So, I mean, this one is, it's a communication between, and amongst several co-defendants and alleged co-conspirators. Given all that she set forth as the different things that were significant, I don't think it's just cumulative of him himself sitting there with the chain. This is him talking to his
his co-defendant,
co-perpetrator
yes.
of the robbery, and talking about slat business and rat business. So it's not simply cumulative, it adds a whole lot more. And honestly, like whether this one is public or not,
Okay.
it's them talking in furtherance of the conspiracy. So for this particular one, it wouldn't be significant to the ruling, whether it's public. For that first one, it seemed to be, I mean, for one thing that she was saying, that was one of the reasons why, but yeah, not really for this one.
And for the court, I'm being told that whenever the court does consider public or private in terms of whether or not it's a condition precedent, that there should be some comments or icons demonstrating how many viewers are present, common.
Okay. So I don't think how many viewers actually see it is significant to the fact that you might be putting it out there to be seen. Or you're putting it out there where it could be seen.
And comments and viewers count are key, you know, to determine or in allowing. I'm just trying to read the writing.
Westmoreland is like, would you older people please stop talking about this?
But Your Honor, the reason why Attorney Matthews is bringing up comments and things of that nature is because when it is public, even just public, meaning that your own followers can see it, you would tend to see commentary from even your own followers.
Okay.
So I just don't think that the state has proven that the videos, at least the videos that you're considering, whether it's public or private, even your own followers being able to see it, I just don't think they provided any evidence of that.
All right, well, I don't think it really matters for this one. So I find this one to be admissible.
Your Honor,
Yes.
before, and this has nothing to do with the court's ruling. I'm not trying to relitigate anything, but
Mhm.
while Ms. Hilton was speaking, she mentioned Mr. Darius Smith and their possible threats or something of that nature. I don't know of anything that I've been told or provided in discovery that provides any information about that. So to the extent that the state's ever going to want to get into anything like that, I would expect to be given some information.
Some production of something.
Yes.
Are y'all planning to get into that?
I believe it's already, and we'll double check. I believe it's something that's already in discovery, that after this, whether it was his interview, whether it was Mr. Smith's interview, that he talked about receiving threats because he went to the police. And so I'll
All
find it
right, we'll
specifically.
just
and
make
get it
sure
from you.
that they've got that.
Okay, so there's no video of any threats or
No,
anything like
no.
that? Okay.
Okay, it's just that he says during the course of his interview with police when he was reporting the crime.
Yes.
Okay, and y'all are familiar with that?
I'd have to check too.
Okay,
I just
that's
didn't
fine.
remember seeing any
Okay.
videos or.
Yes.
I know you just said that the last one, which is 5860, has more, so it's not cumulative of the
Mhm.
previous one, 3396, but wouldn't 3396 then be?
Then be cumulative.
Yeah, that's what I was arguing earlier, because you said that it's coming in because it's showing the unique trap commanders, what I believe it says on the pendant. I think it says trap
Yeah,
commander.
no, I just thought that when you, that comment was when you said, how do we know it's his necklace? I was
Sure.
saying that looks like a pretty unique necklace.
But wouldn't, I mean, at some point, is it I know it's short, but isn't it cumulative of the next day?
You know, that is much more to me, him really kind of flaunting the necklace that had just been stolen a day before, flashing money, throwing gang signs, saying, if he said, I heard him say this shit YSL. I think that is somewhat different than what we see in that 5860 video.
Your Honor, after all of the
The
specific,
videos, okay.
yes, after all of that, I just wanted to make a general, ask the court's instruction on a general matter about
Okay.
cumulative nature, but I'll let the court go through all of this. I just didn't want to.
Well, what do you want to know?
Generally, what I'm hearing is that whenever a video, a picture of something is shown that's slightly similar in nature to something else, there's been the cumulative of the 403 objection. And the court knows, and everyone does, that there are 65 counts in this indictment and 8 defendants currently on trial. And to the extent that some of the evidence in the court has been essentially ruling along these lines, but I just wanted to say that to the extent that there are efforts by the state to put in multiple showings of a defendant doing, or other defendants or co-conspirators doing things that may appear similar on different times or at different days, this is meant to rebut this continued assertion by counsels for 8 defendants on trial that this is a record label and nothing more. So I just wanted to put out there regarding the cumulative and the 403 objection that we constantly get when there's some similar, and the court's ruled the way, I believe that is proper, but I did want to respond to that objection that is constantly being made. Thank you, Judge.
Well, to me, cumulative isn't whether there's some reason to put it in to rebut something or not. It's just do 7 or 8 different pieces of evidence show the same thing. Then after like probably 2 or 3, 4 through 8 become cumulative. So you're not necessarily limited to, oh, I can only show this one way with one piece of evidence, but you don't need to show the same thing 8 different ways.
Well, Your Honor.
Yes.
Ms. Love's argument may remain the same, but it's not 8 defendants, it's 6. It's okay.
You're right.
Right,
I suspect your argument would remain the same.
I found where we were referencing at least some indication that maybe the victim in the armed robbery was being threatened.
Okay.
It's going to be in Discovery 7. And within Discovery 7, the last police report, it's the first paragraph from May 18, 2022. And then the actual text messages that is referenced in that particular portion of the police report is also found in that same folder, in the digital evidence folder.
Okay.
You're welcome.
All right, when do you think we all can circle back on the evidence that y'all were gonna get together on with regard to Mr. Ryan?
Mr. Boston, right before the court came out, we were trying to figure out a time. So we'll talk some more after lunch. I mean, after lunch, at the end of the day, just to try to solidify a time within the next couple of
I'm
days.
just not sure we're gonna have a non-jury day before y'all might get to that. I mean, we might, but. Okay, so I have some notations on if we go back to, I guess it must have been on this wiretap, because that's what we've been going through.
Your Honor, you did ask the state to look at least before we get to Mr. Harvey's motion, you had notes on 2 of the recordings.
Okay.
I believe it was what was identified as 513
Yes.
and 5/523
Right.
and then 1109 and 1124. I'll start with the easier one, Your Honor. 1109, 1124, the state does not intend to use.
That does make that easy.
And then I'm not sure if the court just wanted for 513 to 523, the relevant portions of that call.
So on that one, it was the part, yeah, the flipping the car and laughing part.
So when I listen to a trial, I don't know if I hear flipping the car, but there is some conversation that starts at about 35 seconds into the call, in which, to set the stage, this call is at about 9:45 p.m. on March 16th. And so this is about 9. The home at, or the house at 2830 Waters Road just got shot up earlier, late the night before, earlier in that day. And Mr. Garlington is speaking to someone that we believe to be the Waskin Wright, who is a member of 30 Deep. And when they're on the call, they first talk about different types of weed.
Yeah, I said that part then.
And after that, Demekion begins to tell Dewaskin about the drive-by shooting. And he tells them that 12 had us, they shot up Big Nick's spot, which is the home where they are. And we thought that they were going to come back through, meaning that they thought that the ops were going to come back through, that they sprayed through the house.
Y'all know
that they
I'm
were
over
all
here
in the
eating,
living room,
but I'm right
and
here,
they
I'm
were surprised
listening.
that no one got hit. And Dewaskin asked, well, essentially, why do you think it happened? And Mr. Garlington says, one of their little partners just got shot or just got killed in Mechanicsville, which would have happened on March 14th, 2 days prior. Then at some point in time, a little later within that call, Mr. Wright says, do y'all have to drop on them in words? And Demekion responds, I would need to play it again, what exactly his language was after response to that. And that portion is from 0:35 to 1:40, and then from 1:48 to 2:31. There's a small 8 seconds in there that we wouldn't need to play, but those are the 2 we believe relevant portions. Again, they're talking about the opposition first shooting up the place and then being asked by a 30 Deep member who we allege they have alliances with, YSL, that some members who were formerly 30 Deep are YSL, and then they still have an alliance with 30 Deep. He then asked, do you have a drop on them? Meaning, are y'all going to retaliate is what we would think that they say. And those are the portions that we believe are relevant.
And those are the only portions of that.
Yeah, the call is only 2 minutes and 30 seconds. So it's really the entirety of the call, except for that 8 seconds that is between 40 and 48. Yes, sir.
Yes.
There's a portion, I believe it's the same call. I have it as call 513. Mr. Shark gave me that number.
Yeah.
That it says something to the effect, and I was going to object. It says something about McMiller's funeral is going to be private. and his mother doesn't want Thug there or his money. And I don't see how that should come in. That would be a hearsay statement. I don't see how that furthers a conspiracy. If it's not on that call, then I have the wrong number. I have 513.
It's not that call. No. Well, let me make sure.
Well,
Hold
I
on.
think it is.
No, I'm sorry.
Well, it may not be, I don't know.
So
No,
there's
no,
two
no, no.
there's a remember, there's a page number and a reference number. I'm
Right.
with Mr. Steele. I have 513, and I think we're going by the call reference number.
On the sheet.
So the
Or
call
no?
reference number for 513 is the call that I'm just speaking of, which is on March
They came
16th.
through and they were gonna come back.
It's-
Yes.
Getting ready to
I
write
have the
them
same
up.
date as well. You're on
Okay.
5/3/16.
What time on March?
So the call,
9:41?
9:41, but we can listen to the call, but I just listened to it and I don't hear
We're not
anything
going to
about.
play it. If it's not an issue, there's nothing to discuss, but if it is an issue, I wanted to raise.
Okay, because part of it, when it was described on this big sheet that y'all shared with everybody, was them laughing about the drinks murder.
Right. And I have that happening at 4 minutes and 20 seconds into the call. So, and I'm not saying Ms. Hilton's wrong. Maybe this call isn't that long, but the parts that you wish to play, can we just play it?
Yeah.
Because there's a lot of confusion.
Okay, because then I guess the part about the drugs comes after all of this. Okay, all right. Because I definitely wrote down that there was something about, y'all said there was a non-hearsay purpose and you wanted to show something about flipping the car and laughing, but if y'all aren't gonna get into that anymore, then that's fine. And I think this one and the one before reference a quay, and understandably, there's some concern about confusion. Is it gonna be clear?
And I'll apologize. I must have listened to 512, which is the 2 minute and 40-second call, because they talk about drugs in that call as well. But it looks like I was supposed to look at the call under.
The one at 9:41 PM.
Of course, indulgence for one moment. Let me just-
No, that's the 502 is also 512, and that's talking about Big Nick's. And that one also says something about not having to drop on people. But we ruled that one, or I ruled that one could come in. But there was a concern about whether we need a 105 with regard to Quay or Qua, which I'm happy to consider.
On call at lunch, I listened to the 2 minutes and 40-second call, which is the call right above it. If we could have
the one that says 502.
Yes, Your Honor, at 6:49. If I could have a brief moment, I can listen to the correct call, Your Honor. So that I
Well, we-
apologize.
Okay.
Talk about the same thing twice.
Only other one we had talked about but not made a decision on was the nested hearsay one. Do we need a quick break? Why don't we all take a quick break? 10 minutes.
Okay, guys, I have been in court, running around on airplanes, all kind of stuff. And I finally sat down to eat. I've settled so many cases today. If you're my client and you on here, you'll be proud of me today. Like I said, today, I think today is it's a slow day. It's a non-jury day. I think it's interesting that, well, I don't know, but a lot of things we got to come back to. I know we had a poll going. It's been going all day. How many of you guys think that the state is going to have that brief ready? We got a good, um, we got a good denial on some evidence that the state was trying to bring in. It was a strong denial. So, sorry, y'all, I had to take a phone call.
take way longer than 3 minutes.
I'd just like to recap if we can before Ms. Hilton. Can we recap where we are just for a second?
Sure.
You
And there
can
she
help me
is.
with that, please, Judge. My notes from our previous sessions said 513 was open, 624 was open, 806 was open. The state today said 1109, and I'm going from the reference numbers.
All right, hang.
They weren't going to try to get that in. Was there a ruling on 513?
That's what she needed to go back and
Okay.
listen to again. So that's what we're about to hear from her, whether she's narrowed.
Okay, great.
And then, okay, so read those out to me again.
All right, 513 we're going to deal with right now.
Yeah.
624. I had that, my notes reflect that that was open as well.
What,
Open meaning you hadn't ruled
we
on.
haven't,
Yeah.
yes, agreed. That's the one that's the nested hearsay, right?
No, the nested hearsay, well,
Oh, okay.
it nested hearsay was 2119. That's on the next page.
Okay.
At least that's the one that,
Yeah, you're right.
so I'm trying to
So
figure
what
out
else? So 513 /
624.
6, which is also 635. It's very complicated with these
Yes,
two different numbers.
806 and 820.
806, yeah,
I had,
you're right. I have a note by both of those that said
So there's no-
tomorrow, which we apparently never
Right.
got to that
so
tomorrow.
there's no ruling on those yet.
Correct, no
Okay.
ruling yet. And on both of those, if somebody from the state could listen, I think the question for both 636, I don't know which reference numbers which, but 624 / 635 and then 806 / 820, I think, was who is the other talker? That's what we were waiting to hear back on. But yes, that matches up with what I've got as well, Mr. Harvey. All right, so if you're ready on the 513, 523 one, we can do that one.
So I can answer the 624 and 806.
Okay.
We just know right now there's a person named Unc, but we don't know who that person is.
Okay. Name, what's the first name?
Unc, like they call him
Unc, okay, which y'all knew also, and they don't know who that is. And so are y'all asserting that Unc is a co-conspirator, or you have no idea?
No, we're not going to start because we don't know who.
Okay,
Unc is.
and so then is there some other basis under which you're asserting those two, whatever they are, conversations could come in?
One second, Your Honor.
Okay,
No, 624, 806.
getting to sorting through the evidence exhibits today.
And also, Judge, while the state is discussing
Sure.
among themselves, I think that's almost as far as we got.
It is, because we
Um,
stopped, we stopped with, we got much further, but we stopped with the one that is 2119, that
Right,
is
that's-
that nested hearsay.
Yes, that's what I mean.
Yeah,
And then there's a page
That's
and
as far as we
there's a
got.
page and a half.
I know,
Okay,
after that.
yes, that's,
Yeah, no, there are many, many pages after that. 3 pages after that.
Judge, forgive me for missing the portions of the conversation that Mr. Harvey was just having. I was looking with my colleagues at number 624 and 806. Are we correct that those are the two that the court is now inquiring about?
Ye- As to, yes, Unc.
513 and 513.
No, we're not, we're gonna come back to
Okay,
that one.
all right, sorry.
Okay.
That's-
So,
Go ahead, sorry.
so, Your Honor, in advising the person that he calls Unc about the search warrant at Waters Road and Ms. V being on him, one, and I'm not yet through in saying this, but one, the familiarity of the person to whom Mr. Garlington is speaking with Ms. V, and without further explanation as to what Ms. V being on him means, it becomes apparent that this is a person who is aware that at the time, Investigator Vivarito is someone who has been, who's had Demekion Garlington on his radar. So Demekion Garlington obviously is talking to someone that he trusts. But the 806 call where Demekion Garlington is telling the call Unc that he said on the news they got 2 and 1 outstanding warrant. They just hadn't said my name. He just wanted to make sure he didn't know what was going on. You've made it back, okay. And the person advising him to keep it to your chest, and that Mr. Garlington is advising that person that he's trying to make as much as he can now. These words all lead us to conclude that this person, though we don't know his identity, he is a person on whom Demekion Garlington is relying, who he is getting support and advice from, as it relates specifically to the conspiracy. Arguably, in telling Mr. Garlington to keep these matters to his chest, this person that he's talking to knows all about Waters Road, knows what it's there for, knows that likely knows about what was being kept at Waters Road, given that he's not asking, wait, what do you mean? What about Waters Road? Who is Ms. V? So this could be, though we don't know, and we're not trying to assert that this is some person we know is, YSL. This seems like, reads like, he listens like an unindicted co-conspirator, someone that he is relying on and trusting for information and guidance as it relates to his actions in this conspiracy. Those type of actions fall under what courts have deemed statements in furtherance of the conspiracy may consist of. Because of that, because of the type of information he's sharing and the feedback he's getting and the role that this person seems to serve in Mr. Garlington's life, these 2 statements, we'd argue, would fall up under the co-conspirator statement exception.
All right. Does anybody need to hear them again?
I don't know. It seems to me that if we don't know who this person is, I don't know my understanding of the case law, and I don't have it, but I'm certain of it being the law, and I can get a case, is the statement itself cannot establish the conspiracy and the prerequisites of 801 D2E. So without knowing who the people involved in the conversation are, and just going by the conversation itself, I don't know if that well, I do know that that could never satisfy the requirements of 801 D2E under our Supreme Court precedent and state in case law in Georgia as well.
I
What do you
don't
have to say to that?
I do not agree with that assessment at all. In 502, this is an 11th Circuit case, but United States versus Miles 290 F3D 1341 is from 2002. The courts have said in its admissibility evaluation, the court may consider the statement itself as well as extrinsic evidence to qualify the statement need not be necessary. This is not what Mr. Sharp was putting forth, but it's, I think, helpful.
It's exactly what I just said.
The statement need not be necessary to the conspiracy, but needs only to somehow further the interest of the conspiracy, Your Honor. And personal knowledge of the subject matter on the part of the declarant isn't required, but it talks about the statements of unindicted co-conspirators. Specifically, Your Honor, I think
All right, we know
Statement
statements of unindicted co-conspirators
Right.
can come in if they otherwise qualify. What Mr. Shard is saying is the conspiracy and it being in furtherance can't be established by this statement alone? Is that what you're saying?
Correct, Your Honor.
I haven't seen
It
that.
can't bootstrap itself, and
right.
I'll get you.
So,
All right,
Your Honor,
he'll get us a case.
So-
and then we'll take it up.
I'm reading
It's not in
from,
the
It's
statute.
in, yes, it is. The statement must be considered, but does not by itself establish the declarant's authority
Your Honor,
under the existence or scope of the relationship or the existence of the conspiracy or participation in it.
Your Honor, I'm reading from United States versus Rivera,
Okay, and I'm reading from the
Hang
statute.
on, don't talk at the same time. Let me pull up the statute. That would certainly be the easiest place to go to if it answers the question.
And I have cases, Your Honor, as
All
well.
right. Give me a second. As the contents of the statement shall not alone be sufficient to establish the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered.
and so, Your Honor, the state is not tendering the statement. We in no way suggest that the content of this statement alone establishes a conspiracy. The conspiracy, we'd argue, has been shown by evidence that we've already presented at trial and more evidence that we will be presenting later on. What the content of the statement does show is that the unknown party to whom Mr. Garlington is speaking about things that the conspiracy inherently kind of involves, i.e. Waters Road, Miss V looking for him, the outstanding warrants, all of those things that sort of the conspiracy encapsulate. When he does that, he is receiving, he's giving the statements and he is receiving assurance, and the statements made between the two are serving to maintain trust and cohesiveness among them, or inform inform of the current status of the conspiracy, which furthers the ends of the conspiracy, so long as the other requirements of 801 D2E are met. And that's coming from a First Circuit 2012 case, United States versus Rivera, RIVERA-DONATE at 682 F 3rd 120. Especially when you hear, given everything Mr. Garlington is saying, I mean, he's literally just telling the guy, like, you know, Ms. B is on me, blah, 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 blah. And of course, the court and anyone can listen to it. But he just wanted to make sure, you know, he didn't know what's going on. You made it back okay. The man is saying, keep it to your keep it close to your chest. And Demikian is then saying, I'm trying to make as much as I can now. This particular case that I'm about to point out is a Third Circuit Court of Appeals case. So it's not anything that the court has to follow. It's just sort of instructive, but it does speak to the United States versus Lignelli, Lignelli. And the site is 660 Fed APPX 118. It's a 2016 case. There, the court found that a statement made by an unknown speaker could qualify for the co-conspirator exception if the government establishes that the speaker was likely a member of the conspiracy alleged. And in United States versus Helmel, which is an 8th Circuit 1985 case, and Helmel is spelled HELMEL, and that site is 769 F2D 1306 at 1313. What Lignelli says or cites Helmel for is the parenthetical. What is essential is that the government showed that the unknown declarant was more likely than not a co-conspirator. And I believe that the prescriptions that were described earlier regarding the statute alone, the statement alone being used to establish a conspiracy is not one applicable here.
Okay. All right, can I hear the statement again? It's been a while since I've heard it. Yeah.
And Judge, just so that the court is aware, since we are researching in real time, there's a notice at the front of Lignelli that says not presidential opinion under Third Circuit Internal Operating Procedure Rule 5.7. Such opinions are not regarded as precedents which bind the court. I want to make the court aware of that notice.
that? What's going on? Where you at? In the apartment. You got your family? Hell nah. Nah, I got my shit. Just got down. What's in? So no folk got down. Where you at? I finna pull up. The meat on white out there. Yeah. Nah, everybody out here though. I ain't got no fire. I been got the chillin' until these folks on. You say you trying to do what? I said I just been chilling trying to see what these folks on before I get another fire. What? Yeah, man, fuck you. Nah, cause them folks they got damn man. That shit, them folks they hit the spot that they went in there but still just like what Miss V, boy. I know they hit that bitch. Yeah, but now I just feel like Miss V on the nigga, boy. So I'm really trying to move cautious. Well, definitely. You know that wrong. Yeah. And she saying y'all see nothing. Well, you know she on y'all. Who else you say out there? Big regular, big, zoo them. Big out there? Yeah. Alright, here I come. Alright. Yeah.
Your Honor, I'd also point out a thing I left out. The person to whom he's speaking is also advising Mr. Garlington, giving him more information about the circumstances out there that Mr. Garlington was describing at Waters Road, where he's talking about who all else is still out there. So that adds to our argument as well.
All right. Let me hear the next one, if you don't mind. Yes.
Hello?
Hello?
What going on?
What's up?
Hey, what's up with you? What happened?
Who is there?
That
My bad. No, look. I just seen the news. I seen the news. They said who they got, and they said one they got on outstanding one. They ain't say the name.
Oh, okay.
Yeah, well, I just feel.
Well,
I just want to make sure I don't know what's going on.
yeah, you know I'm back though. I just really let you know too. I was back.
Yeah, you made it back.
Yeah.
Okay.
Yeah. Well, shit. You just keep that shit on to your chest, really, and hold on to that paper.
Yeah, that's what I'm doing. I'm just trying to make as much as I can.
Yeah. Exactly. Right down, I'm here though. I'm gonna let you pull up on me. Check out down, answer the phone.
All right.
All right.
And if the court notices, I think Mr. Garlington does not even start giving details until he's reassured that it's Unc, who of course then tells him, you just keep that close to your chest, and so forth. So I think that both of these calls make it apparent that this person is giving information that serves to reinforce the underlying purposes of the conspiracy itself. They're providing reassurance. They're informing of what's going on, that is putting members of YSL in peril. Ms. V out there looking for Mr. Garlington. He knows who she is. So we believe that these all form to tell the court these are statements of co-conspirators that should be admitted. And yes.
I'll hear any defense argument. And Mr. Sharp, I think with regard to, and Mr. Harvey, the issue of the statement alone can't establish the participation of the declarant. I think with regard to Garlington, there's certainly more. And are y'all offering like both sides of the conversation?
In order that they understand what's going on, yes, both sides are being offered of the conversation. The most important part we feel is what Mr. Garlington is saying. His words are more pertinent because they're reflecting a knowledge of something that just took place. Is very important and close in time to acts that are alleged via overt acts or counts on this indictment. So Mr. Garlington's words are the most important ones, but the other ones are needed for context.
Can I just respond very briefly to this? It's still just the statement itself. And every court, the United States Supreme Court and our Supreme Court, have specifically said in determining the existence of the admissibility of a co-conspirator statement, the trial court may consider both the co-conspirator statements and independent external evidence, although the co-conspirator statement alone does not suffice. That's specific language from Dublin versus the state at 302 Georgia 60, pinpoint site 63. But that's the rule, and that's the intent of the rule in the code. I have heard nothing but argument about the statement itself, but no external evidence other than the statement itself. And that is simply not enough with an unidentified party.
Right.
Period.
Yeah, so I think with regard to whomever Unc is, that it does sound like all you're relying on to establish that Unc is a co-conspirator, and therefore the jury can consider what Unc is saying is what he's saying and what he seems to know that's based in the statement itself. So I think that if this comes in, if these two come in, there needs to be an instruction that, you know, it's only Garlington's statements that you can consider.
In his, hang on, I'm sorry. In as much as Unks is providing context to what Garlington's statements are, one moment, Your Honor, I'm reading a statute. If the court would indulge me, I apologize.
Your Honor, if I may jump in, I just have actually a couple cases which I think maybe. All right, can you wait just a second? Because I think Ms. Love's trying to absorb the statute right now.
Almost, Judge. I apologize. Making sure that I'm reading the right area. It's the portion of the statute that says the contents of the statement shall be considered, but not alone sufficient to establish a declarant's authority under paragraph C, which is not applicable here
Right.
because we're not talking about
D
that.
is not applicable, and then, yeah.
Or the existence of the conspiracy and the participation therein of the declarant and the party against whom the statement is offered under subparagraph E.
Right.
So if I'm reading this last portion that Mr. Harvey references, we're not trying to establish both
The existence of the conspiracy, right.
Right.
That part's not the issue.
and the participation therein against of the declarant.
That declarant being Unc. The Garlington statements are one thing. I mean, y'all have other evidence that Garlington is a member of this conspiracy, but you don't appear to have others for Unc.
So it's not, and I hesitate to say it, but it's not so much Unc's statements that are important. Unc's
Right.
statements are the ones that give context to Garlington's statements. And so to the extent that you need to hear what Unc is saying so that you know what Garlington is responding to, that part is important. So to the extent that I guess an instruction that Unc's statement, you can consider them for context for Garlington's statement. I mean, I'd have to work through that, but
Alright.
my reading of it is that the declarant of concern is Garlington, and we're not really that concerned about Unc.
Well, you might not be that
I know
concerned
that.
about
I know
Unc,
that.
but if the jury's gonna hear it all, then why don't you look at both of those portions again and see if there's some way, if it's Garlington's that you need to have just Garlington statements come in, and if not, what limiting instruction would be appropriate.
I appreciate the opportunity. We will. Thank you.
All right.
And Your Honor, I was never able to verbalize, maybe for the record, maybe to persuade the court,
Okay.
about why I didn't believe that Garlington's statements were admissible under 801 D2E.
Okay.
And my argument, I think the fact that we don't know who Unc is important, because certainly knowing who the receiver is, knowing who Garlington is speaking to, would better educate us as far as whether his statements are in fact in furtherance of a conspiracy or not. And at least the second call, he seems to be calling Unc and just saying, hey, I heard I have a warrant. You know, what should I do? And Unc seems to say, you know, just stay safe and get money ready for a lawyer. But it seems that Garlington is concerned about his own legal troubles or the possibility of being charged. I don't really find that as furthering any conspiracy. That seems to be concerns about himself and his legal future and and concerns about being incarcerated. But I don't view that in any way, shape, or form as furthering any conspiracy. And especially since we don't even know who Unk is, but me calling, if I was involved in a conspiracy, me calling my literal uncle, who I reach out to for advice, and him saying, hey, Max, if you think there's a warrant, start getting your money ready for a lawyer and, stay in the house. I don't know how me asking my uncle for advice would be furthering any conspiracy. So I don't believe that Garlington's statements, at least with that second call, meet the requirements of 801D2E.
Yeah, I think that Mr. Sharp's analysis leaves out, if I'm mistaken, forgive me, and he can correct me. I think it leaves out telling him what's going on at Waters Road, like who else is still out there in that second call. So he's informing him of circumstances that still exist that put members of YSL who incidentally were hiding in and then ran from and apparently took contraband from. And this is our assertion that we believe the evidence will show. So I'm not trying to put something in front of the court that, is just my word is bond. But Unk is advising Garlington about circumstances that continue to place YSL members in peril. And Unk obviously has knowledge of what this conspiracy is. He's not asking any kind of questions.
And then Garlington's responding, he's wanting to make sure what's going on and is told to keep it to your chest. And frankly, he doesn't need to be talking to a co-conspirator.
I agree.
Okay.
I agree, but I still think knowledge of who he's speaking to
would certainly, sure,
and
further elucidate things for us, but it's not necessary for the admissibility of this statement. This, I think, would come in under, I can't remember the name of the case right now, but the case that's, I think the state cited where, somebody's getting support from their girlfriend or something about, how to handle the fact that somebody might be on to them. And it's not exactly the same, but it does sound like, frankly, it sounds like this is somebody who knows a whole lot about what's going on at Waters Road, and they're sharing information in order to stay hidden. I don't think.
Respectfully, so this is the day after the Waters Road shooting. So this is not while Waters Road is in practice. And he says, I'm pulling up. And I think a very common sense reading of what was said there is he's pulling up to where Unk is and wants to know who's at Unk's house. The state keeps saying, alerting about who's at Waters Road. That's not the way I hear that call at all.
The court should also be aware that this is the day that police go to search Waters Road. And I think in another call that the court heard on in our previous hearing, they find that the sticks were removed, like they took guns and stuff out of the Waters Road the night that they were there initially just to check on the occupants. And nobody was willing to come to the door, but they found everybody hiding in cubby holes and stuff. And so in subsequent calls, I think the court heard last time that they didn't get the sticks that were in the attic or wherever it was. And now Unk is talking about, my reading or listening to it, Unk is talking about who's still around, and Mr. Garlington is talking about Miss B.
I think whether he's saying who's still at Waters Road or who's at wherever he's about to pull up to.
I just want to make it clear for the record. This is not the day, to my understanding, that Waters Road was searched, okay? And the state, I would love to hear their evidence, whoever Unk is, that he was at Waters Road on that day, because it doesn't exist. He's talking about where Unk is, and I'm pulling up to you, and who's over at the house, which is not furthering any conspiracy. But, I understand the court's ruling. And I just want to state that for the record.
All right. Thank you.
Your Honor?
Yes.
I did just want to bring attention to one case. I don't know, perhaps frames it in a bit of a different way. Statements are admissible when the state establishes a prima facie case of conspiracy independent of the co-conspirator statement. I think looking at this, if we look directly at that standard, let's take out what the statement is. What evidence is there to make a prima facie case? Nothing. And the case I'm relying on for that is Williams versus State, 293 Georgia, 750 from 2013. There's another case which quotes the same language. It's Newer Franklin versus State, 298 Georgia, 636, 2016. And in both of those, they go on to discuss some of the other independent, separate, apart from the statement evidence, which did justify using that co-conspirator exception. But here, where we have no information about Unk except his name is Unk, I don't think the state can make that prima facie showing.
I don't either. I mean, I think that with regard to Unk, there's not enough. So that's why I've directed Miss Love to figure out whether she can either get in the Garlington statements without Unk statements, or if not, come up with some appropriate limiting instruction.
And we can do that, Your Honor, and just as a matter of the prima facie showing of the conspiracy itself.
Yeah, no,
we're not dealing with that.
I get that, and there's enough to show that Garlington is a co-conspirator and that there's a conspiracy. This
Thank
is
you,
just
Judge.
with regard to Unk, as far as I'm concerned. So let me write myself a note. And then we'll circle back to the 513, 523 one.
Thank you, Judge. And this case that Ms. Abbasi just cited, does the court mind providing that site one more time?
Franklin or Williams, or both?
Both, please, if the court doesn't mind.
Franklin versus State. Franklin versus State, 298 Georgia, 636 from 2016. And Williams, 293 Georgia, 750 from 2013.
Thank you. And I think that the court already has Kemp.
I do, thank you. All right, let's go back to the 513, 523 or whatever it was, one. So the narrowed version, that's what you were gonna do, was figure out.
So it appears the narrow version is going to be from roughly 34 seconds. Yeah, there's about 3 sections around, so I'll play. The first will be from 34 to 354.
I don't need to hear the drug part again. We already rolled on that.
I believe we're past the drug
What Friday? Fucking free. Last night, well, you know, I wasn't even gonna come out. Man, you like goddamn pull up. Ooh, finna be on one. Goddamn. So y'all was in there? In boy, about 6, 7 deep. Two, they had them pulled out, boy. Damn, that's some food. I thought they already went over there and shot one upside. They did, but still, man, I'm following some everyday shit. They double back. Oh, it's my, oh, yes, right? Yeah. Ain't nobody went next, right?
Oh, no, I heard it a couple days ago. Somebody they said they went over there.
Oh,
That one I ain't
yeah,
know.
nah,
What you
yeah,
said?
nah.
You said they just went over there last night.
Yeah, but we down, man. I'm like, yeah, man. Boy, I wasn't even finna come over here, man.
Yeah, you talking about? Yeah, I ain't even know nothing about this.
Yeah,
Shit.
man, look, we like to hear. We think we like, all right, they gonna come back through. Man, we think they gonna come back through, so we can hit that motherfucker up, man. 12 pull up, man. Hey, right?
In the house?
Yeah, I'm like, yo, we hit them folk like, cause we got our lights out. Them folk like, we gonna have to come in. We gonna have to come in. Goddamn, make sure ain't nobody dead. Man, hit the back door like, hey, boy, I'm on parole, man. All this shit in here, man.
Hey, you talking about?
Hey.
Like, y'all have to come in.
Yeah, now we just heard them talk to the other officer like, yeah, we go in, make sure ain't nobody. Man, it be them up under the house. Goddamn, man, about 4 of us in the house. They keep saying, man, you don't go out. I'm like, man, I got me fucked up, man.
You took out right?
No, I hit the back door. Them folks it was on both sides. And I was just like, I seen them on one side, 'cause I was just gonna sit in the car, in the yard.
Yeah.
But I seen them looking at the cars over there, go to the other way. They know they was over there. I'm like, hey, come here. I'm like, hey, man, I just heard some gunshot. Yeah, I'm like, hey, man, I just heard a gunshot, man.
Okay.
Yeah, that's where you come from, like the wood. I'm dry here. It pouring down rain. No folks like, man, you ain't wet at all, man. I'm like, man, I'm telling, man. I was in the woods. I don't know how I ain't wet. I was in the woods. But I ain't no salvage.
Man, what?
Y'all check that out, found them guns. I went in there, well.
Yeah, man, I ain't got nothing to do with
They
that.
still went in there, though. They checked that was good, well. It be safe.
Oh, they ain't certain.
They'll make sure.
They just looked around.
Make sure nobody dead.
Yeah, so when nobody know when they went in?
Yeah. They found now. Goddamn, look Quay and other name.
Okay.
Yeah. I'm like, yo.
What they at the house?
Yeah. From the pop out for Coat on her. Coat, so they got a little video shoot.
And we'll stop it here. We'll fast forward to the next relevant portion. And we'll say, Your Honor, Little Quay is not either Mr. Nichols or Mr. Huey. That is Quatez Arnold, who was at the house during the shooting. That's
Are y'all gonna stop and tell the jury that?
That will come out through Investigator Viverito, who was all in the house prior to this call coming in, because Investigator Viverito will testify as to who was there when it occurred. But we've always established, even when we did the motions hearing, who was at the home, and it was never Mr. Huey or Mr. Arnold. And so that will come out.
Well, couldn't you just stop it 3 seconds before that Little Quay part gets said?
Right, and we can either remove it, or we can do a stipulation so that it can be, so the jury can hear it in real time, so that the jury doesn't develop.
Okay.
Yeah, because I mean, Viverito may not be coming till sometime later.
Well, this call is coming in through Viverito. So none of this.
Regardless, I think it's stipulation.
Yeah.
This is not either of these people that are on trial would
We'll cover
be
that.
safer than, if you can either do that or you can take that part out.
Yes, we can do the stipulation and ask her. And I mean, we all agree that it's not either of these individuals.
I have a solution.
Don't play it.
Don't play it at all.
Yes,
But
because
it's important, Little Quay.
it's two parties giggling and laughing about what happened at a prior event. There's no informing anyone for any purposes
I
of
know,
further any
I wouldn't-
conspiracy. It's just spilling the beans.
Your Honor,
and
and
giggling.
I would say, though, that Quatez Arnold is important because that individual is in a previous video that we have with Quarmavius Nichols that's already in evidence with Quarmavius Nichols.
But just because something's important, just because something
as to who all was at that house, right? Right? Hello?
I'm sorry. I apologize.
You are gonna have the detective testify to that person being at the house anyway?
Yes.
I mean, I didn't hear anything in this portion of the conversation that does sound like anything other than, man, can you believe what happened? So this portion is out. Yes,
So it'll be out, Judge. as
I
opposed-
know, I hadn't listened to that other portion yet.
No, I mean, she was on the cusp of addressing Mr. Sharp's concerns and was wanting to make sure the court knew who was in the house, but she had another argument she wanted to make.
Did explain.
Thank you, Your Honor. Yes, Your Honor. So when you hear this portion of the call, Your Honor, they are boasting and bragging about what happened in that home, the fact that they were hiding from the police, or he was hiding from the police with the other members in the house. We believe that was stated to obtain confidence between co-conspirators. We do believe that this person is the Waskin Wright, who I mentioned earlier. Your
Well,
Honor.
nonetheless, it's out. Let me listen to the next part.
The next portion starts at 4:18, Your Honor. Start a little bit earlier.
Too much going on, oh yeah, nigga got to see what's going. They flip nigga get up on the bridge in the Ville.
Yeah, I heard.
Yeah.
Yeah, I heard. Where the hell you at?
I'm right here.
So, Your Honor, that's when they say they flipped
Right.
under the bridge under burden. We believe that they are referencing and laughing about Shamel Drinks because he just got killed under the bridge, which would be the I-20 bridge in Mechanicsville 2 days before this phone call.
Okay, and you had said before that you had some non-hearsay purpose for it, that wasn't even hearsay, that you, I mean, I don't know what it was, but you said that there was some non-hearsay purpose to introduce that, so that it didn't need to come in under an exception. I don't know, I wrote it down, I don't know what it was.
I got it. Your Honor, we believe that the fact that they are speaking in code and laughing about this particular murder when they say, I heard someone flip the car in Mechanicsville, and then there's like a pause, and then they both laugh. Given that this is again 2 days after the murder of Mr. Drinks, and we believe that Mr. Garlington was a part of that homicide, the fact that they are laughing about that particular instance at that time is a non-hearsay purpose of why this portion of the call will come in.
I'm gonna exclude that. So that drug part that we talked about before is the only part of this conversation that is gonna come up.
And there's one more portion, Your Honor, I believe this is the portion that Mr. Steele referenced earlier today.
Oh yeah, they were like, they say his mom like, well, she don't even want him to come.
Yeah, they said she don't even want to call.
Yeah, I already told them for but folks' family gonna be talking crazy anyway. Like they gonna be like, we don't want no money, nothing. Like they gonna be tripping.
Yeah, you know how.
That's just how that shit be, yeah.
Yeah. All right, damn.
That's why I know he just like, man, he just respect it. He just know how that shit is.
Yeah.
Yeah. I never said what the hell you had going on. That shit, you know.
I'm pull up on you like tonight or tomorrow or something.
And Your Honor, that portion is Mr. Wright and Mr. Garlington speaking of the murder or the funeral of Christian McMiller, and it's Christian McMiller's funeral, and that Mr. McMiller's mother did not want Mr. Williams to be present at the funeral. We do think that that is relevant, given that we believe that Mr. McMiller, Mr. Ford's murder was a direct result of Mr. Bennett being stabbed in the jail, and we do believe that the evidence, we believe, will show that the stabbing at the jail was done at the permission of Mr. Williams, so it was a trickle down effect. So we believe that Mr. Jaden Myrick, who actually stabbed Mr. Bennett, asked for permission through Demekion Garlington to Mr. Williams to get permission to do that stabbing. That stabbing occurred once that stabbing occurred at the jail, and the information was released to the public on early in March, on March 2nd or March 3rd. Only about 7 days later was Mr. Ford and Mr. McMiller murdered by YF and Associates, and then the other murder happens when Mr. Drinks after that, Your Honor. And so the fact that Mr. McMiller's mother does not want Mr. Williams at the funeral, I believe, is relevant to show that there is a belief that he is the cause of the murder of Mr. McMiller and Mr. Ford.
And Your Honor,
I
in
didn't-
addition to that, I see the question, you said, I'll be quick, but Judge, the fact that he is bragging about what we believe to be the murder, and that he is informing the person that he is talking to, that they were gonna come back and they were getting ready to light them up, we believe falls under
that in that clip.
So
It
part
was-
about
That
the,
part is
the
fine.
funeral
Oh,
is
the
definitely
funeral is
out.
not.
If there's some other part where somebody.
That's the
is
first part,
bragging
Your Honor, I
on-
think is coming in,
Okay.
that you allowed. My understanding is everything from the drugs to everything before Little Quay can come in when we talk about what it,
No,
or,
no, nothing from this call is
The
coming
drug
in.
part is the only part that can come in.
but Your Honor,
Yes.
but there's portions of that first part where they discussed that they were going to get ready to shoot back at them, shoot back at the opposition when they were going to come through.
And
So earlier in the call,
When they're talking about shooting up Big Nick's, is that this part?
right, so before,
And being surprised nobody got hit?
right, but Demekion says we were getting ready to shoot back at them, but it ended up being the police and not the opposition coming. And so I think that that's important, that they were willing to shoot back at them if they came back through
Your Honor,
And,
through the
and,
location.
and to augment that, Your Honor, just to add a little to what Ms. Hilton just said, them boasting and bragging to one another, we would argue our statements used to obtain confidence between co-conspirators, and it is serving to up and maintain trust and cohesiveness among them, and to inform them of the current status of the conspiracy. And in doing so furthers the ends of the conspiracy. As
Okay.
Ms. Hilton.
Thank you. I
Thank you.
understand the argument. I appreciate y'all perfecting your arguments for the record. My ruling stands. So the drug part can come in, and that's the only part from that wiretap. Now, I have a note that the one above that, 502 or 512, there's a reference to a quay in that one also. And there was a question whether there needed to be a 105 instruction, or there could be a stipulation that as to who that was about, if y'all know it wasn't. Yeah.
In Your Honor, I'll just add to that. My notes indicate that the reference to Quay is that he's locked up in that call. So
Okay.
that made it
So does that
especially concerning.
Do y'all know who was being referenced there? Probably.
That is who was at 2380 Waters Road. There were outside of Mr. Garlington, Mr. Stillwell, and Mr. Farley was Quatez Arnold. A gentleman named Atty Kay that's escaping me right now, one other individual. So every time at Waters Road on March 16th, there's only talk about Quatez.
All right, and so y'all are gonna enter a stipulation that says it's not either of these defendants?
You can't.
Okay. I mean, if it's a stipulate,
I mean,
would you rather it be that? I can't hear you.
I rather that it not come in because it's an assumption, Your Honor, that they're saying we believe, we think that it's Martez
Well,
Arnold.
no,
And there's-
it's gonna be a stipulation that it's not either of these defendants.
And again, Your Honor, we intend to introduce testimony through Investigator Viverito, who was at the house when she arrived, along with the responding officers.
Okay.
We'll talk about who was detained on that day.
So is it gonna be a stipulation that it is whomever Arnold, the Quay referenced in here?
Yes, that is Quatez
So-
Arnold. Yes, we
okay.
will stipulate that the Quatez Arnold, that there's, the Quay that they're talking about is Quatez Arnold.
So there's another Quay that's being referenced. Fair enough. Thank you.
Okay, so that takes care of that as well. Make sure y'all get that stipulation together before that gets played. All right, let's get this nested hearsay issue taken care of before we break for the day.
Judge, can I ask how inclined the court would be to entertain a request to do the nested hearsay? Not today, but on another day?
Why?
Because I want to make certain that we have our most cogent, succinct, and clear argument for the court, because we're gonna get one go at it, and I want to make sure that we do it properly.
Well, hadn't y'all already briefed it?
Judge, we have briefed something similar. That's what we were looking for earlier. But I don't want to read a brief to the court. I just like to give about 4 lines to the court if I can, if the court would indulge us and allow us to just argue it on a different day. That particular one, because it has layers, and I want to make certain that we say it clearly and quickly.
I couldn't hear. Are we just saying, hey, I need more time because I haven't briefed
Sure.
it yet?
No, Judge, I'll be clear, and I'll say it loudly enough for everyone. We are asking to be allowed to make this argument on a day different than today. That is it. Please.
And
Thank you.
the reason is?
And the reason is we would like the opportunity to make certain that our argument is as concise as possible. We don't want to be trying to read a brief and distill information. We have briefed a similar subject. We would like to respond more clearly than we believe at this point we would end up doing today.
Well, the state has already sent what they thought was the issue to the court, which was 2 pages from a brief that was filed when in November of 2023, maybe? No, 2022. And that was in response to Mr. Copeland's statement. So the state has had plenty of time to come up with this. And you know something, we've been asking since December of 2022 for the unindicted co-conspirators. They were supposed to have been given to us well over a year ago. And now we get in here and unidentified people are being identified now as unindicted co-conspirators. And no, I object to any additional time because we got some unknown person referenced in this phone call. And I don't want to hear anything about, oh, well, now we know who the hell this guy is. Now we know who we're referring to. And now we know that this dude is an unindicted co-conspirator as well. And I don't even know whether it's a dude. So let me undo that reference.
And
All
I
right,
apologize.
and the unindicted the whomever it is that's unknown that you're referencing is rel?
Yes.
Or what
yes,
sounds like rel?
Yes.
So Judge, I'm sorry, we got the 9:30 PM Monday, 9/9 supplemental brief by Mr. Harvey. And we want to just address everything and be concise. That's all.
Okay.
Okay.
And you know, y'all have had this for a couple of years now, and you indicted it. And you've had this wiretap.
All right, you don't need to be talking to her. So, I mean, I think your biggest sticking point is probably the fact that some of this is only coming through rel. And we're probably gonna have the same issue we just had with UNC, which is unless you're gonna be able to tell us more, it's only this statement that is going to be able to establish anything about, and obviously rel is very knowledgeable about what's going on, or they wouldn't be talking to rel about this kind of thing, but that's only the statement that establishes that.
So if we could be allowed at the same time that we address, that we provide the court the additional information the court said it'll allow us to do on that one, the call, or if we have to do it before, I'm just asking for an additional time to address the last call, just this last one.
Okay, so I haven't given you any additional time at this point to do anything about the UNC call, right? That's out.
No, it was out. I thought that the court had said something about redacting, and if there.
Right. Yeah, yes, figure out a way to, yes. Okay, I'm sorry, I misunderstood you. I mean, honestly, I'd like for us to do, what do you want, to just skip over it and move to another one?
Yes, if we can, and then come back.
Well, we certainly have 3 more pages to get through. Have y'all looked to see whether you really want, or you really feel like all of what's in this is necessary to establish different issues? I'm sorry, yeah. It is 3 pages. Have y'all done that yet?
So the court repeat the last part.
Yes. So we still have 3 more sheets worth of this printout that you gave us, which is probably 10 calls or so a sheet. So maybe 30 more pieces of a call. Have y'all taken a careful look at that to see whether you really need all of this to establish the issues in the indictment? Because, I mean,
So
this is going to take a long, long time to get through.
And so obviously, Your Honor, we are trying as the court, as we go on, to pare down where we can, as much as we can, but at the same time, keep defense apprised of things that we may use so that there's no argument that we didn't, but we can look at it some more.
I'd like for y'all to start making some decisions about, oh, we're not going to use this. So have you done that evaluation yet?
We on a lot of others, these are the ones we said we wanted to use. So yes, we can do that more. And as it relates to these that the court has in front of it, Your Honor, yeah, we'll give it another pass.
Okay.
We'll
thank
give it
you.
another pass.
Appreciate that.
Does the court have another day because, that we can just, or do you
Have
just want us
another
to send the
non-jury
one
day?
to us?
Oh.
Yes.
I mean, can y'all get that done by Monday too? Or no?
My team is saying we're gonna.
I mean, I'm asking.
If we could have a couple more days, but if we have to, we will.
That's,
We'll-
I mean, get it, we're not gonna be able to discuss it next week anyway. So
And then next.
get it done
So,
by the 20th.
Thank you.
so we're not arguing today?
Thank you.
I don't know whether we're going to. I
The
don't know.
20th
We're
is
not gonna argue the other ones, but,
Yeah.
there's other stuff we can do.
No, I meant the
The,
call 2119.
We're not gonna play 2119 prior to the 20th, so we appreciate that.
so, Mr. Harvey, I guess that your brief that you filed is so impressive and intimidating that they want some time to be able to respond to it.
Just agree to it because it's right.
So have y'all gotten together yet on, Mr. Steele made us all a nice chart of where he thinks the evidence, the status of the various exhibits is. Have y'all been able to look at it and see where there is any kind of discrepancy in what y'all believe?
We have been looking at that. We've not done that joint effort, but we've been comparing Mr. Steele's chart with what our chart and what Ms. Weaver's is.
And where are y'all on that?
We're checking with our team member that's in the office now.
Okay, because had I walked in here at 9, dealt with the two Rule 22s and then said, let's hit the exhibits, which I told y'all by email several days ago is what I wanted to do today, would y'all have been ready?
Look at that person over here
Hmm.
to be arguing that.
Okay, so that answer sounds like,
Master exhibit list, Your Honor,
Okay.
and that we can forward that we believe is up to date. And we can take some time, over the next couple of days to go over that with any designated person from defense, but we can forward the master exhibit list that we have that we believe is.
all right, y'all exchange that and copy Ms. Persfield as well. And then y'all get together to narrow down where there might be disagreement on the exhibit list. Yeah, because it's gonna be a bear and we can't just put it off until the end. We need to be doing this a few times as we go along. Okay. So, y'all, Mr. Ryan's crowd is gonna get together on whatever else that evidence might be and where there might be disagreement.
The state's going to get us a list by Sunday, narrow down, we'll have conversations based on that.
Okay. All right. And y'all are both gonna get me briefs by Monday, I think is what I said on the what was it? What did I tell y'all to brief me on? Anybody know?
I believe we were supposed to. Yes. Over, and whether or not
It was
over
some of
at.
that, yeah.
Whether someone in jail, whether it ends the conspiracy with that one.
Well, somebody wanted to do that a long time ago and never did.
The other one was whether or not an overact not listening indictment could solely be the basis of a conviction on count one.
Okay.
No. Yes, that's what
An
was.
overact that is not listed, not a count charge, but an overact not listed.
Did you provide any law?
No, they haven't yet. That's what I would like for them to do.
Okay, that was a Monday one.
That was one.
Okay.
Judge, with respect to that, would we be able to wait for the state's brief and then respond in kind if they're able to find that versus us just arguing what the Constitution says to begin with?
Sure, you can wait on that.
Thank you.
And then, okay, I guess if a prior conviction, which Mr. Ryan's murder conviction is alleged to be an overt act, were y'all gonna brief me on whether and how and if that needed to have any kind of a limiting
I think that would be a
instruction?
smart thing to.
Or was I just writing that down on my own as an issue?
No, I don't, I think that we had, earlier
Okay.
today, we had said, that his conviction, that there should be a limiting instruction as to his conviction. We had not, fleshed it out or anything, but
Okay.
I think it does bear some addressing.
I think so too.
Your Honor, again, and I'll do whatever if you want to brief, but I can't imagine a limiting instruction to cure. You know, I'm on trial with Mr. Ryan, and to have this jury be told that another jury in Fulton County found Mr. Ryan guilty of murder, and that his overt act, because you're dancing, the court's going to tell the jury to do this dance because, okay, don't use the prior conviction against Mr. Williams or anyone else of the jury because it's hearsay. But you can use it against Mr. Ryan somehow. But then it's an overt act against Mr. Ryan. And if Mr. Williams and Mr. Ryan are a conspiracy, even though Mr. Williams is not part of that overt act, you can use that evidence against Mr. Ryan to find the overt act, and therefore Mr. Williams gets convicted on that piece of evidence. I don't mentally understand how you're
Well,
going to
I mean,
cure that.
The determination is going to be made separately as to each defendant, whether they participated in those.
And Your Honor, I think
overt
that
acts.
the
Right,
conviction
so-
itself, the issue of the conviction, not the act of the murder, not the evidence or proof of him having convicted the murder, just like we've had to present evidence of other overt acts that were external to the
Right.
conviction itself.
And you're presenting that evidence anyway,
Right,
that he
right.
committed that murder.
Right, yes, Your Honor. And so the conviction itself, and by conviction, I mean the certified
Right.
isn't the overact, it's the actual murder that we are putting up evidence of that we.
Right, but you're also wanting to put in the certified copy of the conviction of Mr. Ryan for that overt act, right?
Right, and that's what we were
Right.
discussing with the limiting instruction.
Right,
that's
and so there is
certified.
a danger, or it gets complicated about how to tell the jury what they can do with that evidence.
And Your Honor, I think.
And I hadn't looked at the two, cases that you cited yet, the 14 F third 881 and the Toco 200 F third one. That was you, right?
Yes, Your Honor, that was the state's cases.
So maybe those will elucidate it somewhat. I don't know.
Anyway, I just want to follow the court and aid the court if we can. So whatever I need to do to write, but I think that would be very prejudicial against.
And that's the danger is it going to be, is there a way to correctly limit it? So
I think that
I
this
need
is-
some,
Right, some more, we.
something on that would be nice as well.
Yes, Your Honor.
All right.
And Your Honor, I think we asked for just some additional case law, not in group form, possibly about prosecutorial meetings.
Okay.
Those were my notes. additional corrections.
Yeah, I mean, if you wanted to provide that. And then you'll get me the hard copy of the in-camera material by Monday also. My
Right,
first
right,
thing
the
Monday.
printouts, right. And when we're discussing the prosecutorial need for the intrinsic acts, we're looking at it through the lens of,
I mean, I don't need further evidence on that.
oh,
I mean, not evidence, further case law on prosecutorial need. If y'all want to come up with some, great. But yes, that is exactly what I did want further evidence on was could y'all find something that more factually aligns with your situation? And obviously that one, y'all were gonna file at the same time because you can find case law that factually aligns and says, no, it's out. And just to flesh that out some more, and it being either admissible or inadmissible, because it either does or doesn't complete the story of the crime of the gangs or the crime of the RICO violations, or, you know, be the same kind of series of events as that. Because those are the only two that it might come in under.
right, it has to, right.
Okay.
So just making sure that the cases that we bring to the court's attention addresses that.
If, yes, ideally, that would be wonderful. All right. Anything else we can do in the next 15 to 30 minutes?
Can I just get, I ask every day, want to know what files to bring
So
tomorrow.
in terms of witnesses?
Yeah, if it didn't change, that's fine, but I know that.
So
the state said
I think y'all said Pitts, Latner, Turner, Bell, Hill, Jinx, and Thorpe. I may have that one wrong. Jinx, was it Jinx or Jenkins? Jenkins. Is that still the plan?
Yes, for the upcoming 2 days.
Couple of days, yeah, okay. And then we'll talk again on Friday about what'll come up next week.
Thank you, Your Honor.
All right. Anything else?
Your Honor, if it matters to you, other people spoke with the sheriff, and we are going to.
Okay, yeah, I didn't know where exactly y'all were going, but somewhere that gives y'all a little bit more room considering the number of people involved. Oh, right. I'm sorry, I don't mean to just point at you. Miss Borden. Yeah, come on up to the podium.
I want to say thank you, Your Honor, for allowing me to come back up again.
Sure.
And I'll be real brief. I just want to share something to you and also on the record.
Okay.
I appreciate being granted the access to the camera pool. And I just want to respectfully express my concerns that that solution does not fully align with the principles of transparency and equal access. The decision to limit the media coverage to a single camera controlled by a pool, which restricts the diversity of perspectives and it raised concerns about control, suppressing, and also withholding crucial details that can be caught by several angles. And I know earlier, I think I might have shared, I am a civil rights leader. I'm also a noted and awarded community advocate for the state of Georgia since 2009. The Rule 22 provision was designed to ensure that the public and media has open access courtroom proceedings. And it is not to be limited to a singular source because that risks tampering with the spirit of that rule. By only allowing one feed, it is inherently biased. It ends up being biased with that coverage.
Are you reading from a case or are you just reading?
No, I just take some notes. I didn't want to spend extra time and I'm almost
Okay,
done.
I mean, so this is just your position. It's not case law, is
I
it?
do have some case law. I got 2 of them.
Okay, all right, go ahead.
So it assumes that one viewpoint is sufficient for capturing the full scope of the trial. It's essential that different media outlets are allowed their own access so the public can be provided with a fair and transparent view of all proceedings. So I am asking the court to reconsider this limitation and the transparency of the Rule 22. So when it comes to, for example, O.J. Simpson trial, also I was a part of Derek Chauvin trial. We were permitted live streaming to ensure full and unbiased representation of the proceedings. If you look up Press-Enterprise COV Superior Court, 1986, also Richmond.
I don't know how to look that up.
Oh,
from
I'm
what
sorry.
You just said.
Okay.
Do you have a site to a reporter, like a case reporter?
Well,
It's usually like numbers and then a book and then some numbers again.
I didn't, so basically I pulled it. If you was to type in Press-Enterprise COV Superior Court 1986.
COB?
I'm sorry.
I got Enterprise.
C is in Charlie, O is in Oscar, V is in Victor.
V.
Yes,
okay.
V is in Victor, Superior Court 1986. And I have another one.
What state?
This, wait a minute, this is in the state of.
I mean, I can try that, but I don't think that's gonna bring anything up for me. But anyway, what's the next site?
Okay, the next one is Richmond Newspaper, INC versus Virginia Supreme Court. And I also want to share that the restriction of the live streaming serves a compelling enough interest to warrant limited media access to a single perspective. Again, when it comes to civil rights leaders, right now, I don't see any other civil rights leaders here. Also, when it comes to community advocacy.
All right, well,
I
Mr. Steele
apologize,
feels
Mr. Bryant.
himself to be a civil rights leader.
So I do want to go on the record, say I have just as much vested interest as the defense team. And I did look at the media room, what is required, I do not have. So therefore, I would ask the courts if I can bring a computer into the courtroom. I don't have to have my phone, but just a computer to do it physically in here. And
To do what?
I'm sorry,
physically in
to
here?
be able to do my notes, also to do live like commentary from my computer. And I'm also asking the court to uphold the First Amendment protection of public access.
All right, there is full public access. Anybody who wants to can watch this trial. It is being live streamed with a pooled media of at least 6 different news organizations. It is also being live streamed by an individual who is pooling with another individual whom you are welcome to pool with. And so you can do that as well. Okay, so then are you saying at this point, you just want your computer in here so you can do live commentary, but you're okay with not filming it because you don't have the capacity to do it from the media room?
Yes, Your Honor.
Okay.
And also, I would like to, I know I brought it up earlier, I still would like to submit to the courts. Maui Davis of Davis Bozeman Law Firm did a letter. Also, Channel 11, I work closely.
Oh, yeah, I mean, and I
Yes.
said before, I'm
Okay.
happy to, and I
I would like
know
to
Mr.
submit.
Davis and happy to, but again, I don't not believe that you are a civil rights leader or that you would be able to add something to what's already in the news. And you are certainly welcome to report on,
Okay.
everything about this trial.
So in there also is a letter from DeKalb, Mr. Robert, he was the DA, DeKalb County.
Yeah, I know him as well.
Also Channel 11, I work closely with their investigative team. They also did me a reference letter as well.
Okay. All right. Yes. Yes.
I just wanted to, this young lady referenced Richmond newspaper
so
v.
much.
Virginia. And I believe the site is 448 US 555. from
I
1980.
thought that was a pretty big
Thank
case.
you so much.
I was
Yeah,
familiar with
press-
that.
And Press Enterprise is 464 US 501.
Okay, thanks. So, yeah, those numbers and then letters and numbers, that's how we lawyers look up cases. So, I mean, the title's nice, but it's the numbers that we actually need. So, okay. And what would you need to do it from back in the media room? Is this,
Just be able to plug up my computer and that's it.
so you're not worried anymore about being able to film?
No, I could make everything work from my computer.
Okay. All right. Well, I mean, I just gave somebody else the ability to do that. So I will revise your Rule 22. I don't know if I think it might have already been emailed to you, but
Yes, it
we'll
was.
withdraw that one and do another one.
And just to make sure I'll be able to
But
come into
again,
the
y'all
court.
are gonna have to fit in the media rows that are available here in court. So it might get pretty, I mean, sometimes there are only a few people here. Sometimes there seem to be a lot of people here, okay,
Thank you, Your Honor.
thank you. All right, anything else? Well, tomorrow is your next court date. Is that what you meant? Or no, the jury's coming back tomorrow. Did you mean when are we gonna have our next non-jury date? I don't really know. Oh, no. I'm thinking we could. I don't know, possibly sometime the week of the 7th, later in the week. But if we need one before then, or if we need one or two before then we'll have to fit those in. I mean, I'm planning for us to have 2 full trial weeks for the, next 2 weeks of September, but do y'all think we're gonna need 1 or 2 non-jury days?
I don't foresee that, not with with how far out the issues that we still have.
Okay. All right. So then we'll plan to do full weeks for the next 2 weeks. And then maybe sometime the week of the 7th, we might have a non-jury day or 2. And if not, I mean, certainly sometime close thereafter. Okay.
Thank you. And Judge, one
Yes.
last inquiry, the matter that the court brought to our attention, from the sound of things regarding the request that we dealt with at the bench, No further.
I don't know
okay.
what you, no, I don't know what you mean. I'm sorry, my memory just may not be as good as yours. I'm not quite sure what you're referencing.
May I approach with just any member of the defense so that I can
Yes.
deal with it appropriately?
Or anything else? Before we break for the day? Nope. Okay. Nobody else? All right. All right. Let's see. We have the jury back at 9. You know, considering that we've been together all day today, hopefully we won't have anything unexpected in the morning. Do you think we could just plan to convene at like 5 till 9? Okay, let's do that. See y'all tomorrow.
Oh, what a day, guys. It's been real. I know y'all will out because I am. I don't feel anything was accomplished. If y'all do, y'all can let me know in the chat. Other than that, thank you for allowing me to fill in for Kayla today. And she may tap in with y'all later. She may have a special guest for you. I'm not sure if that's been confirmed. But if not, we'll definitely be back here tomorrow, 5 to 9. See y'all later. Have a good night. I think she meant like 8:55 or so.
A wallet from the suspect's vehicle?